Yes, I guess.
You don't say I guess. It's either
I
yes,
guess.
no, or you don't recall.
I ain't trying to say the wrong thing. So
So do you not recall?
I stand the question. I don't need it. Just tell me the basis for the objection, Mr. Sharp, okay?
I need you to answer yes. Was it Montauk?
Overruled, Mr. Sharp.
Do you remember if it was Montauk or not remember if it was Montauk?
if he said that's what I said, then yes.
I'm asking you what happened.
I don't recall what happened. I was mad. I had a knot on my head.
Now, do you also recall speaking with Detective Thorpe about what happened at the Cascade skating rink before this fight at Club Crucial on the Monday before Donovan died?
I guess.
When you say you guess, do you recall or you don't recall?
Yeah.
Okay. Tell the jury what happened at the Cascade skating rink before this fight at Club Crucial.
What happened at Cascade?
Yes.
And nothing happened at the skating ring?
Yes.
Nothing.
Do you recall speaking with Kel at the skating rink?
That's what I told Detective Thorpe.
I'm asking you, what do you remember?
I don't remember nothing from 2015. I remember the fight. They put their hands on me.
Do you remember telling Detective Thorpe, actually before talking about what happened that Monday, that you and Kel were at the Cascade skating ring and the two of you actually spoke at the Cascade skating ring?
When I was talking to Detective Thorpe, I can't recall what I told him because I was just telling him anything.
Okay. Do you recall telling Detective Thorpe that at the Cascade skating ring, you wanted to speak with Kel and you said to Kel, hey, let me holler at you?
Not if you put no knot on my head.
This is before he put the knot on your head.
Objection to the proper question.
I'll ask a better question.
I sustain the question, sir.
Do you recall speaking to Kel before he put the knot on your head at Cascade skating ring?
I guess.
I need to know, yes, you remember, no, you don't remember, or you don't remember.
If you saying this what I told Thorpe, then this what I probably told him.
Do you remember speaking to Kel, period, at Cascade skating ring?
We ain't no speak. We wasn't on speaking term.
Do you remember telling Detective Thorpe that at the Cascade skating ring, you and Kel were standing right there and y'all talked about everything that you had against each other?
If I was somewhere around Shell Kill, I don't think we would be talking.
Okay. Did you also tell Detective Thorpe that as we talked, we said it was over? So it was like, we're over, we ain't beefing no more. Do you recall telling Detective Thorpe about that conversation you had with Kel?
I guess.
I guess it's not responsive. Do you recall or not recall telling Detective Thorpe that?
I told Detective Thorpe whatever he said, I told him.
Do you recall telling Detective Thorpe that on that same day at the Cascade skating ring, Kel wanted to speak with Thug?
Who?
Kel wanted to speak with Thug.
If I would have any chance to be around Shell Kill at any point, I would not been talking to him.
I understand what you're saying today. I'm asking you what you told Detective Thorpe.
And I told you that if I told Detective Thorpe anything and he said I said it, then I probably did.
Okay. So did you also tell Detective Thorpe that you then called Thug on FaceTime for Kel and Thug to speak with each other?
When he checked my phone record, did he see that call?
I'm asking you, did you tell Detective Thorpe that on the Sunday at Cascade Skating Ring that you got Thug on FaceTime so Kel and Thug could speak? Yes or no?
If Detective Thorpe said I told him that, I told him that.
Okay. Do you remember that happening?
No.
Okay.
I don't remember me and Shea Kelly ain't gonna talk.
All right. And then, do you remember telling Detective Thorpe, so him and Thug talked, and whatever was said with that, I don't know.
I probably told Detective Thorpe that.
And again, that was in your January 11, 2015 interview.
I guess.
Now, did you also tell Detective Thorpe about a shooting that occurred at a gambling house in Lakewood?
If that's what he said.
Do you recall a shooting at the gambling house in Lakewood? Do you recall a shooting at a gambling house in Lakewood?
No,
You do not?
I don't.
Okay. Do you recall telling Detective Thorpe in that same January 11, 2015 interview that there was a shooting over in Lakewood and that it was Kel and he was standing on top of a roof and shooting inside?
I probably did.
I need to know, do you remember telling him that or you don't remember telling him that?
When Detective Thorpe questioned me about what happened, I thought I was in there about 5 minutes. I thought I walked in and walked back out. So I don't know what I don't told him. I can't remember what I don't told him.
So you say you don't remember telling him about what happened at?
But if he said that I told him that, I'm telling you right now, I told him that. So can you start asking me what I supposed to told Detective Thorpe? Because I'm telling you now, if he said that I said anything about anything, I'm telling you, more likely I probably did.
Great. Well, I want to ask you about all the things that you talked to Detective Thorpe about. Did you also tell Detective Thorpe about the Friday before Nut was killed?
I guess.
Okay. On the Friday that Nut was killed, were you with Thug the Friday evening before Nut was killed?
No, you just said it earlier. Was I at the house? I said yes.
I'm talking about the Friday evening before Nut was killed.
I can't recall. I don't know what I don't told Detective Thorpe.
I'm asking you, what do you remember yourself?
No, when I think back about 2015, all I remember was getting a call saying that Nut was killed and I was responsible for it. And only thing besides that is people showing up my folks' houses. Details about what happened, all this stuff been blanked out my mind. Like, it been blanked out my mind.
All right. In that same January 11, 2000 interview, you recall telling Detective Thorpe that you were with Thug and you were at DJ Drama's studio.
I probably did.
Do you remember telling him or you don't recall telling him? I need to have it.
If Detective Thorpe said I said it, I said it.
And then after leaving the studio, that is when you went over to your girl's house, which would be Deshaun's house.
I guess.
Now, earlier I asked you about what time you left Deshawn's home to go to your brother's house. Do you recall telling Detective Thorpe that you left Deshawn's home around 5:00 p.m.?
I guess.
When you say you guess, I need to know, do you recall telling him that or you don't recall telling him that?
If he said I said it, I said it.
And is that true or that not true that you left her home around 5:00?
If you notice something about me, I don't keep up with the time or the days. I just go with the flow.
So do you remember it being around 5:00 p.m. that you left Deshawn's house?
I don't know what time I left her house.
When you went to Mechanicsville, do you remember seeing anyone in Mechanicsville?
What you mean?
You said earlier that on the night before Nutt's murder, on the day of, you left Deshawn's house and you went to Mechanicsville. Do you remember seeing anyone when you went to Mechanicsville?
I don't remember if I seen anyone.
Okay. Do you remember telling Detective Thorpe that you went to the green store?
I guess.
I need to know, do you remember telling him or you don't remember telling him? Or was that a lie?
Basis.
Saying he's allowed to answer and they can't force him to answer in the binary one or two ways.
Your Honor, his response are non-responsive to my question.
I'm going to over your objection, sir. Thank you.
So do you remember telling him, you don't remember telling him
Do I remember telling him what?
that you went to the green store?
I probably did.
When you say you probably, I need to know yes, no, or I don't recall.
Whatever Thorpe said I told him, I told him.
Okay. Do you remember telling him that you met with Little Rick at the green store?
I probably did.
Yes, no, I don't recall.
You want me to?
Could I have a continuing objection?
Yes, sir, you may.
Yes, no, I don't recall.
If Thorpe said I said it, I said it.
Do you recall telling Detective Thorpe that while you were at the green store, you called Little D?
I guess.
Did you tell him? Did you not tell him, or you don't recall telling him that?
If Thorpe said I said it, I said it.
Do you recall telling him that he told you he was on Cleveland Avenue?
I guess.
Yes, no, or I don't recall.
If Thorpe said I said it, I said it.
Now, when you got to Cleveland Avenue earlier today, you said that Little D and
You didn't testimony. You probably asked a question.
you're right.
He's oriented to time and place. I'm over with your objection, sir.
Earlier today, you said that Little D and Shannon got into your vehicle. Do you recall saying that earlier today?
I think I did.
Okay. Back in January of 2015, did you ever tell Detective Thorpe? Your Honor, now mention.
I'll
You don't answer the foundation.
rule the question, sir.
Did you ever tell Detective Thorpe that Shannon was in the vehicle with you and Little D back on the morning of January 10th, 2015?
If he said I did, I did.
I'm asking you, did you? Because you're saying you're saying today, you're saying the truth, and back then,
To the commentary.
I sustain the objection.
did you ever tell Detective Thorpe that Shannon was in the vehicle with you?
I guess.
Back in 2015, you did not tell Detective Thorpe that Shannon was in the car with you.
Objection, asked and answered.
I sustain the question.
in 2015, did you tell Detective Thorpe that only Little D to the car with you?
I guess.
Did you say that to Detective Thorpe?
If he said I did,
Back in 2015, did you then tell Detective Thorpe that Little D told you that Nut just got killed?
Basis, sir.
You're safe.
Your Honor, do we address this?
I'm overruled the objection, sir.
Confrontation clause as well.
Your Honor, we
Overruled, sir.
today you said that you and Little D never talked about the murder, correct?
today I said whatever I told Thorpe in 2015, I was trying to get him out my face. So I do not know exactly what I have told him.
Today, do you have an independent memory of what happened on January 10th, 2015?
What you mean?
Do you have a memory outside of what you told Detective Thorpe about what happened on January 10th, 2015?
Basis, sir.
Gave in.
I did, tell me the basis for your objection.
Good faith belief question. He already gave it.
I'm overruled the objection, sir.
He was.
I'm going to object, ask an answer, Your Honor.
Overruled, sir.
Wait,
So today, do you have an independent knowledge of what happened on January 10th when you picked up Little D?
can you say that one more time?
Sure. Today, without remembering what you told Detective Thorpe, what is your memory of your interaction with Little D on January 10th, 2015?
But I don't have a memory. What you mean? Like,
Okay.
I just know that I picked up Lil D and Shannon, and that's when I got a call saying that I supposed to did this and did that.
And in January 2015, you never told Detective Thorpe that you picked up Little D and Shannon.
I guess.
Earlier, I asked you if Moulton FaceTimed you. And did you say you did not recall if Moulton FaceTimed you?
I know he called me. I don't know if it was FaceTime regular. All I know was I remember what came out of his mouth.
And in 2015, in January of 2015, you told Detective Thorpe that he FaceTimed you.
I guess.
Do you remember telling Detective Thorpe that or no?
Objection, ask an answer.
Yeah, that's I guess it's non-responsive.
I'm overruled your objection, sir. You can answer the question, sir.
I need to know if you remember or if you do not remember.
If he said I said it, then I said it.
Do you remember telling Detective Thorpe that?
Overruled, sir.
That's not. Do you remember telling Detective Thorpe that he FaceTimed you?
I guess.
I guess it's non-responsive.
Well,
It's not responsive, Mr. Steele. I'm gonna overrule your objection.
Do you recall?
I don't know what I told detective. I don't remember what I told detective. Whatever
the perspective they're standing at the time. And I am going to permit you to make a brief proffer of what you believe happened. I do not think, based on what I have reviewed, that you were laboring under any conflict of interest. I don't even know that at this point in time, any of that is particularly relevant, but I can understand you wanting to put something on the record. I would like you to stick to the facts to the extent you can, keep emotion out of it, and go ahead.
So, Judge, basically what it comes down to is after receiving the transcripts from the two ex parte hearings that took place, or ex parte meetings that took place between Judge Glanville and the district attorney's office, and then with Ms. Bumpus and Mr. Copeland in tow, the allegation has been made that I was somehow acting in conjunction with Mr. Steele and Mr. Shart and other members of the defense team in this case, which is categorically untrue. I am unfortunately in a difficult position as it relates to this issue, because what I would need to produce from a documentary standpoint to rebut these allegations are privileged communications between myself and Mr. Copeland. But my presence, so starting with June the 6th, I sent an email to Ms. Hylton, Ms. Love, Mr. Steele, and Mr. Shart stating that Mr. Copeland wanted to take the fifth, did not wish to testify. On the 7th, I was shown an order that was signed on June the 7th stating that Mr. Copeland was being given transactional immunity. At no point, and I think what really bothers me is that at no point did anybody from the DA's office before that time, within any relevant time frame, reach out to me and just ask me if I was representing Kenneth Copeland for purposes of his testifying in this trial. Everybody in this room that has been involved in this case from the beginning has known that I was representing Kenneth Copeland.
All right, and I know because you had a case before me
With Mr. Copeland.
with Mr. Copeland that resolved in June of 2023. So
right.
I know that as of that point, you were representing him.
Yes.
And then following the resolution of that case, he did not have any more pending charges.
He did not, that's
okay.
correct, yeah.
All right, so that was a year ago.
So at a minimum, I feel it was incumbent on the district attorney's office to reach out to me just to ask that question. Now, as far as what communications took place between the DA's office and Mr. Copeland, I don't know exactly. But I do know that on June the 6th, he and I spoke, and he told me that he wished to assert his Fifth Amendment privilege. And so I sent that email. The transactional immunity order was granted on June the 7th, which I find the timing there to be, let's just say, ironic, in that apparently they were going to have Mr. Copeland testify without any grant of immunity because it was the state's intended purpose to call him as a witness on June the 7th. And so I was here on June the 7th. I told the court what Mr. Copeland's intentions were. There was a lot of back and forth. Obviously, Mr. Copeland was taken into custody on June the 7th, and then everything that happened on June the 10th. I don't have to go over all
Yeah,
that.
I've read all of that.
Yes. So my purpose here today is to state on the record that absolutely, nothing that I said or did on Mr. Copeland's behalf was done in any conjunction or with any consultation, in cahoots or anything along those lines with Mr. Steele or Mr. Shart or anybody else in the defense team.
All right.
I was here doing what my client had expressed to me, what he wanted to do. And as I said, if it becomes a major issue, I have more than enough documentation to prove that.
Okay, I appreciate that.
Mhm.
It's not an issue at all to this court.
Okay.
All right, thank you.
All right. That's it.
That's it?
All right.
Okay, Mr. Steele, you had said to us on Friday afternoon that you had a good faith basis for believing that there may have been a conversation you believe during the June 10th ex parte in chambers meeting at some point when Judge Glanville was not in the room, but between Ms. Bumpus, who was acting as counsel for the day for Mr. Copeland, and Prosecutor Hylton. So can you give me what your basis is for that? Otherwise, we might just move on.
I also have a couple of questions, if it's okay,
All right.
for Mr. Melnick.
Oh, well, I think may have already walked out. I didn't realize that. I thought this was kind of to let him have a chance to clear the record. What are your questions going to be?
Just about the representations made about an email with a BCC and it was sent inadvertently. I believe that he'll say that that's not accurate. And then we sent your honorable court on Friday all of the emails. If you put them in order.
Yeah. Okay. I mean, I've seen it. I think that's fine if you want to ask him that and clarify it. I don't think that Ms. Love made a representation that is in fact what happened. That was her theory because she couldn't figure out why Mr. Melnick was referring to her in the third person. But sure, you can ask him that.
Can I just ask you a couple more questions? Sure. And Your Honor, I'll move the admission of all those emails, and I have copies for them if that makes it easier, and we can mark them as an exhibit if that's what you want. They were already sent to your honorable court.
If you've got them now and can make them an exhibit, and I'm not sure exactly what courts, you would make them a defense exhibit.
Can I just step back for a second?
Sure.
And Your Honor, would the court be admitting those exhibits for any purpose as it relates to this trial?
No, not for the trial, just for whatever these ancillary proceedings are. I'm not sure what to call them, but motions. So it'll be, I guess, an exhibit to, we can call this a motions hearing. It's today, August 5th, 2024. Proffer by Mr. Melnick.
So, Mr. Melnick, have you looked at?
All right. Good morning, brothers and sisters. Hope you're doing well. Yeah, kind of weird how our streams were this morning. Didn't have what we were supposed to have when we were supposed to have it. Yeah, sorry about the background there. All kinds of funny things happening, but we're going to jump on with Steele in a moment. Have no fear. We're going to get to Brother Steele. Obviously, we've been waiting for this, and we have decided to be back at you. You know, since we're covering the foolishness, I guess we can continue to go down that winding road of chaos and see if we can get some justice out of an unjust system and unjust process. Unjust. Yeah. You know, you look at the whole thing, you say, well, hey, if you didn't have the type of money, you know, to have a Brian Steele, Brother Adams, etc., if you didn't have that kind of dough, you know, where would you be? You know, this is all indicative of some real problems within the American justice system, just clear to see. If you're looking at what could make things better, that's tough. You know, can you really get it? You know, I mean, what are you going to do? We're going to get it from politicians, let's say. Well, you know, how do the politicians make it without money? Just the role of the dollar in the American system is just ridiculous. And, you know, you could just see, what are we watching here? Are we watching the true pursuit of justice for those who have been harmed or those who are innocent? Is that what we're really watching, or is there something else at play? Ask yourself, ask yourself. And some of you have obviously been on both sides of this thing. And so you already know it's a dirty game. It's really, really a dirty game. Okay, so where we are right now with Brother Melnick and Brother Steele, we'll pick that up. Good morning to you. Good morning, good morning, good morning. We appreciate you being here. Rhodes, dogs, and conversation. Let's hit it.
Use him as a witness in this case.
And did you make it clear from your viewpoint that you were representing Mr. Copeland in this case, meaning the case that's on trial before Judge Whitaker?
Yes.
As a witness or as a potential co-defendant?
Yes.
Okay. And that the Honorable Court knows, I believe, but to your knowledge, who is Don Geary in 2021?
What he introduced himself. I mean, I knew Don for a long time, but what he said, he was special counsel for the Fulton County District Attorney's Office. He was basically hired almost like in an of counsel position, as I understand it.
And was he affiliated on working this case that's before Judge Whitaker
Yes.
on trial?
We talked about this case specifically.
At any time, I'm sorry.
And nothing else.
At any time, did you or any member of the District Attorney's Office in your presence ever say that you were not representing Mr. Copeland pursuant to a potential witness in this trial?
No.
Did you ever have conversations with Ms. Love, who is seated to your left?
Yes.
About representing Mr. Copeland as a witness in this trial?
Yes.
And when were those conversations?
March of 2023.
And was it clear from your standpoint, from your viewpoint, as the court said, people can observe things differently, but from your standpoint, was it clear that you made it known to the Fulton County District Attorney's Office that you were representing Mr. Copeland as a witness or potential witness in this trial?
Yes, it was.
All right. Did you do anything to separate yourself from that representation?
No.
All right. The Honorable Court stated a little while ago, and you left here so quickly, but that your representation ended of Mr. Copeland, I heard, in 2023 when you entered some sort of disposition. I don't remember what it was, before this Honorable Court. And when I say this Honorable Court, I'm talking about Judge Whitaker.
Sure, that's correct.
Did your representation end of Mr. Copeland as a witness in this case? Did
No.
you ever make that known to anybody?
No, I never did.
Did you actually do the opposite?
I was contacted by another member of the Fulton County District Attorney's Office in June of 2023.
And about
Yes,
what?
I'm sorry, about representing Mr. Copeland in this, as a witness in this case.
Were there any agreements between Mr. Copeland and yourself in the District Attorney's Office? Because you obviously got him not to be charged, or that's a bad way of saying it, but you obviously did someone did something that he's not charged in this case.
I would honestly say that may not have been due to anything that I did or said necessarily. I think it was an internal decision from the DA's office.
Okay. All right. Now, I'd like to show you what I marked, and I just want this for the record. And I marked it number 1, Mr. Williams. And can you announce it just so the court, and we're going to give all this to the court, what this is, if you recognize it.
Sure.
And then go to number 2, 3. But for people looking on, just announce it by the title, if you don't mind. If you don't recognize it, please say that as well.
I recognize this. This is an email I sent to Ms. Love, Ms. Hylton from the DA's office, yourself and Mr. Shart, dated June the 6th, 2024 at 4:31 p.m. You want me to read it or?
Sure.
Says, good afternoon. All it has come to my attention that the Fulton County District Attorney's Office has questioned my client, Kenneth Copeland, without my knowledge or consent. Please be advised that my client does not wish to speak with any member of the Fulton County District Attorney's Office, nor any law enforcement officer from this point forward. My client will assert his privilege under the
Way, it's
I
way
am
too
going
fast
fast.
for the
I'm
court
sorry.
reporter to take down.
You with me? Law enforcement, nor any law enforcement officer from this point forward. My client will assert his privilege under the Fifth Amendment tomorrow and will not testify. Thank you, John Melnick.
Okay. On the 6th, and you made it clear, to your knowledge, was there any type of immunity agreement whatsoever in place? Use immunity, transactional immunity, any type of agreement?
There was no response from the District Attorney's Office to this email to me. So I was not aware of any immunity, any offer of immunity to Mr. Copeland at that time.
Did you personally know that if Mr. Copeland testified at this trial without some sort of protection. By protection, I mean whatever type of immunity, that he could be making statements that would incriminate himself.
Yes.
No statute of limitations ran, he could be charged.
So I can't say that with absolute.
Okay, well, we're dealing with a bunch of lawyers, so I think Mr. Melnick can handle it. I'm going to overrule that.
I can't say with absolute certainty that I investigated it to the point where I would know whether the statute of limitations would have run or not.
About federal crimes for gun offenses.
No, as far as I know, again, I didn't do extensive research into it, but it's my understanding that it would not have run in terms of the federal statute. And Mr. Copeland, of course, has been charged previously and convicted in U.S. District Court. So the feds, once the feds have their eyes on you, they have their eyes on you.
And how about as a co-defendant in this case being indicted later? And the statute of limitations barred to that?
I don't know.
Okay,
I don't know with absolute certainty.
Okay. Were you concerned that if he testified when you wrote this email, the one you just announced as Mr. Williams #1, that he could be facing criminal liability?
I absolutely was.
All right. Is that the reason you wrote that email?
Among other things, but that is one reason why I wrote the email.
Was there anything in your mind at the time of sending it that was suspicious or clandestine or by CCing the Honorable Maxwell Shard or myself on that email?
Not at all. I thought everybody had a right to know.
Okay. And everybody being?
Everybody from the prosecution and the defense team.
Okay. All right. Your Honor, I move for the admission of Mr. Williams #1 for purposes of this hearing.
It's admitted.
Can I just get clarification as to which of the emails we don't have a number is defendant Williams #1?
Can you
Yeah.
clarify?
June 6, 2024, 4:31 p.m. to yourself, Ms. Hylton, Mr. Steele, Mr. Shaw.
Does it have the response at 4:57:05 from Ms. Hylton, or is it the one without response?
I don't remember seeing a response.
Okay.
So is there a response on there
There's not a response.
on Williams 1?
There will be, Your Honor.
Okay,
Not
so
on this
that
one,
is
this one.
then for purposes of the record, the one that does not have the response on it.
Okay. Okay, so here's the response.
But
Is it a part of Williams 1?
No, it's not.
Okay, so I assume Mr. Steele might ask you about the next one. Go ahead.
and that is, I'd like to show you what's in front of you, Mr. Williams, exhibit #2 for purposes of today's hearing, okay?
Mhm. Yes.
Tell us, take your time to look at it, tell us if you can identify it, if it's true and accurate for what it appears.
I hope this is from Miss, I think exclusively from Miss Hylton to me.
But do you recognize it?
I do, I recognize
Is that
it.
accurate?
Yes, it is. Yeah.
Okay. Your Honor, I move for purposes of this hearing, Mr. Williams #2, after you identify so everyone knows what you're looking for.
June 6, 2024, 4:57 p.m. I hope good as addressed to me. Good afternoon. I hope all is well. In our conversations with Mr. Copeland, he advised that you were not his attorney and he had not spoken with you. However, if you are asserting that you are his attorney, we will cease communication, but your client is under subpoena and is expected to be here at 8:30 a.m. It is our understanding that your client does not have transportation, so we're planning to pick him up. So please make sure that he is present so we do not have to take any further action if he fails to appear for his subpoena. Thank you and have a great evening. And then it's from Ms. Hylton.
And did you respond to that email? And if yes, is it on Mr. Williams #2? And what does it say in time and date? If you don't
It is. I did respond. It's dated June 6th at 5:47 p.m. Again, with CCs to everybody in the case. I have been Mr. Copeland's attorney. He tells me that he repeatedly told you that told you that when you were questioning him. I also spoke with Don Geary extensively about Mr. Copeland when he was assigned to this case, and I spoke with Ms. Love.
Slow down.
I spoke with Ms. Love early in the process around the time jury selection was beginning. I have a plea with Judge Carnicel tomorrow at 9 o'clock, and I will come to the courtroom as soon as I am done.
Is everything that you responded about being Mr. Copeland's lawyer for purposes of this case true?
Yes.
Okay. And the court already admitted #2. If you could go to #3.
Well, no, I haven't.
Oh, I'm sorry. I moved for the admission of Mr. Williams #2.
It's admitted, and that one contains both Ms. Hylton's response and then Mr. Melnick's response back that he just read. Is that correct?
Yes.
Okay, that's admitted.
Okay. This is a repeat, so I'm withdrawing this. Okay. Okay, if we go to Mr. Williams, number 3, can you take a look at this and tell us whether you recognize it? And if yes, what is it?
It's a,
Your Honor, if we could just have what that is, and we don't have numbers on it, if I could just have in the court what it is that you're even tendering.
I don't know. I don't know how many things you got handed, but Mr. Melnick's about to describe it.
it's dated June 7th, 2024, 11:52 a.m. It's from me, Miss Hylton and Miss Love. The first sentence says, here is a communication between myself and Miss Love, which pertains directly to the YSL case. And it's a forwarded message from a number of people, including myself and your case manager, Sheila Rosser, dated March the 3rd of 2023. And it's from Miss Love, stating, good morning, Miss Rosser. State asks that the defendant be required to sign the conditions in front of a notary or a sheriff's official so that we can enforce the conditions upon his release, since he was not apprised by the court in person. And I'm sorry, that is in reference to 2 bond orders, I believe, that I had prepared and presented to the court in reference to Mr. Copeland's case that was pending before you in 2023. That is an email dated Thursday, March 2nd, 2023 at 4:42 p.m. And this is just a chain of emails related to the bond order for Mr. Copeland's case.
Brothers and sisters, just keep in mind that not only has Brother Steele been preparing for this moment for some time, he and the team know, and they have known, that having Melnick come forward gives them a lot of options. The only difficulty here is that Whitaker's style, she could just say, so what? You know, they can put all of this on the table, just like they did, you know, by having all those motions, and she takes 5 seconds and goes right through them. You know, so right here, you know, Brother Steele is, you know, ingeniously opening the door for several options, including there had to be another ex parte to get to that immunity that no one see. Melnick was involved. No one was involved. You know, there are lots of different things that he's opening up. But the difficulty again is, you know, Whitaker could still just be like, so now, you know, you go through this whole thing for another year, then maybe you get to the appeal, and then, you know, bring it all up in appeal, and then you guys can win the appeal. So these guys sit in jail until then. That kind of junk, you know, I mean, it's just ridiculous, utterly ridiculous. But what we're looking at right now is Brother Steele giving them more avenues to argue, you know, pushing for mistrial, pushing for bias, pushing for corruption, trying to show that the state is corrupt in their dealings one way or another, which gives an opening for another mistrial argument. But again, Whitaker may not care. So. Okay. Glanville's already gone. So. And if you get that, then what have you really gotten?
In 2023.
All right. And you're forwarding that in June of 2024 to say, see, you knew at some point I was representing him. Okay.
That's correct, Judge.
Is that document, is defendant Williams a 3-page document, or just the one portion of the chain that you just read?
So this is a continuation of 3. Okay. There's more to it, Ms. Love.
Is it a 3-page
It
document?
appears to be, I think it appears to be a 3-page document.
Okay, brothers and sisters. Homeboy here talking to Love. Do you remember him? Remember him from the Willis Wade situation? Remember that homeboy? Very, very smart. Very, very smart attorney. But remember? Do you remember? So are we seeing the infusion of Sister Fani coming on in? We've been saying heavyweights need to show up. She need to bring the team. Do you see what's happening right there, brothers and sisters? That's the homeboy that was defending Fani. Huh? He was at that table with Fani and Brother Wade. That cat right there. Yeah.
Yes, yes. Okay.
Do you need me to, I don't need to read all of this.
No, I don't think so.
We move for the admission of Mr. Williams, number 3, for purposes of today's hearing.
It's admitted.
Why did you, Mr. Melnick, why did you send this to the district attorney's office on June 7th, 2024, 11:52 a.m.?
Because of what they claim to be the confusion as to whether or not I was representing Mr. Copeland for purposes of his being a witness in this case. I think these emails demonstrate that I did in fact represent him and that they knew I represented him.
And were there conversations that you represented Mr. Copeland for the witness in the YSL case during that time?
Yes, there were.
And who did you speak with?
Miss Love?
Okay. And you're responding to Mr. Williams, number 2, that's already in evidence?
Yes.
All right. Your Honor, I move for the admission of Mr. Williams, number 3. It is a 3-page document.
It's admitted.
And I'm going to mark this as Mr. Williams, number 4. Can you take a look at this and tell us if you recognize this?
I do.
What is it? Okay. And what is that?
It's an email that I also sent on June the 7th, 2024 at 11:54 a.m. To Miss Hylton.
Okay, as we keep bringing up Sister Hylton, who we already knew was not going to be here this week, keep in mind, if they do get to Brother Woody on Wednesday, if Professor Woody is on the stand, then who is it going to be? Is it going to be Love, Atkins? I mean, who would it be, right? Now, it could be that cat you just saw. Could be Sister Fani. Very interesting. But who is it going to be? Who's going to be now the attorney questioning Professor Woody on Wednesday if we get there? There's magic in the house.
Hylton and Miss Love, referencing another communication I had from the district attorney's office. It was a forwarded message from Peachtree Offices, which is an executive office company that answers my phone for me, where I got a message from Peter Herzog asking me to contact him in reference to Kenneth Copeland. So it's a forwarded message from June the 27th of 2023 that I then forwarded to Miss Hylton and Miss Love, demonstrating that they should have just communicated with me about Copeland before questioning him.
And go ahead. I'm sorry.
And before we got into all this.
And who is Peter? And I'm going to spell the last name, okay?
Yeah.
Herzog. Who is that person to your knowledge?
I believe his last name is misspelled there. I think it's Herzog, but Peter Herzog is the assistant DA in the Fulton DA's office.
And Mr. Williams, what's marked as number 4, is sent for that message on June 27, 2023, about 3 months after the March 1, 2023 correspondence with Ms. Love about Mr. Copeland.
That's correct.
Now, if your representation of Mr. Copeland had in fact ended when you disposed of the case before the Honorable Judge Whitaker by that time, do you remember? Did it end?
So my case with Judge Whitaker, is that what you're asking me about?
Yes.
Yeah, I believe it had, but honestly, I haven't gone back and checked it.
If y'all have the case number, I can look it up and let you know the disposition date.
I don't have it.
Happy to do that. Nobody has it.
It
was a 22 SC case, but that's all I know. It's fine. I can probably pull it up some other way. Y'all go ahead.
Okay. And you forward this, you said why? This message.
To reiterate the fact that the Fulton DA's office knew and should have known that I was representing Mr. Copeland for purposes of his testimony in the YSL trial. Mr. Herzog was never involved in the case before Judge Whitaker. I'd never spoken with him about anything related to the case in front of Judge Whitaker. The only attorneys that I ever spoke with about the actual disposition of the case with Judge Whitaker was Abigail Potter, Abby Potter from the DA's office, and Mr. Abbate. And the only reason Mr. Abbate was involved with it, that's Adam Abbate from the Fulton DA's office, was because he was concerned about Mr. Copeland's testimony in the YSL trial.
And obviously Ms. Love, because she
And
was
Ms.
the bond
Love,
order.
yes, right.
Same
And Ms. Love
reason?
the bond order, that's correct.
Okay. Now, I'd like to show you Mr. Williams' number 5. Oh,
Can
Your
I-
Honor, I
can
move
I-
for the admission of Mr. Williams, number 4.
It's admitted, and for purposes of the record, the case before me where Mr. Melnick represented Mr. Copeland is 22 SC 182134, and the final disposition was actually on June 29th of 2023.
Is number 4 a one-page document, or are there any more?
It's a one-page document.
Okay, I'm showing you Mr. Williams, number 5. Tell us if you remember that, look at it.
I do.
Okay, and is it accurate?
It is.
Can you describe, like you've been doing, the date and time, what it is, what it purports to be?
It's dated June the 7th of 2024. It's to Miss Love and Miss Hylton from me. And it is in response to an email that I received. I'm sorry.
That's okay. You can look at the documents, multiple.
Yeah, okay. So this is a part of the same chain of documents where I was referencing the fact that Miss Love certainly knew that I was representing Mr. Copeland. She and I talked extensively about Mr. Copeland, and she had told me that she wished to use Mr. Copeland as a witness in this case. Obviously, by the time we were having these communications in March of 2023, the case had long since been indicted, and Mr. Copeland was not charged as a party on the indictment of this case. So this is a continuation of the same emails going back to March 2nd and March 3rd of 2023, where we're referencing the bond orders. These emails actually go back to March the 1st of 2023, where Ms. Love is discussing whether or not Mr. Copeland should be subject to a curfew as part of his bond order. There are, I seem to remember, other communications in which Ms. Love references the fact that she's concerned about Mr. Copeland's safety and the like. And then so the last part of this email, which is at the top of the first page, is where Ms. Love questions whether my concern is for Mr. Copeland or Mr. Steele and Mr. Shart's client, neither of whom I've ever met or have any relationship with whatsoever. And then I responded to that.
Did I ever do anything untoward to affect your representation of your client, Mr. Copeland?
Absolutely not.
Did Mr. Shard do anything?
No.
Did anybody come to you, at you, about your representation, Mr. Copeland, in this case?
What Mr. Copeland did on June 7th of 2024, where he asserted his Fifth Amendment privilege, was entirely his decision. I was there just as his mouthpiece, as a lawyer, as his advocate for purposes of him asserting his Fifth Amendment privilege. Other than that, I have absolutely no agenda in this case whatsoever.
When Ms. Love wrote on a motion, ex parte motion for the former judge, the recused Judge Glanville,
Yeah, I would
grant your
object to
client.
the introduction through this witness or the posing to this witness of any question about a motion that I wrote, given that the witness cannot testify confidently about anything that I specifically wrote of, but I.
All right, well, I don't know yet what the end of the question is going to be, so I'll hold your objection until I hear the question.
And it's in the record. Already, Your Honor, I could get another copy though. Ms. Love wrote in that motion seeking use immunity under 25-5-507 for Mr. Copeland.
Yes.
That Mr. Copeland on Thursday, June 6, 2024, had some sort of interaction or dealings with members of the defense team. To your knowledge, is that true?
I have no knowledge of that.
All right.
Do you want to admit, or did you want to tender for admission Williams 5?
I do. Yes.
All right, that's admitted.
Thank you, Your Honor.
And Williams 5 is what?
Okay, Mr. Melnick, I don't have any other
Hang on. What are
questions.
you asking?
for
Hang on,
you.
hang on, Mr. Steele. What are you asking?
Just
what it is.
Which one is it? Yes.
It's
Just
the last
part
one they
page?
discussed that, I don't know how many pages it is. I don't have any of it in front of me, but it's the last one they discussed that has the email from you asking who Mr. Melnick is most concerned about or something like that. And then Mr. Melnick's rather peppery response back.
Okay, so it's just, could the court ask for clarification, just one page or?
I don't know. 4 pages.
Mr. Melnick, were there any BCC? You know what a BCC is?
Yes.
Okay, I apologize for asking.
Yeah.
Were there any-
We're all old enough to know that that means blind carbon copy. A whole lot of people don't know that anymore since we don't use carbon copies, but that's where somebody can see it, but the recipients who are CC'd don't know.
Yes, I did not blind copy anybody on that last email. I just sent it to Ms. Hylton and Ms. Love.
Any
I
app-
told her Ms. Love.
I apologize.
Yeah.
Any allegation that there was some sort of teamwork or conspiracy against the state of Georgia and against your client, Mr. Copeland, is that true at all?
It is categorically untrue.
All right. I want to thank you so much. I don't have any other questions.
Ms. Love, do you have questions of Mr. Melnick? Hang on just a second.
Just briefly.
Okay, hang on. You have questions too? All right, I'll let Mr. Sharp go.
And those are the court's copies.
Okay.
Mr. Melnick, if you're more comfortable taking the witness stand, that's fine, but, okay.
Mr. Melnick, good morning.
Good morning.
As part of your representation of Mr. Copeland, as part of your representation of Mr. Copeland, yes, sir. Did you also make it known? Did you make your representation known to the defense counsel in this case, specifically myself and Mr. Steele?
I did. Yeah.
Okay. In your dealings with the defense in this case, have myself or Mr. Steele ever gone behind your representation to your knowledge and attempted to speak to Mr. Copeland without your knowledge and understanding?
I have no knowledge of that.
Well, as we continue to see the fantastic teamwork of the defense, just looking forward to seeing exactly the body language when Sister Love asks her questions of Brother Melnick and where she'll do it from. Because as Sharp just had to move closer to get to the microphone at the podium, is Love actually going to move that close to Melnick, or will she use the microphone at her desk to keep distance? It's going to be interesting if they're going to actually be that close. And we know he did use that quote unquote spicy language directed toward her in that email. Let's see. Thank you for being here.
I'm not aware of any time that would have happened.
Since you were alerted about the state speaking to Mr. Copeland, have you read the transcripts from the ex parte communications?
I have mostly read them. I'll be honest and say I haven't read the whole thing.
Okay. Have you become aware that Mr. Copeland was speaking to the state in the week leading up to June 7th, 2024?
Yes.
Okay. Have you become aware that Mr. Copeland was in the actual courthouse speaking to the state on that week?
I became aware of that on either June 6th or June 7th.
Did you know anything about that as it was happening?
I did not.
Before you reached out to the state via those emails that have been introduced, did the state ever tell you that they were communicating with your client?
No.
How did you initially learn that the state was communicating with your client?
Are you referencing the week leading up to June the 7th of 2024?
Yes. Let me ask in a more precise manner.
Mhm.
Did you become aware on Thursday, June 6, 2024, that the state had been speaking to your client that week?
Yes.
And did you become aware that the state intended to call your client to the stand on the next day, that Friday?
Yes.
Okay. Did you, and how did you find out about the state's plans to call your witness to the stand?
I believe you called
Could you say it again?
me. You called me.
You being
Yes.
Matt Shutter?
Yes.
Okay. And I called you on the telephone?
Yes.
Okay. In that conversation, did I ever ask you to do anything on behalf of myself or Mr. Steele or our clients?
Absolutely not.
Did I ever ask you to stop Mr. Copeland from testifying?
Absolutely not.
As a lawyer, is it appropriate to contact another lawyer about their client?
Objection, Your Honor, as to this witness being qualified to speak about what are in the ethics.
I would hope that every lawyer in the state of Georgia is qualified to speak on what we're expected to do under our code of ethics. I'm going to overrule that.
Would you repeat the question, please?
In your experience as a lawyer, is it appropriate for another lawyer to contact you about matters concerning your client?
That's law school 101.
And is that what I did on Thursday, June 6, 2024?
Yes.
Mr. Melnick, before you got in, well, your testimony is you were involved representing Mr. Copeland
Yes.
throughout this entire period, correct?
Mhm.
Before you emailed the district attorney's office about their communications with your client that you were unaware of, to your knowledge, had Mr. Copeland been granted any sort of immunity or legal protections for his testimony?
To my knowledge, no.
Okay. After
Something else that we'll keep monitoring, but you see that there's this contention and there seems to be some difficulty between Speedy Whitaker and Sister Love. We are watching this and you're noticing it, but keep in mind what you just saw, not only the snap towards her and the overruling of the objection, and then Brother Melnick put a fork in it, right? And said, well, yeah, that is, that's law school 101, jumping on that same point, like, bashing Love for even coming up with that. But what you don't want to miss, brothers and sisters, is Love made the objection sitting down. Don't want to miss that. So remember when Whitaker first shows up and everybody's being so deferential, especially from the state, and doing a lot of active listening, nodding their head at everything she's saying and being so cordial and sweet and trying to, really be on her good side. And now Love is a different thing happening. You dig it? A different thing. And even objecting without even standing up, right? Just like, I keep my seat. Got to catch that. That's not the same person who's trying to win friends and influence people. Thank you for being here.
After you contacted this district attorney's office and actively communicated with them about your client, what protections was Mr. Copeland granted?
Use immunity.
I have nothing further. Thank you.
All right. Any other defense attorney with questions for Mr. Melnick? All right. Hearing no other. Go ahead, Ms. Love.
Thank you, Judge. Mr. Melnick, I'm just gonna be a little bit brief and I'm gonna clarify some things. Is Defendant Williams exhibit? Yes, Mr. Hart.
Or speak just more loudly.
Fair.
Or come around and, yeah.
I'll take the stand.
Okay.
No, I just can't get these two.
You can leave them there.
Okay.
That's
Does somebody have a copy of those exhibits for the court?
Judge, I'll give to the court the ones that he has admitted, and I'll just go ahead and use the ones that.
All right, so there's the answer to that. We were looking for how that was going to work, the proximity of them being that close together. So Melnick says, hey, I'll just take the stand. Interesting.
have copies.
Okay, thank you. Just pull that mic down towards you and make sure the green is on. Mr. Melnick, there should be some button somewhere.
You see where it is?
Turns green.
I don't actually see it. It sounds to me like it's on.
Yeah, sounds like it's on. Yeah. All right, go ahead, Ms. Love.
Thank you, Judge. Mr. Melnick, and Your Honor, I'm going to use, unless the court instructs me otherwise, I'm going to use the copies that I was given, that I've marked as defendants the way that they've indicated they should be marked exhibits.
Okay.
Okay. Mr. Melnick, I'm showing you what is the copy of Defendant's Exhibit 1
Yes.
that was given to the state and to the court. Is this an exact copy of Defendant's Exhibit 1 that I'm showing you?
I believe so. I mean, I haven't printed them up. I don't know if there was another email that was.
Y'all are welcome to just use these if you want. That doesn't need to be an issue. I mean, they were handed to you, Ms. Love, by Mr. Steele, right?
Yes, Your Honor.
All right, then they ought to be exact copies.
May I refer to them?
Just a second. Mr. Harvey, yes, can you not hear? Oh, me? Okay, sorry. I was just saying, I'm sure that the copies are the same, but if she wants to use the admitted copies, she can. I'll trade you. How about that?
Yes.
Just make sure you get the admitted copies to the court reporter when we're finished with this.
Yes.
Thank you.
So showing you what has been admitted as Defendant Williams Exhibit Number 1.
Yes.
Looking at Defendant Williams Exhibit Number 1, is that an extraction? In other words, is that a portion of an email cut out and isolated from a larger email?
I don't believe so.
Okay. Then I'm going to show you Defendant
All right, brothers, this is interesting because when Brother Steele was initially talking to Melnick and Love seemed to interject, there was a response that was missing on an email that the email that they were looking at that Steele was talking to Melnick about didn't have a response. And the copy that Love it seemed to have had the response to it. So it appears that she's showing that there may have been some monkey business in the exhibit, that the actual chain wasn't complete, that was just brought in. Now, it appears that maybe it was on 2 different pages, but we're going to find out either way. If by chance Love is successful and she can actually show that there was some hanky-panky going on with what was just presented, now that would be interesting, right? I mean, but why would Steele do that? Why would Steele do that? But if Steele did that and Melnick co-signed it, but wow. So I mean, it may be that they were just on 2 different pages and both of the exhibits were given to the court. But if Love really has something right here, if she's really going to show that there's stuff left out of what we just heard, I mean, wow, right? Let's see.
Your Honor, I just may need the portions that I gave to the court because I don't see.
All right, here you go.
Yep. Thank you. All right. All right. Showing you what I will mark as State's Exhibit 1, copy of Defendant Williams Exhibit 1, Melnick proffer. And I was provided this by Mr. Williams, Your Honor.
By Mr. Steele.
Yes. Could you look at what I've now labeled as State's Exhibit 1 and compare it to what has been admitted as Defendant's Exhibit 1 and tell me whether or not those two documents, State's Exhibit 1, just for the purposes of the record, is a one-page document. Could you tell me whether these two documents contain the content from the same email?
So the content appears to be the same, other than the fact that on the one that you just marked, there what appears to be the seal from the Fulton County, the Atlanta Judicial Circuit.
And in fact, the one that I've marked as State's Exhibit 1 is the actual email that Mr. Steele would have had access to, correct? It's a portion of the actual email chain, given that it has that seal on it.
Very often, if I'm sending an email, I'll just pick up from the last email that I sent to or from that individual. So that may well be, there may have been a prior email, but I mean, if it was between you and I don't remember exactly when it was.
I'm showing you what has, I believe, been marked as Defendant Williams Exhibit number 2. Let's see if those two match. Give me 1 second, okay? Defendant Williams Exhibit 2. Okay. So you'd agree with me that Defendant Williams Exhibit 2 is in fact the top portion of the email that I have labeled and tendered as State's Exhibit, or not yet tendered, but labeled as State's Exhibit 1.
Yes, that's correct.
Your Honor, the state tenders State's Exhibit 1 just as evidence.
All right.
All right. Now,
Admitted.
thank you, Judge. So looking at Defendant Williams Exhibit 2 and State's Exhibit 1, are you able now to say with any more clarity that Defendant Williams Exhibit 1 is a document, a piece of paper where a portion of the email chain that is contained within Defendant Williams 2 and State's Exhibit 1 has been extracted and pasted onto a piece of paper?
So I can't speak for how Mr. Steele printed this up. I wasn't there in his office when he did that, or whenever somebody in his office did that. You are correct that what has been marked here as Mr. Williams Exhibit number 2 is part of a chain of communications between myself, yourself, Ms. Hylton, Mr. Steele, and Mr. Shart. Looks like there's a CC to Antonio Long as well. Yeah, so but these emails were sent after the State's Exhibit 1, which is also Mr. Williams Exhibit number 1. These emails date, so you can see here, Ms. Love, this is dated June 6, 2024, 5:47 p.m. Yeah, this is dated June 6, 2024, 4:31 p.m. Right. So this is just part of the same line of communications that we were having, where I said, Mr. Copeland doesn't want to plead, doesn't want to testify, wants to take the fifth. Ms. Hylton responds, and then I respond to her response. And in her response, this is where you get your insignia for the Atlanta Judicial Circuit.
Okay, so let me be clearer. The exhibit that is labeled Defendant Williams Exhibit 1, did you ever forward that separately to Mr. Steele or Mr. Sharp?
I think I just forwarded. I mean, I wouldn't have had to because they got the emails. Right.
Okay.
So they got this email initially.
All right, y'all, when y'all are saying this email, we have no idea
I got
what you
you.
mean. Can you refer to the exhibit numbers?
They got Mr. Williams' email number 1, exhibit number 1, which is the first email from.
I'm also waiting to see here, brothers and sisters, is Whitaker going to allow this to be fully explored? I mean, Love thinks she's on to something here. and you know how Speedy Whitaker can get. And I'm not vouching for the fact that Love really has caught them in some junk, but I think there's enough potential here that you want to see where this goes. I mean, I think as much as Sister Love has, you know, difficulties within her emotions and all that kind of stuff, but if she's on to something here like this, dealing with what was just presented after it was just fought to be presented and all of that, she has every right to explore this. So let's see if Whitaker gives her some room to see if there was some junk that went on here with these documents. So let's see. But again, I think that if she's got something, I think she deserves the right to be able to explore it right here. It would be pretty dirty if she's right, but let's see.
June 6th at roughly 4:30 p.m. Then there was a response from Ms. Hylton, June 6th, 4:57 p.m.
And that's marked Williams too.
Williams too, thank you. And then I respond to that, June 6th, 5:47 p.m.
Okay, so
And that's also on Williams.
On two,
right?
yes.
Yeah, okay.
So as it pertains to my original question, Defendant Williams Exhibit 1 was never a communication that you sent separate from the emails that are contained in Defendant Williams 2 and State's Exhibit 1. Is that wrong or right?
That is wrong.
Okay, so you sent, without forwarding the rest of what is labeled as Defendant Williams 2 and State's Exhibit 1, you sent an email that contained only the document.
All right. It sounds like Melnick should have answered that last one as to the best of my knowledge or some kind of qualifying instead of saying that's wrong. You know, he sends emails all the time, right? And this was a while ago. So I think that he needed to give himself a little room right there. He sees what she's trying to do. Everybody in the room sees what she's trying to do. And for him to just say, no, you're wrong. And she's holding documents. I mean, she's doing this for a reason. So you might want to just say, you know, to the best of my knowledge, he knows that, but he didn't do that. No, you're wrong. Yeah, you might want to be careful with that.
That is labeled Defendant's Exhibit 1 to Mr. Sharp, Mr. Steele, Ms. Hylton, and myself.
I sent it on June the 6th at 4:30.
Right. And do you also see June 6th at 4:31 p.m.? And when you say 4:30, you do mean 4:31 p.m.?
Yes.
Do you also see June 6th, 2024 at 4:31 p.m. on the email State's Exhibit 1?
Yes.
And in fact, the email State's Exhibit 1 is at the bottom, meaning it came before
Yes.
the emails that were Defendant Williams Exhibit 2.
That is correct.
Okay. And so given that State's Exhibit 1 looks as it does, are you saying that the email that is Defendant Williams 1 is the entirety and not a part of any other email chain that you sent?
This email was the first email sent. Okay, so when I say this email, I'm referring to Mr. Williams Exhibit number 1.
Okay.
Was the first email sent on June the 6th of 2024.
Okay.
That is the first email. Mr. Williams Exhibit number 2 is the continuation of that chain of emails in which Ms. Hylton responded to me, and then I responded to everybody else, including yourself.
Thank you for clearing that up. Your Honor, I'm going to give back to the court's copies of the emails.
Okay.
Thank you. And I apologize, they're not.
That's fine. Okay.
You were asked, Mr. Melnick, you were asked by Mr. Sharp, how did you become aware that the state was talking to Mr. Copeland? Do you-
Okay, let's try to figure out where that squelch is coming from.
Might
and
be from
maybe-
me. I may have been too close.
Okay,
to the
where's
microphone.
state's one, Miss Love?
And Your Honor, if
If
the
you've
court
got-
didn't, I send her.
Yeah, you did, it's submitted. Thank you.
Did we clear up the squelch? Is it gone? Okay.
It seems to be.
Is it, what's mic? Okay. I'll step away from it so that I'm not echoing. Mr. Melnick, do you remember Mr. Shard asking you, how did you become aware that the state was talking to Mr. Copeland?
Yes,
And did you understand that question to me in 2024?
leading up to June 7th of 2024, yes.
Did you answer how you became aware that the state was talking to Mr. Copeland?
I did,
How did you become aware?
because Mr. Shar told me.
Okay. And when Mr. Sharp called you, was that the first time that you were aware that the state had been talking to Mr. Copeland?
Since, I mean, I was aware of an interview that took place with, I think it was investigator Viverito. I don't remember the date of that interview, but it was during a time when I was representing Mr. Copeland. But other than that particular communication, that was the first time I became aware of any direct communication between the district attorney's office and Mr. Copeland.
And when you speak of the interview by investigator Viverito, was that while she was with the DA's office or while she was with the Atlanta Police Department?
I do not know.
And was that interview one that you have seen or have knowledge as a part of the discovery in this case or something different?
I have knowledge of it. I've never seen the interview. I know that it exists.
And was that interview a formal interview while he was in custody at the jail?
Yes, as I recall. I mean, I haven't seen the interview, but I believe he was in custody at the time.
And did you give permission for that interview? I'm gonna turn this off.
Just speak loudly.
Did you give permission for that interview, or did Mr. Copeland reach out to investigator Viverito to talk to her?
I have no idea. I did not give permission for that interview. I do not know if Copeland reached out to her or not.
And had you been paid by Mr. Copeland or retained by Mr. Copeland to represent him on criminal charges at that time?
Yes,
And was that prior to March of 2023 that this interview took place?
yes.
Do you recall at any time representing to any member of the district attorney's office in 2023 that Mr. Copeland had not paid you for your services?
No.
Do you recall telling a member of the district attorney's office that you were not representing Mr. Copeland on his criminal charges because he had not paid you? I'm just asking if you remember. If you don't, that's fine.
I don't.
Okay.
No, I represented him in his criminal charges to the end.
We understand.
Yeah.
And when Mr. Sharp called you, what was it? What did he say to you exactly?
He said that Mr. Copeland was being called as a witness the next day, June the 7th of 2024.
So at what point how did he tell you that the state had been talking to you?
During the course of that conversation,
What did he tell you exactly?
he just said that the state's been speaking to Mr. Copeland.
How many times have you spoken with Kenneth Copeland between the time that Mr. Sharp called you and the time that you resolved his criminal matter before?
How many times did I speak with him between June of 23 and June of 24? I mean, I can't give you an exact number, but Mr. Copeland has always been in communication with me.
Did you speak with him more than one time?
Yes,
And during your communication with him, did he always have access to your phone?
always.
Did he appear to always be aware that he could reach out to you at any time?
This is something where we're going to have to, I don't feel comfortable.
I can stop and pull that question all the way back.
All right.
And the court can decide if the next question is privileged. Did you assure Mr. Copeland
I'm not going to talk about anything I said to Mr. Copeland. Period. I'm not going to talk about anything that I said to Mr. Copeland.
Okay. Based on how you have already testified, is it safe to say Mr. Copeland didn't reach out to you and say to you?
I'm not going to talk about any communication I had with Mr. Copeland.
Do you have any idea why it would be Mr. Sharp who first alerted you that the state was talking to Mr. Copeland?
No.
Okay, brothers, so just keep in mind that Sister Love is on record, according to the defense, for trying to, bring to the light of the court the fact that her contention is that Melnick has been working with the defense, right? Remember when we got the ex parte, right? That's what Love was, putting out there. That was the theory, right? That Lil Woody is not being properly represented by this guy, right? Because this guy is actually working with them, the defense, right? And remember that whole thing. So right now is her attempt, among other things, to try to bring that out, that Melnick, has been working with the defense. So if she can somehow get to that, then, it's pretty good point if she can get there, if it's true, right? But she's got a long way to go to be able to do that. And it doesn't sound like those emails turned out the way that she wanted them to, unless she has a plan of bringing it back up, because it seems like she just hit a wall and moved on, which doesn't look good for her. So let's see. I mean, did she set it up and gonna bring it back? Either way, she's got a long way to go. And Melnick has his bar license. He knows that he's, this is being streamed all over the world. So, he's not going to break attorney-client privilege because Sister Love's asking him something. He's not going to throw away his whole career right now over this. No way. So, that's part of his sternness. I'm not going to, I'm not going to give up my career because you asking me a loaded question. Come on now.
And are you aware of any communications Mr. Copeland made to state as it pertains to your representation of him after his criminal case was resolved?
I'm not.
Do you recall, you indicated that you spoke with Mr. Abbate, the district attorney's office, regarding Mr. Copeland as a witness in the case that we are in trial on now?
Yes.
Do you recall telling Mr. Abbate that you were not representing Mr. Copeland beyond the criminal case?
No.
Was the time or times that you spoke with Mr. Abbate in the context of resolving or getting a bond for Mr. Copeland's criminal charge?
It was primarily with regard to the bond and the underlying criminal charges. I don't believe Mr. Abbate has much, if any, involvement in this case.
What is your recollection of what it was that you said to Mr. Abbate or anyone else regarding your representation of Kenneth Copeland beyond his criminal charges?
I don't really recall having, other than the fact that, he's talked to me and I've talked to the state, I don't recall having in-depth conversations about it. Y'all were still in the middle of jury selection. It wasn't much of an issue.
Understanding you don't recall having in-depth conversations about it, what is it that you recall telling Mr. Abbate or any other member of the state about your representation of Kenneth Copeland beyond his criminal charges?
I don't really have any independent recollection of anything specific.
How are you then able to say that you spoke with members of the state and told them that you represented Kenneth Copeland in his capacity as a witness in this trial?
Because I had specific conversations with Don Geary about this case and about Mr. Geary's desire to use Mr. Copeland as a witness.
Am I correct that that was pre-indictment?
Yes.
And am I correct that that was at a time when there was at least a prospect that Mr. Copeland would be a defendant and not only a witness?
That's correct.
So apart from the conversation you had with Don Geary pre-indictment, where there was a prospect that Mr. Copeland would be on the indictment, do you have any recollection of conversations that you had with members of the district attorney's office regarding your representation of Kenneth Copeland as a witness in the current case 22-18357?
Ms. Love, we did not have substantive discussions about what his testimony would be, but everybody in your office knew that I was representing Kenneth Copeland.
With respect, I don't mean substantive, I'm asking you simply, do you recall what it was, if anything, you said to either Mr. Abbate or any other member of the district attorney's office regarding your representation of Kenneth Copeland as a witness only in the current case 22-18357?
Just that I'm representing him.
And you recall specifically saying to some member of the DA's office, apart from the criminal charges that you helped resolve in 2023, you recall saying to a member of the district attorney's office, I'm representing Kenneth Copeland as a witness only in the YSL trial.
I said that to you, okay?
That is your memory.
Yes.
Where was this? Is it on the phone?
Yes.
Okay. And what was it? Was it before or after Mr. Copeland resolved his criminal charges?
I guess before, because it was when we were talking about the bond issue.
And so what exactly did you say about your representation?
I said that I was representing him, and if you want to talk to him, talk to me.
And when you said you were representing him, isn't it true that you were talking about this criminal charge?
No, Miss Love, it's not true.
Did you state that you were representing him beyond this criminal charge?
Had you finished your answer?
That's fine, yes.
Make sure he finishes his answer before you put the next one on the floor, okay?
Did you state that you were representing Kenneth Copeland in his capacity as a witness in the 22 SC 183572 case?
Yes.
Outside of the criminal charges?
Yes.
And did I hear you say that it was your testimony that you never once indicated that Kenneth Copeland?
That's a heck of a thing right there. So now we're down to a possible phone conversation. What do you think, brothers and sisters, that Melnick knows? Hey, I mean, it's a phone conversation, so it's your word versus mine. And most of the people right now don't like you and they like me. So I'm just going to say yes. But the way he's saying yes, what do you think, brothers and sisters? Is that a credible yes to you? I mean, let's say that the state, they knew. Let's say everybody in this room knew, and what we just found out, even Whitaker knew, because Whitaker handled a case where Melnick was representing Lil Woody, right? So she was like, I even knew. That was good information for us. Okay, so everybody basically knows. But Love's contention is we didn't know. That's why we were having conversations without Melnick being present, because Woody told us that he didn't have an attorney, that Melnick wasn't representing him at the time. And if we would have known that Melnick was representing him, we would have stopped. Just like Hylton's email said, that once we got the email and said, okay, well then we won't have any more conversation with him. We wouldn't have had it if we knew, but we didn't know. Okay, so now we're down to no documentation, but Melnick's asserting, I told you, Love, on the phone. Now, I'm asking you, brothers and sisters, if everybody knows that for a long time, Melnick's been Lil Woody's attorney, right? Everybody knows that. Let me ask you this, brothers and sisters. Let me ask you this. If he's talking to Sister Love, right, would it make sense for him to do what he just said he did? Would it make sense for him to say, I'm representing Lil Woody. I'm representing Kenneth Copeland. So if you want to talk, it would be understood, right? It would be understood, right? Why would he have to say it to her? So her question is, did you say it? And he's saying, yes, I said it. And I'm saying, why would he need to say it? So it seems like the truthful answer, again, it would seem like the truthful answer would be, I didn't need to say it because everybody knew. So no, I didn't say it because that'd be ridiculous for me to say it. You're asking me if I said something that you would already know. Why would I offend you like that? Why would I offend you, love, by saying what we all knew? Everybody in this room knows I'm his attorney, and you knew too. Why would I say it? So it's a dumb question, Miss Love. That sounds more like the truth. But to say, yes, I said it. Yes, I said it. And I said it to you. Why would you say it? Why would you say what everybody knew? Just interesting. It is interesting. Thank you for being here.
Had not paid you, and you weren't even representing him in the criminal case.
No.
So is it also your testimony that no one from the DA's office reached out to you to try and get you to go speak with Mr. Cole
About what?
about his criminal charges?
Nobody tried to reach me to go talk to Mr. Copeland about his criminal charges.
Is that your testimony?
I don't know why that would be necessary.
That wasn't the question. Answer the question.
No, I don't recall anybody speaking to me about going to talk to Mr. Copeland about his criminal charges.
And so is it fair to say you also don't remember telling any member of the DA's office that you were on vacation and you were not able to deal with Mr. Copeland's criminal charge?
So I resolved Mr. Copeland's criminal charges. As far as I know, I resolved them to Mr. Copeland's satisfaction. And it may well be that at some point I was on vacation and not available to go speak to Mr. Copeland. I don't recall specific dates and times, but there is no issue with communication between myself and Mr. Copeland. Okay.
So as it relates to the question that I asked, do you recall there being a time when you conveyed to the district attorney's office that you were on vacation and could not go to talk with Mr. Copeland?
Ms. Love, if you have such a communication, then I'm sure it exists. The fact that I may have been on vacation a day or a week doesn't mean that I wasn't communicating with my client.
Okay, brothers and sisters. Now I'm going to ask you, that tone that he's using versus answering the question, should Whitaker be allowing that tone? I'm asking you. I mean, I'm looking for fairness, all right? And yeah, I can be hard on Sister Love myself, okay? I mean, I can be hard on her. But dog, I mean, a witness is snapping, right? He's snapping and not answering the question. So is Whitaker going to just allow that? Now, if she's going to allow that for everybody that gets up there, if that's the way she going to roll, like, hey, y'all duke it out, then okay. But if she's going to be, if we get that far a week from now, 2 weeks and 3 weeks from now, right, showing a different thing, well, you got to be consistent. You got to be consistent. So what's happening here? Let's see. Thank you for being here.
Okay.
And if you would mind answering whether or not you recall it.
I don't recall.
All right, y'all, we've been at this for over an hour and it's really not particularly relevant anyway. So let's wrap things up.
Yes.
There it is. Speedy Whitaker to the rescue. And what did I tell you, brothers and sisters? We could go through all this and then Speedy Whitaker could just decide, it really don't matter anyway.
When you spoke about Mr. Herzog and you said he was never involved in the case, do you know what it was that he was calling you about?
He was calling me about Mr. Copeland testifying in the YSL trial.
And you spoke with him?
Yes.
And he said that?
Yes.
And what did you tell him?
I told him that Mr. Copeland didn't want to testify.
Now, That was in March.
That was in June of 2023.
And did Mr. Herzog ever say he was working on that trial?
That was my understanding of the purpose of his call to me.
Did he say he was working on it?
Yes.
You indicated, and Your Honor, I have about 5 more questions.
All right.
You indicated that upon questioning by Mr. Steele, that your concern regarding the district attorney's office communication with Mr. Copeland was Mr. Copeland's criminal exposure, and that the DA's office was seeking use immunity. And that you considered it ironic that a motion would be filed on June the 7th, considering there should have been, or wasn't, apparently there was no grant of immunity prior to that time. Do you recall saying
I
that?
do.
You never once asked the district attorney's office what protections the immunity afforded to Mr. Copeland.
I'm familiar with what use immunity is, Ms. Love.
Do you recall telling Ms. Hylton in the presence of an investigator that you had never heard of OCGA 245-507?
I believe that I did not know that that was the use immunity statute, but once I read the order and saw that it was the use immunity statute, I'm very familiar with use immunity. I've been doing this for 30 years.
And so you are aware then that there wasn't a need to seek use immunity, but that the motion was to compel Mr. Copeland to testify after the state had offered him immunity.
I feel that the motion and the order that was granted to Mr. Copeland did not protect him very much at all.
And finally, in writing to the email that is labeled Defendant Williams Exhibit Number 5, you wrote, "My concern is for my client. Had I been involved, I would have demanded a much more specific immunity deal. You need him much more than he needs you. You've put him in a terrible position where you know his life is in danger, whether in custody or on the street. He's a marked man from this point forward. Go F yourself if you think I'm doing anything besides protecting my client."
Yes.
So what specifically did you intend to, you didn't include in here anything particular that you were worried about with the immunity deal, but you were very specific about.
Brothers, sisters, I want you to notice Speedy Whitaker. She does what she's doing right now at very interesting times. She'll look back to Shart and Steele. Like, yeah, I know. Yeah, this is ridiculous. Yeah, this is taking too long. You know, now, is that what's happening? Maybe, maybe not. Okay. But just want you to observe things like that. I've even seen her nodding her head, right? So like this moment right here that I've captured for you, you know, just she's doing that. Now, what is she doing that for? Why is she ignoring what's happening, like being dismissive of what's happening and making contact to the back of the room? You know, just something to, I mean, obviously, she's not on the team with the back of the room, because she could have just declared a mistrial. We'd have been out of here, right? So, so it certainly is not, you know, she's YSL, right? But yeah, no, there certainly is some interesting eye contact versus focusing on what's happening in front of her. Thank you for being here.
Mr. Copeland's potential danger from testifying. Is that wrong or right?
We all know that Mr. Copeland is in danger by virtue of his testifying here.
Now, are you asserting that he is in danger for any member of the state from testifying?
No.
And what specifically did you want, more specifically, in the, because you do understand it's not immunity dealings. We can't use anything he says in any way against him.
Yes.
So understanding that, and that the motion was simply to compel Mr. Copeland to testify, given that he had received that, what much more specific information did you want to see in the?
I would have demanded that he be given immunity from all state level prosecutions as a result of any action he may have had involved with any other individual in this case. And I would have seen if we could have included the feds in that as well.
And did you not understand Mr. Copeland, or did you want more than what he was entitled? Did you not understand him to have been afforded immunity for anything he was asked about criminally, whether it was from the state or the defense?
All that protects him from is from you using his testimony against him.
So you did not understand that it actually protected us from using that testimony in any way to get information about him to prosecute him regarding those acts? You didn't understand
It protects him from from his testimony at trial being used against him, Ms. Love.
And anything derived from that testimony?
And anything derived from that testimony.
Let's speak one at a time. Anything derived from that?
Testimony. Are you aware of that?
Yes, ma'am.
So given that Mr. Copeland could not be prosecuted for anything he testified about criminally, the state could not use his testimony to go seek additional information or reasons to prosecute him. What is it that you would have been seeking to get?
So we are getting dangerously close to privileged communications here. So, but I told you what I would have demanded. I would have demanded absolute immunity from any state level prosecution for any criminal action involved in this matter.
Even those that he didn't speak about at all in the state?
Yes.
And could you tell us just why it is that you would have felt that that was
I think that's,
something that should have been afforded?
I'm not going to get into
Even if
that.
it did not?
I'm not going to get into that, Ms. Love. I'm not going to get into that.
Yeah, I think that's all that I have. Thank you.
All right, is there any further questioning? Okay, Mr. Melnick, this time you can actually go. Thank you for your time. All right. All right, let's move on to the next issue. All right. We're done with this, right? Everybody satisfied?
Judge, I'll just proffer on the record, and without calling unless the court finds it necessary, that the lawyer who was.
Okay, on just a second. Yes, sir.
I do not accept any proffer by Ms. Love. I've told the court that before, but that remains.
All right.
I'm rejecting it. She
No,
wants to
I'm not.
testify, then that's fine.
Don't talk while somebody else is talking. Let him finish. Let me rule. Then you can go ahead. I will listen to what your proffer is, because it's really not for Mr. Steele to accept or not. It's for the court to accept or not. Go ahead.
That Mr. Abbate, who was earlier present in court, was on the call that I think Mr. Melnick referenced that he had regarding, he said he had spoken to Mr. Abbate about Mr. Copeland and his representation of Mr. Copeland as a witness in this case. Mr. Abbate would testify that Mr. Melnick specifically and explicitly said that he didn't want to have anything to do with this YSL case, that he was not representing him in his capacity as a witness in this case, and that when he was done with the criminal charges, that was it. I believe that he made some reference to a used car salesman or something like that. I don't remember exactly, but if necessary, I will bring Mr. Abbate back at some point to testify.
All right. Well, if I am presented with a motion that makes that testimony relevant, then we'll hear from him at that time. My point in all of this was just so that Mr. Melnick could feel like he'd cleared his name. All right. Okay. So, anybody need,
My point in all of this was Mr. Melnick could feel like he cleared his name. Yeah, get them brothers a bond. if we're gonna be speedy, and then take care of stuff and have the world watching on pins and needles, like this is a big moment, like something can really turn, and she already done decided. This is what we told you how long ago, brothers and sisters. How long ago this morning did we tell you? She could just decide this don't even mean nothing. She just told us. So if everybody's jumping on to watch this right here, like, oh man, she letting us know. Haha, fooled you. I was just letting him clear his name. This don't mean a doggone thing to me. What I tell y'all? You better watch Speedy Whitaker, boy. You better watch Speedy. Or listen to Rhodes. You know? Oh, man, Melody. Oh, they go, man. She ain't even caring. Yeah, I just want to let him clear his name. This don't mean nothing to me. This don't change a doggone thing. Told you. Better watch it. Better watch it. All right, brothers and sisters. Thank you for being here. We appreciate you.
Restroom break before we move to our next topic. All right, let's take 12 minutes and be back at 10:30.
And Your Honor, there's the omitted parts of the transcript. I just want to let you know before we move on to something else.
Omitted parts of the transcript. Yeah, that's what the next topic's going to be. Yes.
All right, brothers and sisters, we should be able to, we've been taking some analysis breaks, so we should be able to jump ahead a little bit and catch up without having to wait. Some of the advantage of having our analysis breaks, that we can not have to just sit idle for so long. So we'll be able to pick it up. Thank you for being here.
Okay.
I do need to get. Would you please admit me to this?
Oh, I guess if Zoom's relevant, I better get on the Zoom also. So give me a second to do that also.
I'm pretty Zoom illiterate, so I might need a little assistance.
How can anybody be Zoom illiterate in this day and age after all of our COVID era Zooming?
I know enough to not turn myself into a cat.
Okay, if you can let me in, and I guess. Are we going to be hearing from somebody over Zoom?
I just have a brief TikTok that I need to play.
Really?
It's very brief.
Okay.
Well, this is part of the proffer, so it's your choice. I can do it or I cannot do it.
I
Your
have
Honor.
no idea what it's going to be.
I can tell you what it will be.
Why don't you tell me first?
This will be a TikTok of Mr. Copeland speaking to Miss Bumpus, where
Okay.
Mr. Copeland acknowledges that what is in the transcript the transcript is not complete from the June the 10th meeting.
Now that's interesting. And we know that kind of stuff was going on. We know them cats were talking about stuff. Yeah. Is Whitaker gonna allow this? Shout out to Brother Weinstein. Shout out to Brother Weinstein. Wow. Thank you for being here.
Did Mr. Copeland read the transcript?
I don't know what Mr. Copeland has read or not.
So
If you don't want to hear it, then I can just do my proffer, Your Honor.
I mean, if that's what it says.
Oh, I didn't like that. I didn't like that. Brother and sister, she just asked if Mr. Copeland read the transcript. Y'all don't hear that? Y'all don't hear that? Okay, let me give it to you better. Let me give it to you better. It's like if you say, Psh, did Trump even read the transcript? Right? It would go over to you, right? Because you got an impression that Trump ain't gonna read the document, right? you get me? Now, what if she said, what if we were talking about like Sharp, right? Like Sharp, or even Weinstein himself, right? You're gonna be like, of course he read it. Of course he read it. You hear that? You hear that? Like, psh, you believe Weinstein read it all, yeah? Or even the judge herself, right? I mean, as much as she reads, right? You'd be like, psh, of course she read it. So when she says, did Mr. Copeland read it? Dang. Y'all don't hear that? That's pretty insulting. That's pretty insulting. He's on TikTok and he's saying stuff is not in the transcript. Is she saying he can't read? I'm asking if you hear that. How does she snippetly say or ask as if to say, are we sure this boy would even do that? You don't find that insulting? Now, has Professor Woody presented himself in such a way that you would, question whether or not he does certain things? Yes. Has he even said that he wasn't the best student and he was in the special? Okay, yeah. But that's your response? If he says something's not in the transcript, did he even read a transcript? Does he even know what a transcript is? Wow, Judge. That's awfully. Can he spell transcript? I mean, dang, for real? Thank you for being here. Really?
As it shows Ms. Bumpus talking to Mr. Copeland.
Believe it or not, yes, Your Honor.
Okay. And Mr. Copeland says, whatever. I mean, I don't care. Play it.
You can take it for what it's worth.
Yeah,
Your Honor.
I'll just.
Let me just, if I can begin with my proffer, then I can play this, Your Honor. It is my understanding, based on my conversations with Ms. Bumpus, that while the transcript may be, let me be more specific, the transcript of the June the 10th, 2024 ex parte meeting, and I'm not going to list everybody that was in the meeting, but that transcript was complete in the sense that when Judge Glanville was in the room and the court reporter was in the room, I have no basis to believe that transcript is incomplete for when Judge Glanville was in the room. But was a portion of that morning, a significant portion of that morning, based on my understanding, where it was Ms. Hylton was in the room, Mr. Copeland was in the room, Ms. Bumpus was in the room.
And how is that your understanding? Because I don't see that from the transcript. And I know I actually said that at some point, but I went back and looked, and let me reference y'all to, let me find it. All right, so the beginning.
Okay, so shout out to Brother Weinstein, but I think he made a tactical error here. As soon as she was like, I don't care, just play it, and you know how Speedy Whitaker is, when he said that, or when she said to just go ahead and play it, then he should have just played it. No, well, let me just go ahead and get my proffer and then I'll play it. No, that was a mistake, because now you left the door open for all these other shenanigans that she's going to do to let you know what she knows or doesn't know. Go ahead and you got it in, man. Go ahead and play it, and then you can rap. You see? That was a mistake. She was on go, didn't let it go. Now you done rambled a bit, and now she's, back to her. Well, let me find a way to be more efficient and cut through some things and correct some other things that I was rushing through, or whatever the case is. But, now your flow is off because she doing her thing. You had the floor, bruh. Run it. Run it. Thank you for being here.
Beginning of the transcript, it is just other than it is, if we all look at page 3, present in chambers were Judge Glanville, ADA Love, Attorney Bumpus, Court Reporter Weaver, and investigators Long and Hamilton. And then they have a conversation that goes through page 22. On page 23, the proceedings stood in recess from 9:34 to 10:03 because just before then, they had decided to get Mr. Copeland in and Miss Hylton in. So when they go back on the record at 10:03, this is reflected on page 23, it's Judge Glanville, ADA Hylton, Attorney Bumpus, Court Reporter Weaver, investigators Long, Hamilton, some deputies, and then at some point, Mr. Copeland expresses that he might want to call his sister, and on page 36, Mr. Copeland says, this is not the sister, can I speak with her for a second, meaning Miss Bumpus? And it shows that Judge Glanville, ADA Hylton, Court Reporter Weaver, and the 2 DA's office investigators leave chambers at 10:17, return at 10:33. Then Mr. Copeland has a question for the court. And then on page 46, a sheriff's office person comes in and tells Judge Glanville, we have a security issue. We need to stop for a minute. And it reflects that Judge Glanville and that officer, Lieutenant Dean, exit chambers at 10:45. Judge Glanville returned to chambers at 10:47. Okay, and then there's something about he might want to talk to his sister, and on page 52, they appear to maybe call his sister, and Ms. Hylton says, if y'all want to talk, let me go somewhere where I can't hear you. The judge is over there, so just speak low so he doesn't hear you. And the court says, hold on. And Judge Glanville exits chambers along with Ms. Hylton, Investigator Long, Investigator Hamilton, and the court reporter. They all leave from 10:53 to 11:28. When they come back in, and this was where I got confused, the court says, okay, all right, Mr. Copeland, have you had an opportunity to talk with Ms. Bumpus, your lawyer, and Ms. Hylton, the state's counsel? Have you got any other questions? And I hadn't looked up to see who left before, so I thought maybe just the judge had left, but it appears that they had all left. So, I assume he meant, obviously we know Ms. Hylton and Mr. Copeland had been talking prior to this. So I guess that's what he meant. But anyway, that's where I had gotten that. So where do you get your basis that they were in there at some point?
I get my information from Miss Bumpus.
Okay.
So perhaps, and I don't know specifically at what point. I don't know if Miss Hylton came back in the room prior to going back on the record. I don't know. But at some point, Miss Hylton, Mr. Copeland, and Miss Bumpus were in that room discussing things amongst themselves. And my understanding is that Mr. Copeland relayed information regarding the murder of Donovan Thomas and perhaps some other information that Ms. Bumpus indicated would be Brady material. And so I just want to put that on the record that this happened.
Okay, so you can't put that on the record
Well,
that it happened. You can put it on the record that Ms. Bumpus told you it happened.
Well, Ms.
Is that
Bumpus-
what you're saying?
Yes, Your Honor.
All right, I want to hear from Ms. Bumpus if that's the case.
Okay. And then would you like to, are you interested in
If you
seeing this
want me
TikTok?
to, that's fine.
Okay.
No, I'm not interested in seeing it, but if you feel like it's relevant, I'll watch it.
Thank
Your
you.
Honor, may we approach briefly Mr. Kendrick?
Yes.
Well, appears that Miss Bumpus's YouTube channel will get another spike in views, as apparently she's going to make an appearance at some point. There it is. All right, there you go, brothers and sisters. I got a money maker for you. I got a money maker for you. Can't you see it? Brother sitting in, can't make no money, but they come to court every day. They're billboards, right? Their clothes are billboards, right? And they need the money to pay their lawyers, right? And they billboards every day, right? Act like you know. I mean, if that's what you think, if that's your thing, right? If you're a clothing designer or something like that, you know. I don't know how you breaking no law. I mean, if you that's some news to me. Everybody got a brand name. What's your brand name? You know, like NASCAR or something, right? Pennzoil. All right. So if for some reason it doesn't get in, then it's still going to be, a mark against Brother Weinstein. He gave Sister Love a chance to clearly object, blah, 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 blah. I mean, you had Whitaker saying, just go ahead and play it. He pushed play right there. Boom, play. I mean, man, opening up too much. All right, again, thank you for being here, brothers and sisters. We're continuing to wait for sidebar. While we're waiting, just another acknowledgement with Sister Hylton not being here this week. Oh man, the defense should really be pouring it on, right? I mean, they don't have any love for love, right? They have no love for love. Then, just pour it on. Do whatever they could do to frustrate love. I mean, they're short-staffed. They were already short-staffed, right? The team is already overloaded. And you don't have Hylton this week? Oh, man. You know what I'm saying. Put the weight on it, baby. Thank you for being here. what do you think? Should Lil Woody and Sister Bumpus been doing all this conversating on the channels and social media? Should all that be happening in the midst of, should Lil Woody really have been burning it up, going all over the place in social media land and going viral several times, right? Is our understanding. I mean, it was at the proper move. He still is on the stand technically, right? He's still a sworn witness at this point. At the same time, like you look at why the 10th, that ex parte, why that was so egregious, right? Is because inside of that ex parte was not just the prosecution, but it was also a witness who had been sworn. He's on the stand. That's heavyweight stuff, So now stuff like this.
We've got a
let's see if it gets in.
resolution, and that is that we're going to take 2 minutes or so. Mr. Weinstein is going to go refresh his recollection by watching the TikTok himself. And then he represents that there are really only about 10 seconds that are relevant. It is one question by Ms. Bumpus and one gesture and short answer by Mr. Copeland. He's going to make himself a written record of what that actually says, and he's going to proffer that. So we'll take a quick break and allow him to do that. Then he can come back and put a more detailed, specific proffer on the record, and we'll go from there. All right, so we're in recess again.
All right, so he missed it. So, many times, Brother Weinstein has come through in the clutch, right? I mean, we've seen that, he's Diesel, but he blew that one. Tactically blew that one, man. Gee whiz. Man, you don't hesitate up there like that. Now with Speedy Whitaker, now she gonna find a way to do her thing and get you down to just the 10 seconds, just that one, she gonna get you down like that to save time. Well, we just wasted how much time? That's why as soon as she said, well, just go on and play it, that's what you do, bruh. Push play. Ah, man, you got to read the room better than that. So again, shout out to Brother Weinstein. Normally he's got it, but right there, man, he blew that one. He opened the door. Then Love comes in. I mean, then Whitaker comes where she's going to get the transcript and she's going to read the stuff she want to read. It had nothing to do with my man's point. And, let my man even made his point yet. What has he actually been able to do? Stand there. He ain't been able to get off his real shots. It's no good. So tactically, he's not covering like he needs to cover it and making the impact he needs to make. Letting Whitaker do her thing, letting Love do her thing, and he already had it. He had it. She said, play it, then play it. Roll with it, bruh. Yeah. Okay. I mean, we don't expect Weinstein to make those types of tactical errors, so he might be able to redeem it right quick and get it all back in motion. We'll see. But that was one right there, unforced error. So we got to call it fair. We call it fair. There it is. But we'll see if he makes up for it right quick. All right, brothers and sisters, we should be able to jump back into it pretty quickly here. Thank you for being here.
Hi, Mr. Weinstein.
Thank you for giving me time to refresh my poor memory, Your Honor. So there is actually originally a YouTube video that I viewed on TikTok. And it's an interaction between Kayla Bumpus, Mr. Copeland's attorney, and Mr. Copeland.
Okay.
And there's just is this feedback a problem? Okay.
Not right now, it's not.
Okay. So anyway, I viewed this interaction. I'll go ahead and proffer to the court the exchange that I witnessed. Ms. Bumpus says, Woody, is the transcript complete? Mr. Copeland then vigorously shakes his head back and forth, indicating no. Then Kayla Bumpus says, you say no? And then Woody responds with, you know that. So that's the interaction that takes place. Your Honor, as I think maybe you indicated, and certainly as the state indicated, perhaps the better source of this is Ms. Bumpus herself. She's here. I'd like to call her to the stand and we can hear her testimony about what took place on June the 10th, 2024, during the course of that ex parte that was not recorded in the transcript, not because of anything nefarious, but it would provide, I think, better insights into.
Stop it. Stop it. Hold the press. Even better. All right. So all I'm going to say is that Weinstein, if it was a matter of turning it up and making up for that slight fumble from a few moments ago, if he gets Bumpus on the stand right now, oh yeah, he's good. It wouldn't even matter. To TikTok didn't even matter at this point. The fact that she's in the house and don't have to wait till tomorrow or the next day and all that carrying on. But if he can get her up there right now, then he's good. And we rolling. Thank you for being here.
To our position that there was Brady material June the 10th that was not captured in the transcript and not provided to us.
All right, let's hear it. Ms. Bumpus coming up, and Ms. Bumpus is basically, I think, been in court all morning. Is that right? Okay, coming up and take the stand.
Sure.
So she's not only ready, but she apparently was doing her live stream thing as she requested with infamous Sylvia. So she's been there the whole time. This is, yeah. What are we watching here? What is this? What is this? Thank you for being here.
Ms. Bumpus, would you please stand and raise your right hand? Do you swear the testimony that you're about to give today is the truth, the whole truth, and nothing but the truth?
Yes.
Okay, please be seated. Would you please state your name for the record?
Kayla Bumpus.
And what is your relationship with respect to Mr. Copeland?
I previously represented him on criminal cases, but for purposes of this case, I was a stand-in attorney.
And what was your intent in representing Mr. Copeland?
To make sure that his rights were protected and to make sure that Jonathan Melnick was good to go.
All right, let's focus on the discrete issue that is before the court, okay?
Certainly. You were present in the June 10th, 2024 ex parte meeting, is that correct?
Yes.
Have you read the transcript to the ex parte meeting?
Yes.
I'm not sure if that is already an exhibit in this case, Your Honor.
It is, it's a part of the record as a transcript.
Okay.
It's been filed
All right.
in Odyssey into the case.
Okay.
So I don't think it needs to be an exhibit unless you want to make it exhibit for the purposes of this hearing, but it's in the record.
Okay. I'll just be referring to that transcript. So have you read the transcript from the June 10th ex parte meeting?
Yes.
And does that reflect everything that occurred the morning of June the 10th during the course of your meeting? I believe that was in chambers. Is that correct? That was compound.
Was that was
compound. Was that meeting in chambers? Where did that meeting take place?
In chambers.
In chambers. And was the ex parte transcript that you read a complete recording of absolutely everything that took place in chambers that morning?
No.
Could you please tell me generally, when was there a time during the course of that ex parte meeting when y'all went off of the transcript?
Clarify what you mean by that, when y'all went off.
Was there a break in the proceedings at some point on the morning of June the 10th? Multiple breaks.
Yes.
And during one of those breaks, did you have occasion to speak to Mr. Copeland with someone else, with someone from the states, the state present in the room?
Yes.
And when you...
Okay, brothers, this is thick. This is thick. So whether or not Whitaker is going to jump on this, but this gives all types of possibilities here. And then we shift from that into the possible Brady, that happens if Lil Woody said something about the Donovan Thomas. That's where this goes, right? Well, one of the places it surely goes. But keep in mind, brothers and sisters, keep in mind, Whitaker says, well, hey, let's just get Bumpus then, right? If you're going to bring her in as the person that's on the TikTok, the person that was there, and she's sitting right there, then let's bring her, right? We know she was sitting there, but okay, so she's sitting there. But keep in mind, brothers and sisters, Hylton is not there. Hylton's the other person that is in the conversation, according to the defense. She's on vacation. Hylton's not there. So how's Whitaker going to play this? So she's going to hear Bumpus say, this is what happened. You have no idea what Lil Woody's going to say. So Hylton's the one then, but she's not in the room. Thank you for being here. It's getting thick.
Had that conversation that was off the record, that was without the transcript being transcribed.
Yes.
Let's clarify who is in the room at
Yes.
this point in time.
Okay. Who is in the room? And again, let me just make clear on this. I only want you to speak about conversations that you had with Mr. Copeland that are not privileged, where, for example, someone from the state was in the room. Do you understand?
For sure.
Okay. When there was a portion of that meeting that was not recorded on transcript, who was in the room?
Myself, Mr. Copeland, and Simone Hylton.
Who else, if
Um,
anyone?
I don't know all the deputies.
But were there deputies in the room as well?
Yes.
Do you remember how many?
4.
Okay. Anyone else other than the deputies and the 3 people you just named?
Investigator Hamilton and maybe another investigator from the state.
Okay. Approximately how long was that?
Hang on a second. Was the court reporter in the room?
I don't know. I don't recall. I can't remember.
And at what point during the meeting did this allegedly occur?
Towards the end.
If you had a copy of the transcript in front of you, could you show me where? Like, if
I
you,
could get close, Judge.
okay. Do you have a copy for her?
I don't have, does anyone have a copy? I do not have a copy
Mine just
printed out.
disappeared. I don't know where mine went.
Max, do you have one?
I don't mind passing up, but it does have notes.
Maybe not. Let's get a clean copy.
Okay.
What had just occurred and then what occurred following it? What had just occurred prior to?
What had just occurred was we have been meeting.
I think that's an unfair question. That's, if you're going to allow her, see, that's that Speedy crap again. That's that extra Speedy Whitaker junk. I don't like that. It was cool if you say, hey, if you have a transcript in front of you, then can you look through the transcript? I mean, this, what I'm saying, that's already stretching your memory. Be like, okay, well, I can look through it. And she said, I can get close. She just said she can get close if she's reading, if she's looking at the transcript. Now, because you're in such a rush and nobody seems to have a clean copy of the transcript within 2 seconds and you don't know where yours is, now all of a sudden you're going to ask her to just tell you, which basically exposes her, right? If she can't remember. Now she has no transcript because you can't wait 2 seconds to get a transcript. Now she said she could get close with it. With it, said she can get close. Now all of a sudden she got to just remember. Well, what was going on before and after? That's that Speedy stuff. That wasn't fair to Bumpus to do her like that. Speedy, Speedy, Speedy. Thank you for being here. Get that girl a transcript and then see if she can get close like she said. We ain't even got to go through this extra stuff that can get her fumbled up and this, that, and the other. Well, that's not fair. That's not fair. Judge, you ain't even the one supposed to be asking the questions anyway right now.
Even for a really long time, and I needed to go to the bathroom because I was stressed out. And
Okay.
when I went outside in the hallway, Simone was outside in the hallway, so I guess she didn't want to be in the room with Mr. Copeland while I stepped out. That's all I can think of. So she was outside. She met me in the hallway, and she said,
Okay, hang on before you get into what anybody said. So y'all are in chambers. Like, paint the picture for me. You're in chambers, and then and what happens for you to then leave chambers to go to the restroom?
I needed a break.
Okay, and so you leave chambers.
Yes.
And Miss Hylton leaves chambers.
I don't know when she left, because when I left, she was still in there. But when I came from the bathroom, she was in the hallway.
Okay, when you left chambers to go to the restroom, who was in chambers at the time that you left?
Mr. Copeland, the deputies that were with him, about 4, Miss Hylton, the investigators from the DA's office, the judge, and the court reporter.
Okay, so you took a bathroom break.
Yes.
And as far as you know.
Okay, brothers, sisters, well, that's a problem. Because if the court, meaning Glanville, is in chambers and the reporter is there, Miss Weaver, which is what Whitaker is hearing, and Whitaker is making it clear, and she knows there's a problem now if this is true, because the transcript should have at least had Bumpus leaving and also Hylton leaving and their return. And if that was the case, when she's about to testify, that the other conversation happened later. Once she comes back, she's saying that she doesn't know if Weaver was there. So at some point, then there should also be an indication that then they left. Glanville and Weaver potentially left or not. But there's more interactions happening. So the transcript should at least signify that these people have left and come back or what have you. And none of that's there. So Whitaker is certainly picking up on that right now. Thank you for being here.
No, you left and then you have no idea when or if anybody else left. But when you came back, Miss Hylton was in the hallway.
Yes.
All right. Well, then that's not the part we're talking about.
No. Well, I think it leads up to the part we're talking about. An interaction with Miss Hylton may
Okay.
be relevant to where.
I take that back, ladies and gentlemen. She was off base. She's off base. I'm thinking Whitaker's following better than that. I take that back. Bumpus is trying to tell her, she's trying to indicate the timing of which the conversation that she's going to talk about with Hylton herself and Lil Woody happened. And she's answering what the judge asked her, since the judge wanted to rush and not just give her a transcript. So now we're getting more confusion, but it's the judge who's actually confused. This is ridiculous. All because she couldn't wait for somebody to bring up a transcript. So she asked her to tell her, basically, give her some what happened before. Give me something that was going on. So that's what she's telling you. So once she told you what happened before this happened, oh, well, that's not what we were talking about. She's answering your question. She's saying, this is how I can give you some type of time frame. The conversation that I'm going to tell you about happened once I got back from the bathroom. That's the benchmark I'm giving you. That's the timestamp I'm giving you, which was your question. So now that I've given you that, and that's not what we're talking about then. This is wild. Again, because Speedy Whitaker couldn't just wait for the transcript to get up there. Now she's confused herself. Whitaker has. It's ridiculous. I'm over here giving her credit, saying, okay, well, what she's honing in on is the fact of this is not in the transcript. There's stuff that should be in the transcript, which is the whole overall point, right? There's stuff that's notated. Stuff left out. This is what I'm giving her credit for. Like, okay, well, she hears that. Wow, apparently it's a different thing. Thank you for being here.
Where we're about to go.
All right.
Could you please describe the exchange you had with Ms. Hylton in the hallway?
So she asked me, I think I get what you're saying. I think I get what you guys are trying to say. And if he's trying to do what I think he's trying to do, then that's not going to work. And I said, well, I don't know what you're referring to, but I guess we can come back in and you could talk to him about it.
Okay. And so when you said you can come back in the room and talk with him about it, was there any further exchange in the hallway?
No.
What happened after that?
We go back in the chambers.
Excuse me, we being you and Miss Hylton.
Me and Miss Hylton.
You go back into the chambers, and then would you say again who was in the chambers when you went back in?
Well, Mr. Copeland had then went to the restroom, so it was just me and Miss Hylton in chambers, and then they bring him back in.
Did you and Miss, excuse me, I don't mean to cut you off if you hadn't finished.
No, then the same other people.
Okay, when you and Miss Hylton were in the chambers prior to Mr. Copeland returning, did you and Miss Hylton have any further conversation in the chambers?
No.
Okay, when Mr. Copeland.
Hang on. So you and Miss Hylton go back into chambers. Do you go back? I mean, chambers is, there's an anteroom where the judicial assistant sits. There's a staff attorney's office. There's the judge's office. Where are y'all? The judge's office?
Yes.
Okay. And when you and Miss Hylton go back to the judge's office, there's nobody else there but the two of you?
And probably the investigators from the state.
You don't remember?
Well, the deputies had to take Mr. Copeland.
Okay.
Yeah.
So Mr. Copeland was gone.
Yeah, he was in.
Was the court reporter there?
Yeah, she was there.
Was the judge there? If you remember.
I don't remember if he was in there.
Okay, so you and Miss Hylton have a private conversation in chambers?
No, we don't talk.
Okay, y'all just walk back in and then what happens?
And then everybody comes back in.
Okay, who is everybody?
The judge, Mr. Copeland, the 4 deputies, the 2 investigators from the state.
Okay, we're just going to take it slowly, step by step, okay?
Okay.
All right. So those individuals return. Does Judge Glanville return to the chambers?
Yes.
Is the court reporter in the chambers?
Yes.
Okay. When all of these people are in the chambers, what happens next? A step at a time.
Well, before we go any further, though, we may have a discrepancy because when she was originally telling the story, she was saying she didn't know if Weaver was in the chambers when the Hylton, Lil Woody, Bumpus conversation, the trio, right? The trio conversation is what we're going to get to. That's where supposedly the conversation about Nut came in, Brother Donovan Thomas came in. When the trio, the 3 of them were talking, Bumpus, Hylton, and Lil Woody, okay? So when she first was telling the story, she was saying she didn't know if Weaver was there, the court reporter. Now she's saying the court reporter was there. It seems like that's a discrepancy. So let's see if it gets cleared up. Thank you for being here. We appreciate you.
Simone starts talking to Mr. Copeland about what we talked about in the hallway.
What specifically did Miss Hylton tell Mr. Copeland about what happened in the hallway?
I don't remember what she said at the beginning because then she says, wait, Judge, can you step out?
Who is the she that says, wait, Judge, can you step out?
Simone Hylton.
Okay, ask the judge to step out. At that point, does the judge step out?
Yes.
Does anyone else step out?
I don't remember if the court reporter stepped out, but I know she stopped taking down what we were talking about.
Okay, and she may or may not have remained in the chambers.
Correct.
Okay.
Very
And
interesting.
so at this point, you're saying that the judge is out, you, Miss Hylton, Mr. Copeland, 4 sheriff's deputies and 2 DA investigators are in chambers.
Yes, Judge.
Okay.
Okay. Next step. What happens next?
Simone starts to talk to Mr. Copeland about, I guess this is the part about purging yourself and perjury and impeachment.
Okay. What specifically did Ms. Hylton say about purging himself?
About purging himself once he began to testify that he would purge himself of him being arrested.
Okay. What about perjury did she tell to him? Did Ms. Hylton say to Mr. Copeland?
I think some of this is on the transcript, but she reiterated the fact that pretty much she wanted him to testify. She didn't know what he was going to say, but there was one thing that they know that he didn't do that she would not allow him to testify to.
Okay. What did Ms. Hylton tell Mr. Copeland was the one thing he knew, she
All right,
knew?
let's not assume any of this because this is your witness, so don't lead her, okay?
Okay. So when you say that, what did Ms. Hylton specifically say regarding that?
Well, first, Mr. Copeland said, I can claim all of this. I can claim all of this. I might as well just say I did all of this. And she said, but we know you didn't do all of this. And specifically, we know you did not kill Donovan Thomas. And I will not allow you to get on the stand and say that you killed Donovan Thomas.
And when Ms. Hylton said, I will not allow you to get on the stand and say you killed Donovan Thomas, did she say anything else with respect to that?
Pretty much, I was explaining to Mr. Copeland about independent evidence because she said if she had any independent evidence to prove that he was lying about anything, she would just use his statement to impeach him. But she would not necessarily press charges against him for perjury. But she said that if he said this thing, this one particular thing, which was the unaliving of Donovan Thomas, that she may move forward with perjury. And Mr. Copeland says, well, it's not just about me knowing who killed him, but it's about, I know more about that infinity, and I know something about somebody who's not even on trial.
Okay, I'm going to stop you there a second because there's a lot to unpack, okay? So do I understand your testimony to be that Ms. Hylton said that she would prosecute him if he lied about the killing of Donovan Thomas, but she would not prosecute him if he lied about other things?
Yes.
Let's go back to the infinity, because I didn't catch all of that. What did Mr. Copeland say about the infinity?
You just say, I know something about the infinity that y'all don't know.
And how did Ms. Hylton respond to that?
No, I don't remember, but basically she just like, okay.
Okay. What happened next in that meeting? Oh, can I stop you a second? Had Judge Glanville re-entered the chambers where you were at this point?
No.
Okay. Please continue. What happened after the comment from Mr. Copeland about the infinity?
I think that, I mean, she really didn't say anything about it. She just kept moving forward with explaining to him about she wasn't going to go for that lie about the unaliving of Donovan Thomas, but whatever else you lie about, I'll just use it as impeachment. And that conversation went on for about 5 minutes or so, maybe a little bit more. I don't know. At this point, we've been in there for 2 hours. And they gave me a second to talk to Mr. Copeland, and then that was the end.
Okay. Who gave you a second to talk to Mr. Copeland?
I guess Simone.
Did Simone Hylton?
This unaliving thing, Bumpus is an attorney, and this is a courtroom, so she can go ahead and use the actual words. The unaliving is her new social media platform, sanitizing language, but that's not the appropriate language here. She needs to go ahead and just use the words versus unaliving. It's not a monetized situation. This is a courtroom to which she's a barred licensed attorney. So go ahead and speak the words. Just something to think about. Thank you for being here. We appreciate you.
Remain in the room while you spoke to Mr. Copeland?
Yes, but she couldn't hear what we were saying.
And why do you believe she couldn't hear what you were saying?
She couldn't, I know, because we were whispering in we scooted away from her and we just kind of whispered in each other's ear.
Okay. Is there anything else that happened during the course of this meeting where Judge Glanville was not in the room that you haven't told us this morning?
I'm not 100% sure, but I know there's one time where Adrian says something about Judge closure.
Where, I'm sorry, who?
Adrian Love.
Okay, let's stop just a second, okay? Because I want to make sure we clarify this. I believe your testimony earlier was that Ms. Love was not in the room, at least during this portion of that meeting. Is that correct?
That's correct.
Are you referring to another portion of the meeting that happened that morning?
I don't remember if he stepped out or not. I just remember at one point she said, Judge, close your ears.
I don't remember if who said,
Okay, let's go back.
yeah, that's
Okay,
very
here,
unclear.
we're going to go back and try to clarify.
Let me.
Yeah.
All right. So at the beginning of the meeting, it is Judge Glanville, Miss Love, and you,
Yes, Judge.
the court reporter, and then whomever the deputies are. Mr. Copeland is not there. Miss Hylton is not there. Is that correct?
No deputies.
Okay.
They don't come until Mr. Copeland comes.
Okay. So then it is just the judge, Miss Hylton, and you, and the court reporter, correct?
And the investigators.
The DA investigators.
Yes,
Okay.
Judge.
And so is it that portion of the transcript that you're moving to now?
Yes.
Okay. All right.
And what did Ms. Love say?
I just remember her saying something about Judge, close your ears. And I can't remember if he steps out then for a second or not, but that would be the only other time I remember him stepping out.
What did Ms. Love say after Ms. Love said, Judge, close your ears?
I don't remember.
You don't remember? Okay. So we've discussed that one portion of the morning where the judge was not in the chambers. Was there another time that morning, other than that one time we've been discussing, was there another time that morning where the judge was not in the chambers, but there was a conversation among you, Mr. Copeland, and someone from the prosecutor's team?
No.
Okay, that's the only time.
Yes.
Okay, I don't have any further questions.
All right. Does any other defense attorney have questions for Ms. Bumpus? And we have a copy of the transcript now if anybody needs it. A clean copy. Yeah. It's sitting right up here.
Oh, I'm sorry. I didn't.
Go ahead, Mr. Steele.
Thank you, Your Honor. Good morning.
Good morning.
Counselor, was there a time in your presence that you heard someone give a direction for the sheriff deputies to shut off their body-worn cameras?
Absolutely.
Do you know who gave that direction?
Deputy Brown.
And do you know at what period of time or what point in time it occurred? Were you alone with your client? Was it throughout the whole time? Were you with Ms. Hylton? What was going on when you heard that?
That was the first thing he said when the deputies brought Mr. Copeland in.
So as far as you know, I'm not saying the sheriff deputies filed that order, but they were ordered to turn off all body-worn cameras as far as you were concerned.
Yes.
And this conversation that you just relayed to us with Ms. Hylton, you and Mr. Copeland, your client, was that a calm conversation? Was it heated? How would you describe?
We had been in there for 2 hours. It was a high level of emotional tension, if that's a thing.
Okay, were people getting louder than we're speaking now?
Yes,
And who was that person or people?
Simone.
Okay. And when you were talking about Mr. Copeland not being permitted to take responsibility for the killing of Mr. Thomas, you know what I'm referring to?
Yes,
Did Mr. Copeland in any way take responsibility for that killing that day to Miss Hylton?
pretty much. He just said, you don't know what I did or didn't do.
Okay. And that was said to the prosecutor about the killing of Donovan Thomas?
Yes,
Do you know if you saw Miss Hylton taking any notes or recording the meeting, or any of the people with her recording this meeting or taking notes?
I'm not aware.
It says, and the court just gave a transcript, I don't know where it is, but you can look at it. No one's trying to trick you. It says on page 40, towards the bottom, it's the Honorable
Yes.
Judge.
It's fine.
If you need to look at it, if you don't need to look at it, that's fine. Just let the record reflect. It should be on page 40. If you need it, it's June 10th. It should be 2024 ex parte conference that you were part of. And Judge Glanville says something to the effect, I'm not looking at, this is not a quote, but it appears to be to Mr. Copeland. Do you remember when Mr. Love told you that as long as you don't tell a bold-faced whopper, something like that? Do you see that?
Yes,
Can you just, so the court, unless the court has it in front of her, what line
I've got
that
it in
is?
front of me.
Do you know what line that is? Or it begins on?
12.
Okay.
Well, 9, but 12 specifically, which it's referencing to.
I couldn't hear the last part.
9 is when he starts talking, but 12 is when he gets into that part.
He being Judge Glanville.
Yes.
Okay. And what information do you have that Ms. Love spoke with Mr. Copeland about the bald-faced whopper?
What do you mean?
I'm sorry. Can you ask that again? Well,
Yeah.
apparently Ms. Bumpus didn't understand it any better than I did.
Yes. Do you have any information to educate us on when Ms. Love spoke with Mr. Copeland about you can't make a bald face, whatever it says, whopper?
Your Honor, I want-
Hang on just a second. Yes, Ms. Love.
My objection is that the question itself assumes a fact that has not been established.
Sustained.
Read what it says if you don't mind. Since it's
Tell me
in
what
there.
page we're on again.
40.
Okay. Thank you.
The state can still give you immunity. They can give immunity to whoever they want, okay? And they can make that choice. I don't even make that choice. So if they, like I said earlier, they want your testimony, they figure it's that the jury needs to hear what you have to say, good, bad, or indifferent. And what Ms. Hylton is telling you is just the truth as you know it. And let her worry about, I mean, even though you may have said different versions of whatever, that's for impeachment. That's not going to get you in trouble. What will get you in trouble is you just invoking your First Amendment privilege because you've been given immunity. Or as Ms. Love said this morning, remember, Ms. Love said, if you overtly lie about something, like if you tell a bold-faced whopper, then they can indict you on that particular charge. I mean, that particular false statement.
That part you said about, you remember earlier this morning, Ms. Love telling you about the bold-faced whopper. That's what I'm focused on. Can you tell us, were you present when Ms. Love spoke with Mr.
Objection,
Copeland
Your
that
Honor.
morning?
What's your basis?
Again, assuming facts that have not been established. The question, I believe, was, were you present when Ms. Love spoke with Mr. Copeland?
Okay, so I think that's based on the fact that what was just read out was read out. So I don't know that Judge Glanville's statement establishes that, but that's why he's asking it. So I'm going to permit him to ask that, and she can keeping in mind that that doesn't establish that it occurred. Ask it as a more conditional question, I guess.
Do you have any information how that came about, if it occurred at all?
So the meeting was really long and a lot happened. I can't remember if Miss Love was ever in the room at the same time as Mr. Copeland. So I don't remember them being in the room together. And if they were, they did not have any communication.
Okay. All right. Do you remember in that transcript, I have to get you the page if you don't remember, Judge Glanville handing something to you for Mr. Copeland?
Absolutely.
Can you tell this court what that was?
Which time?
Every time. So go one at a time.
So the first time, I believe he handed me a copy of the immunity order.
Okay.
And the second time, he handed me 2 statutes, one on perjury, and I think the other either on impeachment or, yeah, I think that's what it was.
Okay. Any questions, written out questions you remember being handed to you or Mr. Copeland? District Attorney's questions, was that given to Mr. Copeland?
No,
Okay, you remember that discussion?
no.
All right. I don't have any other questions. Thank you. Thank you,
All
Your
right.
Honor.
Any other defense attorney have questions for Ms. Bumpus? Okay.
Good morning, Ms. Bumpus.
Good morning.
Counselor, I want to take you back to that Monday, June 10th, 2024. When you arrived for court that day, you were arriving to represent Mr. Copeland, correct?
Yes.
As a witness.
Yes.
Okay. And where did you go when you entered the courthouse?
I came right here.
To this courtroom 1C?
Yes.
Okay. Did you ever request an ex parte meeting with the judge?
No.
To your knowledge, did Mr. Copeland ever request an ex parte meeting with the judge?
No.
Okay. How did this meeting come about?
I was down here and when I got here, the courtroom was closed. There was no one here. And so I contacted Mr. Chamberlain and he came down. He told me to call him when I got in the courthouse. So I called him when I got in the courthouse and I was right here. And he came down and got me, took me upstairs.
Okay. Were you ever told why you were going upstairs?
I was never told why I was going upstairs, but once I got upstairs, I thought I was upstairs because that was the only place I could talk to Mr. Copeland.
Okay. At what point did you realize that you were being made part of an ex parte meeting?
When Brian got up there and said it.
When what? I'm sorry. I just.
Start talking. So
Mr. Steele's there?
No, the first time I realized what had happened was when Mr. Steele made his motion in court.
Okay, so you were in.
You realize. Sorry, ladies and gentlemen. Oh man. Okay. Brothers and sisters, I apologize. I just want my people to be better, sharper. You know, I want that for my people. That's all I can say. Okay, yes. This is what this is. This is an attorney. This is an attorney who basically it would appear is about to let you know that she was so stressed out. There was just so much going on. She's about to say that basically she didn't realize even where she was and what was happening until maybe hours after it happened. This is what this woman, brothers and sisters, it would appear that this woman is about to let the world know that because she was so stressed out that even though she was in the meeting representing her client, did you hear what I said? representing her client. She didn't even realize where she was representing her client. She didn't even realize it was an ex parte until later when Brother Steele was saying, hey, we've got knowledge that something happened earlier today. And she's saying that once she heard him say, wait a minute, we upon information and belief, there was some type of meeting that happened earlier today, that she's somehow snapped back to reality. And it just occurred to her, wait a minute, I was in a meeting earlier today. Yeah, brothers and sisters. We got to do better. We got to do better. Thank you for being here.
In chambers with Judge Glanville and Miss Hylton. And Miss Love, correct?
What I'm saying is,
You answer the question that I am asking you. You were in chambers with Miss Hylton and the judge. I'm sorry. There are two different parts to this ex parte. You were in chambers with Miss Love and the judge and a court reporter, and y'all had conversations, correct?
yes,
Okay. And you were aware prior to that morning that this case was being tried, correct?
yes,
Okay. And you were aware that Miss Love was a member of the prosecution team, right?
yes,
And that Judge Glanville was the presiding judge at the time.
yes,
And that there were defense attorneys on the other side of the case, right?
yes,
Okay. And so when you went into the meeting, you could see that there were no defense attorneys present, right?
no, but what I'm saying is, I didn't know I was going into a meeting.
Ma'am, I understand. Answer the question I asked you. You could see at that point in time that there were no defense attorneys present in the chambers, correct?
Yes,
Okay. So at that point in time, you knew this is a meeting with the prosecution and the judge and no defense attorneys, right?
what I'm saying is,
Ma'am, answer the question I am asking you.
I didn't realize it was a meeting.
Okay. So at the point when people started talking, let's call it a meeting at that point in time. Okay.
Okay.
And so you knew that the defense attorneys weren't there then, right?
Yes.
Okay. And so you knew it was an ex parte. If you knew the term ex parte.
Yes, I know.
Okay. Go ahead.
And in the meeting, who initiated the conversation about the purpose of the meeting? Was it you?
No.
Okay, who was it?
All right. Let me ask y'all a question. I can read what's in the transcript. So unless there's, something that we're saying occurred before, the court reporter said, okay, I'm ready whenever y'all are. I don't need an exposition of who said what. I can see it. Okay.
Okay. I have no further questions.
All right. Ms. Matthews.
Ms. Bumpus, good morning.
Good morning.
Just a few questions for you. At any time during the meeting that took place between the court, the prosecutor, yourself, Mr. Copeland, were you ever told by the court not to disclose any of the contents of the meeting?
All right. We are not going to replow the issue of Mr. Steele being held in contempt. That is moot. So to the extent that this is going to that, move on.
Okay, that's where I was going.
All right.
Thank you. No question.
Anybody else?
Well, Speedy Whitaker jumped all over Sister Kayla, so we didn't get a chance for her to do the incredible that she was going to do, to explain why she didn't know that it was an ex parte. So Speedy Whitaker did not allow her to even voice the ridiculousness that was coming. But, it is what it is, brothers and sisters. If you check out her, speaking of Sister Bumpus, she's on record, social media, even saying that she had to spend money and go get a massage after this and go and go to some high price hotel after this just to calm down, So she had to do all of that because she was so stressed out. So, but the fact that she was actually going to say this in court, but she's on record saying that, brothers and sisters, that ex parte, that meeting had her just so, or she had to spend a whole bunch of money and go to a very fancy hotel and get a massage, and she had to do all that because she was just so stressed out after this meeting. She said it. It's on record. But she was going to say it as part of her testimony that she just didn't even realize that there was just so much going on. Didn't even realize that there was an ex parte until Brian, as she said, brought it up. Speedy Whitaker strikes again, though, and jumps all over the testimony, so we didn't get a chance to hear it all. And she jumps all over what Sharp was going to try to do, so that shut that down. She jumped all over what Matthew's about to do, so that shut that down. So now that she shut these things down, where are we? Thank you for being here.
From the defense team side. Okay. Ms. Love, do you have questions for Ms. Bumpus?
A few, Judge, just a few. Thank you. Ms. Bumpus, you were asked by, I believe, Mr. Steele, whether Judge Glanville ever handed Mr. Copeland anything. Do you remember being asked that question?
No.
Okay. Do you recall telling Mr. Steele or Mr. Shard or either member of the defense team this morning that in the June 10th hearing, Judge Glanville handed you a statute on perjury?
Can you say that again?
Do you recall testifying earlier that during the June 10th hearing, Judge Glanville handed you a copy of the perjury statute?
You can correct me if I'm wrong, but
This is going to be interesting because this is an emotional thing for both of them, right? So, but I think Love has the upper hand clearly in this situation right here, emotionally, and she's in the power position. So Bumpus, her credibility may be at stake right now, and Love may be able to expose something if there's something there that's inconsistent. The fact that Love is reading, which means she's prepared a line of questioning, she and or Brother Atkins right there, right? She's reading questions right now in real time, right? She's reading questions. So she's in a much stronger position, and Kayla is clearly not a fan of pressure. And Love, if she's given a chance right now, and if she's prepared enough, she can bring a whole lot of it right now. Kayla's got the stream thing happening. She's got people watching. She's trying to build a fan base. She's got Whitaker, who just snapped her down and snapped the other cats down. There's a lot going on right now. So let's see how Kayla handles it, and whether or not Love is prepared to really press, and whether Whitaker really let her do it. But if so, there may be a credibility issue that gets exposed, if there is one. If. What do you think? We appreciate you being here. Thank you for being here. Let's roll.
I thought the question was, did he hand it to me to give to Mr. Copeland?
Do you recall testifying that Judge Glanville handed you a copy of the perjury statute? Or better yet, let me do this. Did Judge Glanville give to you a copy of the perjury statute?
And said, hand this to Mr. Copeland? Yes.
Okay. And did Judge Glanville give to you a copy of the immunity statute?
And said, hand this to Mr. Copeland? Yes.
All right. And when you responded, let me back up. So do you not recall being asked in this courtroom today, did Judge Glanville ever give to Mr. Copeland anything?
I don't recall.
Okay. Do you recall what you were asked do you recall testifying that Judge Glanville gave you both a perjury statute, copy of that, and a copy of the immunity statute?
Yes.
Okay. Do you recall what question you were answering when you made those statements?
The question that I was answering was, did Judge Glanville give me something hand me a statute or hand me anything in a meeting.
And you don't recall him asking whether Judge Glanville handed Mr. Copeland anything?
Objection as to the answer.
Yes, thank you.
I mean, I'm not sure we've got a clear answer on it, but does it matter?
If she, there's a reason that I'm asking the
All
question.
right, well, go ahead. You can ask it again because I don't think anybody's clear on it yet.
Do you recall being asked today whether Judge Glanville ever handed Mr. Copeland anything?
I believe that I just stated that he handed me two things.
Ms. Bumpus, I don't think she's asking you about what happened. I think she's, for some reason, asking you about the question that was asked to you on direct.
Do you recall being asked if Judge Glanville gave Mr. Copeland anything?
I don't recall.
Okay. At the time that you were called to the meeting, you already knew that Mr. Copeland had been granted immunity, correct?
Incorrect.
Okay. At the time that you assumed representation of Mr. Copeland, you were aware that he had been arrested, though, right? You knew that Mr. Copeland had been arrested.
No.
Okay. At the time that Mr. Melnick spoke with you about standing in his stead on that Monday morning, did you learn during that conversation with Mr. Melnick that Mr. Copeland had been arrested?
No.
At what point did you learn that Mr. Copeland had been arrested?
After he had been arrested.
Was that before or after the Monday morning meeting?
Objection, Your Honor. You asked us to just focus on the content of that meeting. You asked me to not get far from that, and we're far from that.
Your Honor?
Yeah, what does this have to do with whether or not some off-the-record discussion that Ms. Hylton was privy to occurred?
Your Honor, the reason I was asking about the giving to Ms. Bumpus the statutes is that my understanding is that at the time that she was called to represent Mr. Copeland, she was not familiar with certain statutes.
Okay, well, maybe, maybe not, but that's not relevant to what we're trying to figure out here.
And so to the extent that she was asked by the defense whether Judge Glanville gave to Mr. Copeland anything, and she then responded, he gave it to me.
All right, I don't recall. I'm sorry, go ahead. Go ahead.
I was establishing the reason he would have given her that, and I was establishing further the extent of the questions that I had for her dealt with her understanding of her responsibilities. And then finally, I was going to ask her, she'd already testified to my memory that she doesn't recall this counselor ever being in the room with Mr. Copeland, and if there was no communication.
Okay.
So I was going to.
That part seems relevant. You can ask about that.
Miss Bumpus. Do you have any memory of Miss Hylton and me being in the room while you were in the room with Mr. Copeland?
I have some memory of all of us being in the room for a very brief moment of time.
When you say all of us, who is all of us?
You just asked me, do I have any memory of you, Ms. Hylton, and Mr. Copeland being in the room? I remember at one point you came back, but I can't remember exactly what happened while you were there.
Is it your recollection that I was there when Mr. Copeland first came into the room?
No.
And when you say you remember that I came back, where is it that you're remembering that I came back to?
Either, I don't remember. Maybe it's when Miss Hylton came back. But at one point, all three of us were in the room.
Who's all three of us?
Me, Miss Hylton, and Miss Love.
In chambers.
In chambers.
Was Mr. Copeland in the room?
I don't remember. I just said I don't remember. Well,
I mean, it's kind of important. We're relying on your memory for certain things, so. Were there deputies in the room then?
What I'm saying is that if Mr. Copeland was ever in the room with Adrian Love, then it wasn't a long, extended amount of time, and I don't think there was any communication. I remember that Simone left, and it was just me, Adrian Love, and the judge and the court reporter.
All right, so your recollection is that at the beginning of the meeting, before Mr. Copeland ever arrived for the first, when he ever arrived with the deputies, that there was a point in time when the judge, Miss Love, Miss Hylton, and you were in chambers?
There was a point in time where Miss Love and Miss Hylton were in chambers with me. I cannot affirmatively state whether Mr. Copeland was there or not, but there was at least 2 minutes of us all being there together.
Did y'all have any conversation at that time?
I can't recall because Miss Hylton was doing all of the talking. I honestly believe it was when Miss Hylton left at the beginning, when we first got in chambers, when we were in not the judge's office, but all of us were there.
Antechambers, like outside of chambers, but inside of the door.
Yes.
Who is all of us?
Simone Hylton, Adrian Love, me, Investigator Hamilton. Mr. Chamberlain was in and out. The judge was in and out talking to us, and that was it.
In and out talking to you about anything substantive?
No, Judge.
Okay. All right, so y'all are all out where the JA, the judicial assistant, sits. At first, okay, we'll call that the antechambers. ANTE chambers. So when is it that any of you go back into Judge Glanville's actual chambers, his office?
Adrian Love says, Judge, can we talk to you for a second in chambers?
Okay, and who goes then?
Just me, her, Adrian Love, and Judge Glanville and the court reporter.
Okay. Go ahead, Ms. Love, if you had anything else.
Thank you. Ms. Bumpus, there were investigators present or no? When you, me, Judge, the court reporter first went back?
I can't remember.
Do you recall a comment from either the court reporter or the judge just joking about the fact that I'm not allowed to go anywhere without the investigators?
No.
And when you say that we went into the chambers, you, me, the court reporter, Judge Glanville, was Judge Glanville's deputy there?
Yes. I guess if he's a deputy, I don't know.
Which person was there for Judge Glanville? Which sheriff's office personnel? Do you remember?
No.
And where was that person situated when you, me, Judge Glanville, the court reporter went into the chambers?
I have no idea.
That person was in chambers with the 4 of us, 5 of us?
I don't remember. At some points, I don't remember about when he was walking in and out.
Okay. And by that, by he, you mean a sheriff's office personnel?
If he's a sheriff's, I don't know what he is.
Do you remember, do you have any memory of the investigator being present with me while I was in there?
I don't remember. I know there were investigators there. I don't remember if they came in chambers when you came in or after Ms. Hylton came in.
And seeing the transcript, does it do anything to refresh your memory about who all was there?
No.
Okay. And when you testified earlier that at some point after I left the first time, that Simone, me, and you ended up in a room together in chambers. Do you recall testifying that way to the court? Just earlier today?
Yes, at one point, me, you, and Simone were in chambers together. Like I said, it was a brief moment, and I don't remember you saying anything.
But that was, are you saying that now that was after I left the first time?
I really don't remember.
Okay. So your memory, you know that at some point you, me, and Simone are in chambers together. You cannot recall whether after I left the first time I ever came back.
I cannot recall.
Okay. And when you said, let me ask you just this pointed question. Did Kenneth Copeland ever say, I killed Nut while to Simone Hylton while you were in there?
Can you ask the question again?
Did Kenneth Copeland ever say to Simone Hylton, I killed Nut?
No.
Did Kenneth Copeland ever say to Simone Hylton, I killed Donovan Thomas?
No.
Did Kenneth Copeland ever say that he killed anybody to Simone Hylton?
No.
Did he say any of those three things in Simone Hylton's presence and hearing, to your knowledge?
Can I answer that with a non-yes or no question, Judge?
With a what?
With an explanation, because he didn't say yes, or he did not say I killed, but he said, you cannot tell me what I did or did not do.
Okay. That's the extent that he said?
Yes.
Okay.
When you spoke about someone asking the sheriff to turn off their body cameras, was that Miss Hylton? Did you say Miss Hylton told the sheriffs to turn off their body cameras? Did I hear that wrong?
You heard that absolutely wrong.
Please tell me who it was.
I clearly said Deputy Brown.
Thank you. Thank you for clearing that.
You're welcome.
Do you recall what was being talked about when Deputy Brown told the sheriff's deputies to turn off their body cameras?
Nothing. That was the first thing that he said when he walked in the room.
And at that point, was Ms. Hylton, you, Mr. Copeland, judge, court reporter, and DA's office investigators all present in the room?
I don't remember who was in the room. It may have just been me.
So it may have just been you when Deputy Brown said to the sheriff's deputies, turn off your cameras?
I don't remember exactly who was sitting in the courtroom.
But that's
in the
chambers, but that's possible?
It is possible.
It's possible it might have been when you and Mr. Copeland were just in there together?
It wasn't.
Well, Mr. Copeland had to have been in there, right? Because you said the deputies didn't show up until Mr. Copeland arrived.
No, what I'm saying, Judge, is that was the order as he walked in.
Right, but what did you say might have just happened when it was just you?
Nothing. I was saying I may have been the only one sitting there. I can't remember, but there wasn't like, oh, step out. It's as soon as they walked in, this is what was said as Mr. Copeland was walking in.
And was there any, did you request at that point that they brought him in to have a private meeting with your client at the time?
At that moment, I hadn't requested anything.
Is it safe to say you don't know why they were told to turn off the body on him?
That is correct.
Okay. Did you ever hear anyone from the state ask the deputies to have those body worn cameras turned off?
No.
You testified earlier that Mr. Copeland said something akin to, I can claim all of this. Did I hear you right?
Yes.
Okay. And who was he talking to? And
Simone.
okay. And did you know, or did he ever make clear what all of this was that he was talking about?
I believe he was referring to everything that.
Wait, that's not the question. It wasn't what do you think he meant? It was, did he ever make clear?
He said everything in this case.
He said the words, everything in this case?
I don't know if those were his words verbatim, but that's what he said.
Was the court reporter there when that happened?
I don't know. This was an off the record conversation.
Okay, so it was off the, so when what about his words? What words did he say that makes you now say that's what he said if you don't remember exactly how he put it?
I said I don't remember his words verbatim,
Right.
but I was there and he said, I can claim all of this. I can take all of this. That's what we were talking about. We were talking about this case.
Okay. Is what you just testified to the extent of the words that Mr. Copeland spoke regarding claiming something?
Can you repeat the question?
Yes, ma'am. It's what you just testified about, the extent of the words Mr. Copeland spoke about claiming something.
I don't want to say that is a complete lead to the extent because he said it over and over. He said it various ways. He changed the way he said it.
Do you recall what specifically was being discussed at each of the points that he said that? Specifically.
Overruled.
Specifically, not generally, not broadly, specifically what was being discussed at each of the points where he said, I can claim all of this.
The whole conversation was about Donovan Thomas's unaliving.
Are you familiar with any of the shootings that occurred after Donovan Thomas was killed?
No.
Okay. Are you aware or are you familiar with any allegations about any retaliatory events that occurred that the state considers a part of the Donovan Thomas shooting?
No.
At what point, what was being asked of Mr. Copeland when he made the statement that you testified, it's not just about me knowing that, it's about who was in the infinity? At what was being asked of him when he said something like that?
Nothing was being asked of him.
Okay. Did he just sort of blurt it out on his own?
Yes.
Okay.
And what he said was, I know something about that infinity that y'all don't know. And it got something to do with somebody who's not even on the case.
Okay. Did he ever make clear what it was that he knew? To Ms. Hylton in your presence?
He wasn't given the opportunity to.
But what do you mean?
She continued to talk about what she was talking about.
Okay. Did she ever tell him, don't talk to me about that?
No.
Did you ever hear him sort of interrupt her at any other time, at any time?
The whole conversation was them interrupting each other.
Okay. So did he ever interrupt her to give her more information or to tell her what it was about the infinity that he knew?
No.
When you said, Adrian said, Judge, close your ears. Did you mean to say Adrian said, Judge, close your ears?
You?
Yeah.
Yeah, you.
Okay. At what point are you alleging, are you saying, does your memory tell you that I told the judge to close his ears?
I don't really remember exactly what was saying. I don't know if it was you and Simone in there, but something about, we were having a conversation, me, you, and Ms. Hylton were having a conversation about, I don't remember what we were talking about. And you said it, and then you said, Judge, close your ears.
And what did I say after I said, Judge, close your ears?
I don't remember.
All right, so then it's now your recollection that there was a point in time when you, Miss Love, Miss Hylton, and the judge were in there and Miss Love was talking.
Judge, I've said that she never talked while Mr. Copeland was in the room.
Okay, and you don't even remember really whether she was in there or not when Mr. Copeland was in the room?
If she was,
She, Miss Love.
It was very brief, but no.
Okay, but you said before, I thought, that there was maybe a 2-minute time when you, Miss Hylton, and Miss Love were in a room together.
Yes, that's what I'm referring to.
Okay, so that was in front of also Judge Glanville? Because you just said it was, so I'm trying to get clarity.
Okay, so again, Love to me is in the power position. If she's allowed to continue to explore, there are some credibility issues that she thinks she can exploit, and she may be able to get there if there are indeed some things to exploit. Like right now, what did you remember? Well, it's actually in the transcript, that part right there that she said to Whitaker, as far as, you may not want to, close your ears right now. You know what I mean? So that's actually even in the transcript. So Love is digging, like, but what did you remember? Right? She's looking to find inconsistencies, but Speedy Whitaker interrupting right there, she was off base. So Sister Kayla making the statement that she made and the judge jumping on it like, oh, so now you're saying that? No, that's not what she's saying. So Whitaker was off base on that point. It's clear that happened before Lil Woody even came. That's in the transcript. So she's not being inconsistent about that. Whitaker was just off base. But what is interesting is if given the room and if there's something there, I think Love is still the favorite in this situation to exploit it. She's her emotions, Love that is, her emotions are under control. She's in a power position and she's driving forward, and Kayla should, she could break. She could break. If there's something there. If there's nothing there, she could still come across the wrong way. So we'll see what Whitaker allows to happen and how far Love is given the latitude to push.
Here's the clarity. He wasn't at the table with us as normal. He was turned around on his computer, but still inside of his office.
Okay. So when did this occur during, we have the beginning of the ex parte being Miss Love, all of y'all are standing outside in the ante room, and Miss Love says, Judge, can we talk to you for a minute, or something to that effect? And then who all gets up and goes into Judge Glanville's chambers?
Simone has left to go to do something at that point. So it's just me and Adrian Love.
Okay, and who else?
And the court reporter. And she says maybe her investigator. I can't remember.
Okay. And so the three of you talk for some amount of time,
yes.
The three of you being Miss Bumpus, you, Miss Love, and Judge Glanville?
Yes.
All right. And then tell me when that changes and it becomes more or fewer of you in that room.
The first person to join us is Simone when she comes back from court.
Okay. And is that at the same time that essentially the same time that Mr. Copeland also joins you?
Maybe within a minute or so. They don't come in like at the exact.
Okay. So they come in essentially together. And where's Miss Love at that point?
She leaves when Miss Hylton comes, but she does stay for, like I said, there's a brief conversation with me, Miss Hylton, and the judge.
And the judge?
Well, in the judge's chambers. The judge is
okay.
not.
With you, Miss Hylton, Miss Love, but it's not a part of the proceedings yet because the judge didn't even pay attention. He's over there working on his computer.
Yes.
What do y'all say at that point in time?
I don't remember what the conversation.
Anything of substance?
It was about maybe plea deals. I remember she said to me.
She who?
Adrian Love.
Okay.
She says you know, which I can't forget this, is I don't know who's worse, you or Jacoby.
What?
That was the thing. That was the nature of the conversation.
I say that again.
She said, she tells me she doesn't know who's worse, me or Jacoby.
Me or Jacoby?
Yeah.
Jacoby Hudson?
Yes.
What does that have to do with anything?
I don't know.
It has nothing to do with this case.
No, that's what we're talking about. You asked me what we were talking
Okay,
about.
so something that had nothing to do with this case.
And then something comes up about, I don't know if it's plea deals. I don't know. It was something about this case where she says, Judge, close your ears.
Okay. So this is before y'all kind of gone back on the record. The judge isn't paying attention anyway. He's in the room, but he's over at his computer. Y'all are over at his conference table. Is that what your recollection is?
Yes.
Y'all are talking about entirely other things. And then
I wouldn't say entirely other things, but we're not talking about the Mr. Copeland.
Or the case. If you're talking about Jacoby Hudson, you're not talking about the
No,
case.
we're talking about the case. She's talking about, I guess she's talking about the reference to me hugging people. I don't know. But we were talking about the case.
Okay, anyway. And then at some point, Miss Love, to your recollection, says, Judge, close your ears because she wants to talk to you about a plea deal.
I don't know exactly I don't remember exactly what she was talking about, but it was something pertaining to the case. And
okay,
she doesn't want to talk to me about a plea deal because I'm not a defense.
Right, that wouldn't have made any sense.
But she was discussing something pertaining to the case, and she says, "Ooh, Judge, close your ears."
And how long does that conversation go on?
Like two. That's the 2 minutes I'm talking about.
Okay, and then what happens to Miss Love?
She leaves
She leaves, and then when do y'all go back on the record?
immediately.
Okay.
Well, no, I talked to Mr. Copeland for a second.
Okay, privately or, okay. And then y'all go back on the record. And then does the record reflect everything the record reflects accurately? Then whenever this conversation between you, Ms. Hylton, and Mr. Copeland allegedly occurred?
Yes.
Okay. Do you have a copy of the transcript in front of you at this point?
Yes, sure.
Can you kind of point out where this conversation allegedly occurs?
It's somewhere around page 40.
Okay.
Between 39 and 40.
Okay.
Your Honor, could I just get, if it's between 39 and 40, are there any specific lines?
Well, it was like off the record, so I wouldn't know exactly which line it starts back at.
Okay, but you had represented previously that Judge Glanville was not in the room at that point in time.
Yes, he was asked to leave.
Okay. So him being asked to leave isn't reflected. Is that right?
Let's see.
Okay. Do you remember who asked him to leave?
Miss Hylton.
Okay. And that's not on the record either?
No.
And you can't remember whether the court reporter stayed or left?
I can't remember whether she stayed or left, but she definitely stopped taking that.
Okay. All right. And when did you, sorry, Miss Love, go ahead. You know what? Go ahead. I'll save my questions.
Your Honor, I honestly defer to the court. Please continue. I have no.
All right. So after this conversation concludes, then what happens? And by this conversation, I mean the conversation you referenced that is not reflected in the record, but that takes place between you, Mr. Copeland, and Ms. Hylton. What happens after that? But if it's not in the record, it's not going to be in the record. So you just tell me from your recollection what happens after that.
That's probably towards the last 5 minutes of this meeting.
Okay.
And so we go back on the record and
so the conversation finishes. How does everybody get back in the room? And how is it that y'all go back on the record? Give me the details of that.
She just, we just finished the off the record conversation and just Simone just says everybody can come back in. And then okay, wait, Judge, I'm sorry. It's actually
Your Honor, does the court mind if I see?
Go ahead.
I would say that the conversation actually happened around page 46, 45.
45, okay. And is that conversation in fact reflected on the record?
No, but I don't know how.
I mean, so how are you sorting out, oh, it's around 45 that it occurs?
Because I try to get the conversation on the record.
What did you say? To get the conversation or to try to get the conversation on the record?
I say,
I'd like to hear it from your recollection without reference to the transcript first, okay?
I'm trying to make sure. So I just.
So Ms. Hylton says, Judge, can you leave? And at that point, do you say anything? Like, no, Judge, stay, or anything like that?
No, she already told me in the hallway that she was going to ask the judge to leave and have a conversation with him.
Okay. So show me where in the transcript y'all come back from the restroom break.
Well, you want me to, you asked me to.
Now I do want you to look
Okay,
at the
okay.
transcript, yes.
Okay, I'm sorry. You asked when, okay, I think we came back.
No, yeah, the restroom break, show me the restroom break.
See, that's not in here where me getting up. I don't know how to find that.
Okay, so the restroom break y'all take, but it isn't reflected.
Yes.
Okay. Is the restroom break after Mr. Copeland's with y'all?
Yes.
Okay. All right. And it's immediately after this restroom break that you and Ms. Hylton and Mr. Copeland have the private conversation?
Yes. And Judge, you asked me a question earlier that I didn't get to answer.
Okay, what's that?
You asked me, can I, without looking at the transcript, tell you how I tried to get it back on the record?
Yes. Can you give me a second before you answer? Because I'm looking for something in particular. All right, so y'all take a restroom break. You see Miss Hylton in the hall. Y'all walk back in. Mr. Copeland's gone because he's taking a restroom break at that point. The court reporter is there. Mr. Copeland comes back. The judge comes back. And that's when Miss Hylton says, oh, wait, Judge, go back out?
Yes.
Okay. All right, now what were you going to answer?
You asked me how did I get it back on the record?
Yeah.
So after the conversation, I say pretty much, I want to get what she just told him about what he cannot go to jail for.
Okay.
Because the whole point of the off the record conversation is he's trying to figure out, can he go to jail for lying?
Mm-hmm.
And so I'm trying to get back on the record that she says that she's not going to prosecute him for anything other than one thing.
Okay. Okay, and so y'all have had, the three of you have had this conversation. Judge is gone. You can't remember whether the court reporter's there or not, but then what happens?
That's what I'm saying. That's on page.
So then you say, I'd like to get this on the record, or?
No, we go back on the record.
Okay, so how does that occur?
No, she just says, let's go back on the record. Simone.
Ms. Hylton says, let's go back on the record.
Yes.
So you don't say, I want to get this on the record.
No, I just do my best to get it on the record when we go back on record. It's in the.
Oh, I see what you mean. You say, you don't mean, I'm really trying to get this on record. You mean Miss Hylton says, all right, let's go back on the record. And then you try to like give a rendition of what occurred.
Yes.
Okay. And that is reflected where?
On page 48.
On page 48.
Well, between 47 and 48.
Okay. All right. And does page 47 and 48 reflect the off-the-record conversation that allegedly occurred between you, Miss Hylton, and Mr. Copeland?
There's a part where I say, so he can go to jail for anything but what? Okay. And okay, page 51 specifically, I'm asking, I tell him he has to make a decision. And I ask, so if he starts testifying today, is he going home today? And then I say, but if he says he don't recall to everything, he'll be okay.
Okay.
'Cause
Okay. So, at that point, between, whatever you said, 47 and 51, y'all are back on the record, right?
yes, Judge.
Nobody's like declining to take down what you're saying.
No, Judge.
Okay. So anytime during that point in time, do you say, let the record reflect that Miss Hylton, Mr. Copeland, and I had an off-the-record conversation, and I'd like to put on the record what was said during that conversation?
No.
Okay.
And also on page 51, I say, I think, are you saying you want to get up there on the stand and say something?
Uh-huh.
And then it's no response because he just looks at me.
Okay. All right. So does 47 through whenever that last page number was, does that accurately reflect whatever was said during the alleged off-the-record conversation?
It doesn't accurately reflect, but it does. I do try to mention what we talked about, but it doesn't accurately reflect everything that we discussed.
All right. So was there something else that you discussed that you should have said, oh, and by the way, this also happened that you didn't say?
I'm confused, Judge. What do you mean that who didn't say? That
You.
Simone didn't say?
No, anybody during the alleged off-the-record conversation, when you're making this record, after y'all go back on the record, you said it still wasn't accurate. And you also said you weren't stopped from saying anything during that part. So what is it that you should have said that you didn't say?
Well, I guess the only thing that I should have said that I didn't say is that Simone said that she would not prosecute or move forward with any type of perjury if he said anything except for the unaliving of Donovan Thomas.
Okay. All right. All right. So when is it that you actually reviewed and read this transcript?
I really don't know. I think maybe around the time that I had to retain counsel, I think we reviewed it together, which I cannot tell you the exact date but somewhat,
Sometime in late June?
yeah, somewhere after 6/12.
Okay. And we all in this room know this to be the case, but you are an attorney licensed and barred to practice in Georgia, right?
Yes.
Okay. And as such, you have a duty of candor to the court.
Yes, Judge.
Okay. Is there any point in time after you read this transcript and thought to yourself, wow, that really doesn't include everything, that you brought it to this court's attention that the transcript was incomplete?
This court, well, there really was no court's attention to bring it to, because after all of that happened, it's been on recess for so long.
So you've been in court when we've been in session for the last week or two, right?
Yes.
Okay. So I was presiding at that point in time, right?
Yes.
Did you at any point bring to my attention that you believed as an officer of the court and a participant in this ex parte meeting that the transcript did not accurately reflect what occurred in that meeting?
Well, Your Honor, I did not bring it to your attention, and I honestly still would not, as an attorney, if I can answer this as an attorney, I believe that there is some value in off-the-record conversations for specific things, and it has always been my position, even in speaking with members of the defense, that as far as anything minus the off-the-record conversation, that the transcript is complete.
Okay. All right. So what is your answer then to my question?
Can you ask me again? I'm sorry.
Did you ever at any point in time bring to my attention your belief that this ex parte transcript was inaccurate because it was incomplete?
No.
Okay. Why is that?
Well, because of what I kind of just said, I don't believe that it was incomplete per se, minus the off-the-record conversation, but there are a lot of off-the-record conversations that are had that are not included in transcripts, and that's not unusual to me.
All right. So you don't actually believe it's inaccurate then?
No, I just think it's missing the off-the-record conversation. I'm not missing. I just think that the defense did not have knowledge of the off-the-record conversation. Not that it's missing from the transcript per se.
Okay. Because it was officially off the record. Is that what you mean?
Yes, Judge.
Okay. And did you ever, if it in fact occurred, did you ever object to it being off the record?
No, I didn't.
Okay. So at some point you brought it to the defense attorney's attention. Is that how you decided to deal with it?
I had a conversation with the defense attorneys. I don't want to say I brought it to them, but we just had a conversation about what happened.
All right. Ms. Love, do you have other questions for Ms. Bumpus?
Ms. Bumpus, did you tell any member of the defense about the details of the content of the off-the-record conversation that you had with Ms. Hylton on June 10th?
That I had with Ms. Hylton and Mr. Copeland? Yes.
When did you tell them?
The same day.
Did you tell them everything you remember about it?
I told them everything I remembered.
Do you remember how long after the conversation took place it was that you told them?
I don't know, maybe like an hour.
Was court in recess or was court in session when you told them?
Court was in recess.
Between the time that the conversation between you, Ms. Hylton, and Mr. Copeland ended, and the time that you told the
Brothers and sisters, there's a lot that's obviously happening here, but it would appear upon information and belief, it would appear that although she being Kayla has denied on record on other social media sites that she was not the mole, it would appear upon information and belief and the testimony that we are just now hearing as she's on the stand under oath, that within an hour of the meeting ending, the ex parte, she told the defense team everything that she knew, which would, would allegedly, possibly, potentially, MOLE Bumpus would appear to be, yes, the mole. Yes, that would appear to be what happened. Although she said she was not. So, shout out to Brother Glanville if this is true, because that's who Brother Glanville believed and said was on video tape, recorded, having conversations. Holla if you hear me. So yeah, it would appear that Brother Glanville believed it was Bumpus, and now it sounds like she's saying it was her all this time. Imagine that. Thank you for being here. We appreciate you.
Defense attorneys, all of the details you can remember about the off-the-record conversation, was court in session at any point?
I'm sorry, can you repeat that?
Was court ever in session between the time that you finished your conversation with Mr. Copeland and the time you told defense? What happened in the meeting?
Yes.
Court was in session during that hour?
Had court resumed?
Correct. Did court at any time resume from the time that you left the meeting in chambers to the time that you had the conversation with defense? Just in that moment, from chambers to conversation with defense?
Oh, no.
Court had not resumed?
No.
And when you said earlier,
I mean, because remember, we came straight down here and sat down and immediately started, so I didn't speak to anyone.
and when you were speaking earlier about when after Mr. Copeland came in and you said you weren't sure whether I was in the room, did the portion about judge close your ears occur before or after Mr. Copeland came into the room?
For sure before.
Okay. And at that point, was the court reporter taking down anything?
No.
And at that point, did the court give any indication, did the judge give any indication that he was paying attention to whatever it was?
I can't answer that.
Did he give any indication? Did you see any indication that he was paying attention?
I can't answer that.
Yeah, you can.
I don't know. I wasn't paying attention to him.
So no, as far as you know, he gave no indication. She's asking from your personal observation. Answer it as to that. That's what she's asking you.
I would have to say no, but I would also say I wasn't looking at him at all.
Do you remember Ms. Hylton at some point talking about the judge closing his ears at any time?
I don't remember.
And with looking at the transcript at all, refresh your memory.
I'm sure.
Okay. Would you take a look on page 26, line 5 of the transcript? And since it's a part of the record, read from line 2 to the end of line. Let me just ask you this. Do you see where Ms. Hylton says, Judge, you might want to close your ears?
Yes.
Did you hear that phrase or something like that said more than once in that meeting?
Yeah. Before Simone got there, I know exactly what I'm talking about. So are you in here at this point?
So my only question is, did you hear that phrase more than once in the meeting?
I can't remember if it's that exact phrase, but I heard you say something to that extent, and I heard her say that.
Okay. Were you the first person, to your knowledge, that brought to defense's attention that there was in fact a meeting in chambers?
No.
Who, do you have personal knowledge of who that person was?
No.
How then do you know that you were not the first person who brought that to their attention?
Because they asked me about the meeting.
Did they give any commentary to you that led you to believe that they knew what was said in the meeting?
Yes.
What did they tell you?
Is it true that?
Can I object to
Sure.
Defense attorneys, they thought all in all inclusive deals.
Yes, sustain. Can you be specific?
Who specifically came up to you and asked you about the meeting in chambers?
There were multiple attorneys that specifically talked to me at one time.
Would you please apprise the court of the names of those multiple attorneys?
Excuse me, objection, Your Honor. We're still far afield again of the limited subject matter that you asked me to stick to.
Your Honor, as it pertains to Brady or whatever information, I think it's quite relevant. Who knew what and when, as it relates to what was said during the meeting?
Okay, well, I don't know if it's relevant who revealed it, who revealed that a meeting occurred. Ms. Bumpus has said that essentially, if I understand you correctly, that at some point during the day immediately following the meeting, the day of the meeting, you had a conversation with some defense attorney or defense attorneys, and we can sort out who, where you relayed to them everything you knew and everything you recalled about what went on in the meeting, including the off the record conversations, right?
Yes.
Okay. You can figure out who that is now.
Thank you. Who was it? Name the attorneys that you referred to just a moment ago.
Just a moment ago with the question she asked me, Judge Whitaker?
With one eye.
Okay.
I mean, it's the same topic, right?
Okay, ask the question again.
Which attorneys by name first came up to you and asked you about the meeting?
See, Judge, that's two different questions.
Then answer the question Ms. Love asked you.
I don't recall, but I think Judge Glanville did judicial notice of me on camera. I don't recall.
No, my only question to you is who first came up to you and asked you about the meeting?
I don't recall everybody who was there.
Who do you recall?
I recall Attorney Steele and Attorney Adams. And I can't remember who was the other person.
Do you remember how many?
How many
lawyers were there when Mr. Steele and Mr. Adams came up to you an hour after the meeting and asked you about it? How many lawyers were there?
3, I think.
Okay. Do you recall seeing Mr. Sharp? Just throwing out names.
At some point.
Okay. So Mr. Sharp, Mr. Steele, and Mr. Adams, within an hour, is that accurate, of the meeting, came to you and talked to you about what happened in the meeting?
I would say yes.
Okay. Other than Mr. Sharp, anybody else you remember?
No.
And when they spoke with you, regardless of how they got it, did they share with you any details from the meeting?
Yes.
And what details did they give to you that they already had before you started talking?
Objection.
Sustained.
Okay. Last couple of questions, Judge. Ms. Bumpus, when you agreed to represent Mr. Copeland, did you, during the course of the meeting that you had in chambers, did you ask questions of the prosecutors or the judge about what the immunity statute meant or anything like that?
Yes, I asked a lot of questions because I didn't realize until the end of the meeting what was actually going on. That information wasn't given to me.
That's all.
All right. So Ms. Bumpus, you knew to show up for court that Monday because Mr. Melnick had asked you to be stand-in counsel for Mr. Copeland, right?
Yes, Judge.
Okay. Are you representing that Mr. Melnick simply said that and nothing else? He didn't give you any background about what you were walking into?
Well, what I'm representing is I was given specific instructions. And those instructions were, I'm standing in for him. If Mr. Copeland chooses to plead the fifth, which I anticipate he will do, then you won't have to do anything else. If he chooses to testify, we have agreed that he's discharging me.
Okay.
And I made that very clear to everybody multiple times that morning that that's what I was here to do.
Okay, but you had no idea that there was an immunity order in place?
No.
Okay. All right. Does anybody from the defense side have follow-up questions for Ms. Bumpus?
I have just a few, Your Honor.
Okay.
In your cross-examination, you said, quote, "She said she is not going to prosecute him for anything other than that one thing," unquote. What is that one thing?
I can't answer that. I can only assume it would be the unaliving of Donovan Thomas, but those are the words that she chose to use.
When you're saying unaliving of Donovan Thomas, what are you referring to?
I get him being killed.
During cross-examination, Ms. Love asked you about some alleged retaliatory acts. Were those being discussed when Mr. Copeland repeatedly said, "I can claim all of this, I can take all of this"?
Nothing was being discussed.
What do you mean nothing was being discussed when Mr. Copeland said, "I can claim all of this, I can take all of this"?
He said that on his own, and that's kind of how the conversation started.
What was the subject matter being referred to when he said, "I can claim all of this, I can take all of this"?
Donovan Thomas's murder.
Okay. I have no further questions.
Anybody else? While Mr. Steele's making his way up, just so I am clear on this, you're saying that or are you saying that in the off-the-record conversation that you, Mr. Copeland, and Ms. Hylton had, that Ms. Hylton told Mr. Copeland that the one thing she would prosecute him for perjury for was if he got on the stand and said that he, Mr. Copeland, was the one who killed Mr. Donovan Thomas?
Yes, Judge.
Okay, and that she would prosecute him for perjury if he said that.
I don't know if she exactly said would, but she was comparing it to things that she wouldn't.
Okay. All right.
So I guess more of a highly possible situation.
That would be the one thing that could
Judge.
get him in criminal
Yes, Judge.
perjury type trouble. Okay, thank you. Go ahead, Mr. Steele.
Thank you, Your Honor. I just want to do timing or sequencing you were asked about. When you left Judge Glanville's chambers after the entire, not bathroom breaks, after Mr. Copeland was removed from the chambers, et cetera, where did you go, if you remember?
I came and sat right there in the courtroom.
At that point, had you spoken with anybody to alert anyone that there was an ex parte meeting?
No.
Where did next time you saw Mr. Copeland was when? When you left the ex parte meeting, came into the courtroom?
Up here. He was up here.
Testifying where you're sitting?
Yes.
Okay. And then did the jury come in?
Yes.
And did Mr. Copeland testify before the jury?
Yes.
At any time during that moment when Mr. Copeland's testifying in front of the jury, did you tell anybody about this ex parte meeting that you attended?
No.
Or the contents?
No.
Okay. Do you remember there being a break at any point for lunch?
Yes.
Is that the first time that you were approached?
Yes.
Ex parte meeting?
Yes.
True?
Yes.
Did anybody, and that's after you were under no restraint, you told the truth?
Yes.
And that was to myself and the other people you told?
Yes.
True?
Yes.
Okay. Thank you. Thank you, Your Honor.
All right. Mr. Sharp?
Can I ask one more question?
Sure.
After the lunch break, do you remember when I raised it before Judge Glanville?
Yes.
Did I do it right away after we spoke?
Yes.
First time the court reconvened?
Yes.
Thank you.
All right, and Mr. Sharp, come on up. And speaking of a lunch break, we're way past time for hours, so let's plan to do lunch right after we wrap up this witness.
Ms. Bumpus, were you in the courtroom when Mr. Copeland was called to testify after the ex parte meeting? Were you present in the courtroom?
Yes.
Okay, did you hear the Judge Glanville, did you hear him tell anyone from the defense that an ex parte meeting had occurred?
No.
Did you hear anyone from the state tell the defense on record that an ex parte meeting had occurred?
No.
Was there any discussion about the substance of said meeting?
No.
Okay, thank you.
Anybody else? All right, thank you, Ms. Bumpus. You are excused. Let's take our lunch break. Let's come back. It's 20 till 1 right now. Let's come back at 2.
All right, brothers and sisters, we will resume around 2 o'clock. Hope you're doing well. Appreciate you being here. What do you think about what's happening so far? How did Miss Bumpus do? What's your opinion on that? Interesting. Will any of this even matter? Given that we're dealing with Speedy Whitaker, does it even matter? We appreciate you being here. Seems as if Love couldn't really get there. So, all in all, it looks like we have to say that Kayla held her own. I don't think there was a win there, but, you know, she was basically getting tag teamed by Judge and Love. You know, nobody had her completely exposed. There were some inconsistencies, but for the most part, you know, that's memory and what's in the transcript, and she didn't have it initially, and there was a lot coming at her. So we're gonna say that she muddled through. Nothing that was openly exposed that's going to seem to make a tremendous difference as far as her credibility. I don't think the judge finds her 100% credible, but I don't think the judge is looking at it to really make that much of a difference right now. So, you know, weighing that, you pretty much already have a sense from the judge. It would appear the judge is already like, yeah, well, it happened. It shouldn't have happened. Glanville's already gone. What difference does it make? Now, did Lil Woody say that he did do this? He didn't say those words. He didn't say, I did do this thing, right? He didn't say those words. So now he's saying, per Kayla, well, he, you know, alludes to it, or don't tell me you don't know what I did and didn't do, that kind of thing. But that's not a strong declaration. So now you're going to look for what? Lil Woody to give you the declaration now? Okay, but overall, to Weinstein's initial contention here, were there conversations that happened that aren't in the transcript? Yes. And by Kayla saying, well, you know, in my opinion, I didn't bring it to you because basically, you know, that's just a part of how things roll. There's all kind of times when we have off the record stuff. Yeah, that really didn't help the defense too much, you know. Also, her saying that Love was in there, but I don't think when Love was in there, she had anything to say to Woody, right? Her saying that didn't really help the defense either, you know. So there were a couple of things that she said that, you know, maybe got some cringe moments from the defense, like, you know, he was hurting us, right? Like, you know, you didn't need to add that. You didn't need to add that over there. You know, we trying to find some loopholes, and, you know, you adding stuff you ain't got to add, you know what the shot is, right? So there were a couple of those moments, but overall, really pinning her down and exposing her, and, you know, you're not telling the truth about, you know, this, we can't believe you about anything. It didn't get to that point openly. It didn't get to that point. So for that, then, you know, you come full circle, and it still is what? That the meeting was jacked up, and there's still seeming to be an allowance by Sister Hylton per their, you know, Kayla, etc., saying, no, you can lie about anything else except that. But, you know, these things have to be exposed, right? Like why it would make a difference to Whitaker. And Whitaker's not letting on that this really matters to her, that it really makes that much of a difference to her. So what do you have here? And again, if the play is just for some future appeal, man, that's a long way from now. If it even gets to that point, I mean, it's a long way from now. So the brother's going to be just sitting there, you know. That's not fair, is it? So, all right. Meanwhile, what do you think? What happened? The Melnick, she kind of dismissed that. You get Bumpus. She isn't, you know. She kind of takes the lead on that. Whitaker does, and doesn't really hammer too much. At the end of the day, there were a couple things that Brother Steele got on the record as far as the timing of it, how it happened, you know, so that keeps him, you know, his mute issue with his appeal, this whole thing with Glanville, right? And the censorship and being held in contempt and all that stuff that just kind of is under the water now. But as far as his reputation, so Melnick wanted to get some stuff on the record for his reputation. Brother Steele gonna get some stuff on the record as far as how this happened. And it does appear, you know, by him like saying, for instance, the first time he's asking Kayla to put it on the record, the first time after having this information, did I come to the court and put it on the record right after hearing it, right? When I got the information at my first opportunity, when we came back from lunch, did I put it to the court? Yes, you did. Okay. You know, so these are things that are covering other issues as far as the credibility of the attorneys and their careers. So a couple of those things got worked in. But whether or not this is really moving the needle to Whitaker, she's not letting on that it is. But it would appear, in spite of that little language that Sister Kayla's talking about, like they already knew, they came to me, it's still looking like, in spite of what she had said previously, looks like Glanville might have been right. It looks like Kayla was the mole. She was the one who gave up the information, and that would make Glanville correct, that she was the one. And there were a lot of the people who said that they thought she was the one, and she was the one who said it wasn't her. Right? So that's interesting. Now we still have that, you know, where Brother Steele was denying, you know, saying that there was some privilege as to why he wasn't going to reveal who his source was, because there was some privilege. Now, what was that privilege he's talking about then? That comes in question if Glanville was still around on this case, right? It would be like, okay, well, wait a minute. You were arguing privilege. Now, what's your privilege? Because Kayla's not your client. Lil Woody's not your client. So where's your privilege? If you got this from Kayla, then you could have told us, right or wrong. What do you think, brothers and sisters? But that's that might be a moot point again, because Glanville's not here, but it's certainly interesting, right? So when Glanville's like, you can tell me, and Steele's like, I'm not gonna tell you. But if Kayla's the mole, why can't you tell? Why can't you tell? Because it's not a privileged conversation. If, in other words, Hylton heard it. If there's some Brady, if there's information, if there's evidence that came in that can be helpful to the defense, then Woody said it, Hylton heard it, and Bumpus heard it. Okay? So where's the privilege? So again, and Brother Steele's testifying upon information and belief that Lil Woody said he did it. Kayla says he didn't say those words. I did it. I blank, 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 blank. The declarative of, this is something that happened. I did it. She didn't vouch for that. So again, we got to see how this all plays out, because there were little morsels in there that can be exploited. But as far as did it actually get exploited right there during this moment, and we can definitely see that it made a major impact on Whitaker, and she's going to somehow do something like a mistrial or something like that. There was no indication that any of those morsels, any of those possible things are truly going to get exploited and really move the needle. Okay. Let us know what you think. We appreciate being here. Make sure you hit that like button. Rhodes, dogs, and conversation. We do appreciate you. What do you say? We cool off a little while. Got lunch break till about 2 o'clock.
No, he's not. Mr. Bachman.
All right, well, in the meantime, one thing we can do that is not anything of substance that is important is I want everybody to speak into your mic and make sure each of them works all not at the same time, one at a time. And if there are any that don't work, I'm going to try to see if we can get a hold of one that does. So can we start with the state?
Yes, Sean.
All right, and I also am going to try to get a longer neck on each of these, which might help. But for the meantime, let's just see if it works at all. Mr. Weinstein.
Good afternoon, Your Honor.
Does that help at all? Did y'all? I don't know that yours works. Pull it towards you some more.
Good afternoon.
All right. Yeah, you're just going to have to get it closer.
User
to you.
error, I think, on my part.
User error. Okay.
Good afternoon, Your Honor.
Okay. Mr. Steele, does yours work?
Your Honor, is that helpful?
I think we've all got to get closer to them. And I can hear, but I've heard that other people can't hear. So
Is that okay?
that's great. Mr. Sharp.
Testing, Your Honor.
Great. And then who else is left? Misty Williams.
Good afternoon, Your Honor.
All right. Wonderful.
Good afternoon, Your Honor.
Awesome. Thank you. Okay. All right. And now we have somebody here for everybody as well. So let me cross check mics off my list. Okay. Ms. Love, was there any evidence you wanted to present or any witness you wanted to call with regard to our morning proceedings?
Your Honor, given the scope of what the court has already told us that we were looking into, I don't have any witnesses based on Ms. Bumpus's testimony. And my understanding is that it was Brady material disclosed during the June 10th, 2024 hearing in chambers.
Correct. And what she alleges was disclosed is that Mr. Copeland said, I know more about the infinity and it has to do with somebody that's not on trial. I'm paraphrasing, but.
And so the fact that.
Hang on a second.
Yes.
Yes, sir, Mr. Weinstein, you
I'm
think
sorry.
there's more to it?
I didn't mean to give you side eye, Your Honor. I do believe that there was more that she said that was disclosed other than just the infinity.
Okay, what else?
Specifically when she said that the state would not prosecute Mr. Copeland for lying except for that one thing, which she said was the murder of Donovan Thomas. I believe that was on the redirect at the very end. That actually came through more clearly than I think anything else, Your Honor.
Okay, so.
May I respond to that? So because that did not, in my mind, amount to Brady, if the court is inquiring into a different issue of.
Hang on just a second. Everybody who's got a phone on you, make sure it is on silent. And you should only have a phone on you if you are an attorney or if you have a Rule 22 that permits you to have a phone. Anybody else in here should not have a phone on them at all. If you do, it should be turned completely off.
I'm sorry, Your Honor, that was my computer.
Okay, it happened.
I
Oh, your
silenced
computer?
it.
Okay.
I silenced it.
All right, thank you. So, Ms. Love.
I was just saying that based on the parameters that the court set forth, my understanding was that anything that is alleged to have been said by Ms. Hylton in that regard does not impact whether or not Brady material was disclosed. And I'd have a different argument at the appropriate time that the court tells me is the right time to make it. But my position would be that given that defense attorneys came to Ms. Bumpus within an hour of the meeting before court went back in session and asked her, so they had information, they had, I assume, the content of whatever it is that they are alleging took place. And then Ms. Bumpus, based on what I heard her say, told them, sort of filled in the blanks. I'm using my words, not hers. And gave to them this information, my understanding of what Brady is that it is information that is not available to them by any other reasonable means. And they had someone telling them something about what was going on. So it's not a Brady violation if they had access to it. If there's a different argument, a different issue that we're going to be arguing, I'll hear that from the court. But as to the Brady violation, my argument is that based on her testimony, there was no Brady violation.
Let me add this, Your Honor, too, if I may. Also, the testimony of Mr. in the off-the-record meeting where Mr. Copeland.
The alleged off-the-record meeting.
The alleged off-the-record meeting with Mr. Copeland, to which Ms. Bumpus testified to, where Mr. Copeland allegedly said, I can claim all of this, I can take all of this over and over again, and the all of this was regarding the unliving, the murder of Donovan Thomas. I would submit that Mr. Copeland allegedly saying, I can claim all of this, I can take all of this, would also be Brady material.
And Your Honor, again, given that Ms. Bumpus is the person testifying about it today, and that Ms. Bumpus is the person that was approached by members of the defense within an hour of the meeting, that assertion made by her, though I don't agree with counsel's characterization of it, is information that is available to them. But more importantly, Your Honor, I asked Ms. Bumpus specifically what was asked right before. What she said, she understood it to mean Donovan Thomas. But I can claim all of this. My position is that it's not Brady. I can say I can claim it all too, but a hypothetical, I can. What you can do is not saying something that is.
All right, I understand your argument. So just for clarification, you said I had set parameters as to what is and isn't Brady, and
No.
I haven't set any parameters as to what is and isn't Brady. Brady is what Brady is.
I agree. No, I'm saying the parameters that I was speaking of was that you were talking about. This hearing is about whether Brady material was disclosed. And my position was that what Ms. Hylton is alleged by Ms. Bumpus to have said to Mr. Copeland would not, I don't think it would amount to Brady, but if it did, I can put up a witness about it. I just didn't think that it was necessary unless the court saw it differently than I did.
So I guess what I wanted to have us look into is whether what was alleged to have occurred, i.e. an off-the-record conversation that was between Ms. Bumpus, Mr. Copeland, and Ms. Hylton occurred, and then if so, what the substance of it was and whether it contained any Brady. So if you don't want to dispute whether it occurred, that's up to you. I'm not going to tell you how to run your case, but I think that's a part of the inquiry as well. So I don't want to mislead you about that. So if you have any evidence that you want to present to dispute whether it occurred or to give us some more, shed some more light on that subject, you're welcome to do that as well.
State calls Deputy Chief Investigator Antonio Long.
All right.
Your Honor, can I make a statement before or while Investigator Long is taking the witness stand? I am specifically objecting to the proffer of Ms. Love, always. But in addition, Ms. Love said that me and other people who represent people, God forbid, accused of these acts knew already about the ex parte meeting and what occurred and the contents therein, and that is just false. That is just false. That was not testified to by Ms. Bumpus. What she said was they knew that a meeting occurred. No one said contents.
Actually, my recollection is that I asked her specifically that question. Did you share the off the record portions as well, and that she said, yes, she did.
I agree with that. Ms. Love said that before meeting with Ms. Bumpus, that me and other lawyers or people on the defense side knew about what was said at the hearing, and that did not happen.
You know, that's totally irrelevant. So I appreciate it, but I wasn't even accepting that as any kind of a proffer of hers. But yes, so noted, and that's fine. Okay, was there anything else with regard to that? All right. So you said you weren't going to accept a proffer from Miss Love, and that's fine. You said also Miss Long. Do you mean Investigator Long or Miss Hylton, or is there a Miss Long?
Spoke, Miss Love is who I meant, but I think because Investigator Long has taken the stand, my mind may have been been with him.
Okay. And with regard to just on that topic, the earlier proffer by Miss Love that you objected to, and you said on the record, I don't ever accept any proffer from her. And I said that's up to the court. I meant it's up to the court whether I want to hear it or not. But with regard to that, and that was about Mr. Abbate, my ruling with regard to that was that's not even relevant until such point as there might be some other defense motion filed, at which point Ms. Love can call Mr. Abbate. So, okay, so call Investigator Long. Thank you.
Raise your right hand. You swear for and testimony you give the truth, the whole truth, and nothing but the truth.
Antonio Long, Antonio, last name Long, Long.
And Your Honor, before I begin, I just wanted to point out that I'd like to just make the record. I know that everyone may be familiar with Deputy Chief Long, but I'd like to ask the preliminary questions that establish who he is and where he works, with the court's permission.
Okay, that's fine, but he's going to be testifying as an expert, so let's just, cut to the chase. To the extent he's not going to be testifying as an expert right now. He's going to be a fact witness.
Yes.
Okay.
Yes.
So maybe we don't need to go through all of his background. All right.
Just good afternoon, Deputy Chief Long. Would you tell the court for the record where it is that you work?
I work for the Fulton County District Attorney's Office.
In what capacity?
Deputy Chief Investigator.
As Deputy Chief Investigator, are you over any particular units?
I am.
All right. Are you over the unit that is prosecuting this case that we are here in trial on?
I am.
And as part of your responsibilities as Deputy Chief Investigator, do you accompany attorneys to meetings with witnesses or other attorneys?
Yes, I do.
Specifically, are you tasked with accompanying Deputy District Attorney Hylton and myself when the needs arise?
And among other attorneys, yes.
On June the 10th, 2024, do you recall that date?
I do.
And did you accompany myself or Ms. Hylton to the chambers of Chief Judge Glanville on that day?
I was with Ms. Hylton.
Was there anyone accompanying me? As
Yes.
And was that person one of the lieutenants with the DA's office?
That is correct.
While as Deputy Chief Investigator, do you give instruction to lieutenants and investigators regarding how they are to keep the lawyers in mind and keep their eyes on the lawyers?
Yes, I do. I give guidance and counsel in reference to that.
And are you all required to remain with us at all times during those types of meetings?
Yes.
June 10th of 2024, do you recall who was present in the judge's chambers at the time you arrived with Ms. Hylton?
I do recall Judge being present, court reporter, Ms. Kayla Bumpus, several deputies, and with Kenna Copeland, and myself and Ms. Hylton.
Was I present in chambers at the time you arrived with Ms. Hylton?
Not when Copeland was there, no.
did I ever come back after Copeland arrived in chambers?
You did not.
Did you remain with Ms. Hylton during the entire time that she remained in chambers?
I remained with her the entire time she was with Ms. Copeland.
Okay. Were you present with Ms. Hylton when was Ms. Bumpus in the room during the entire time that Ms. Hylton was in a room with Mr. Copeland?
Yes.
At any time did Ms. Bumpus leave the room and leave Ms. Hylton in the room with Mr. Copeland without his attorney?
No.
Were you present in the courtroom today when Ms. Bumpus testified?
I was.
Did you hear Ms. Bumpus talk about an off-the-record conversation that took place between Ms. Bumpus, Ms. Hylton, and Mr. Copeland?
I did.
Do you recall during the time that you were in chambers with Ms. Hylton, how many times, if any, that you all went off the record?
Make sure I understand your question. How many times do we go off the record?
Yes, and let me back up and ask you this. Were you able to discern when you all were off the record?
Yes.
How?
When the court reporter was not documenting what was taking place.
Was there ever a time that you all went off the record at either attorney's request, that is either Ms. Bumpus or Ms. Hylton's?
From what I recall, there were times we stepped out of the room so that Ms. Kayla could talk to Mr. Copeland. And then the last time, there was a conversation before we went back on the record.
At any time that you all stepped out of the room so that Ms. Bumpus could speak with Mr. Copeland, did you observe me go into that room?
No.
Now, when you said there was a conversation that took place the last time, would you please tell the court what you're referring to?
The conversation I believe Ms. Bumpus is talking about right before we went back on the record. There was a conversation where Ms. Hylton spoke with Ms. Bumpus and Copeland before the judge and the court reporter went back on the record.
Did that conversation take place following a time when Ms. Hylton exited the room so that Ms. Bumpus could speak to Mr. Copeland? Or was that a time when you all were sitting in the room and you just went off the record?
That was a time where we took a break, and before we came back on break, it happened. If I'm answering your question, if I understand your question.
Did you all, you being you and Ms. Hylton, did you all leave the room when you say you took a break?
Yes, everybody left the room.
Okay.
Except for Mr. Copeland and the deputies.
Okay. Did Ms. Hylton have any contact with Mr. Copeland during the time that Ms. Bumpus was not in the room?
No.
Were you present when, or do you have any memory of Mr. Copeland saying something akin to, I can claim all of this?
No.
Were you and Ms. Hylton within close proximity, within 2 feet of each other during the entire time that you all were in chambers?
Yes.
Are you able to say whether you all would have been privy to whatever was said? If she heard it, you would have heard it. If you heard it, she would have heard it.
Correct.
Do you recall speaking with Ms. Bumpus and Mr. Copeland about the Donovan Thomas murder?
No.
Generally speaking, starting there, would you tell the court what you recall talking about?
I'm unclear as to when you're talking about. Starting where?
During the time that you were in chambers with Ms. Bumpus, Mr. Copeland, and Ms. Hylton, can you tell the court the topics that you discussed that, not you, but Ms. Hylton and Ms. Bumpus and Mr. Copeland discussed?
The topic at that time, Ms. Hylton just made it clear to Mr. Copeland that she expected him to tell the truth, and that if he was going to get on the stand and claim something that he know he didn't do, then she would be looking at prosecuting him for perjury.
And so I'm clear, is this on the record or off the record that this conversation takes place?
This was off the record just before the judge came back in.
Have you had an opportunity to read the entire transcript of the in-chambers hearing?
I have not.
Do you recall Mr. Copeland making any direct statements about his involvement in the Donovan Thomas murder?
He never mentioned anything about involvement in Donovan Thomas murder.
Do you recall him making any indirect statements or statements that could be construed as an involvement in the Donovan Thomas murder?
No.
Did Ms. Hylton, during her conversations with Ms. Copeland, while you, Ms. Bumpus, Mr. Copeland, Ms. Hylton, the court reporter, not the court reporter and the judge, in other words, during an off-the-record conversation, did Ms. Hylton...
All right, hey, back up. So is it your testimony that there was one brief off-the-record time when Ms. Hylton, Ms. Bumpus, and Mr. Copeland were all in chambers, but before the judge was back in chambers? Or just tell me, maybe I'm yes, no?
Yes, we broke for someone to use the restroom.
Okay.
And before we went back on the record, that's when Ms. Hylton and Kayla had the conversation before Ms. Weaver began to record everything.
So Ms. Weaver was sitting in there.
She was not in there at the time they were off the record.
Okay, well, I mean, you can be off the record and still have the court reporter sitting in there. So I'm just trying to
No, she
get
was not in there.
clarification. So this was after a bathroom break.
Right.
Ms. Hylton and Ms. Bumpus head back into chambers before the court reporter and the judge are back. Is that right?
Well, I want to say Ms. Weaver did come in.
Okay.
And then Ms. Hylton did ask, she needed to say something with Kayla and Mr. Copeland before the judge came back on the record.
And Mr. Copeland's in there at that point in
Mr.
time?
Copeland was in there.
All right. And so what is the substance of that very brief 2-minute or whatever conversation?
It was Ms. Hylton explaining to Mr. Copeland that if he did get on the stand and take credit or try to take credit for something he didn't do, she would then seek prosecution for perjury.
She would.
Seek prosecution for perjury.
And did she talk with any specificity about what crime or crimes that would include?
She did mention the Donovan Thomas case, and that if you got and claim something that he knows he didn't do, and we have proof that he didn't do, then she would prosecute for perjury.
All right. And so your recollection is that that conversation occurred off the record before the judge was in there?
Yes.
Okay. Do you have a recollection of a very similar conversation also occurring on the record?
No.
So if it's reflected on the record, then that's the conversation that occurred?
Say that one more time, Judge.
Were there two very similar conversations about that where Ms. Hylton is saying, if you get up and say something that we know you didn't do, we're going to prosecute you for, or I'm going to prosecute you for perjury?
During the course of the conversation, Mr. Copeland's concern appeared to be his statements or inconsistent statements.
I'm talking about just the off the record now.
Just off the record was just in reference to him taking responsibility for something that he didn't do.
Okay. I have no idea why that phone is ringing or how to turn it off. This is not my courtroom, so we're just going to ignore it. That phone being the desk phone on the bench for some reason. I don't know why. Okay, sorry about that interruption. All right, and you only recall one conversation about that, whether it occurred on or off the record?
I only recall one conversation specifically in reference to Ms. Hylton saying that she would seek perjury unless it was something blatant, a blatant lie.
She would or she would not?
She would not, unless it was a blatant lie. She wasn't concerned about inconsistencies that she would use impeach. She would just impeach him for inconsistencies.
Okay. So do you recall any conversation where Ms. Hylton says, and this is on or off the record, Ms. Hylton essentially says, look, if you get up there and you claim something that you're the one that did something and I flat out know you didn't do it, I'm not going to prosecute you for perjury for that because I don't know what your reasons might be.
I don't recall a conversation to that. I do know that she used an example that she would have to corroborate something before she prosecute.
Okay. All right. So the extent of the off the record before the court got back in their conversation was her essentially just saying what?
Her conversation was in reference to him getting on the stand and taking responsibility for something that he know that he didn't do, or falsely admitting to something that he did after receiving use immunity.
All right. Go ahead, Ms. Love.
Thank you, Judge. Did Ms. Hylton attempt, or did she make any effort to explain perjury beyond what you just described for the court? Do you remember her doing that?
Doing this off the record or just in general?
In general?
Yes, she did.
Was the conversation that you are relating to the court that happened off the record, did it refer to matters that you later discussed on the record as well, or not?
All of it in sense was stuff that per se was explained on the record. It was just clarifying what would constitute perjury versus inconsistent statements, or whether she would need to impeach him.
And showing you, for instance, just page 50 of the transcript, line 11. I'm sorry, line 19. If you'll just take a look at it, is that an instance that is similar broadly in nature to the type of the conversation that took place off the record that you were just describing for the court? And by that, I'm talking about where Ms. Hylton is saying that's different, referring to the word purge. And Mr. Copeland says that can get me back in jail. And Ms. Hylton says yes. And Ms. Hylton in line 24 of page 50 says, it's not what you're saying, what you're saying is not perjury. What you're saying is what we call a prior inconsistent statement, and so forth and so on. Is that the type of conversation that took place off the record?
Objection waiting.
Sustained.
Yeah.
Sustained. Ask a different question.
Yes, Your Honor. During the conversation off the record, did Ms. Hylton endeavor at any time to help Mr. Copeland understand the difference between perjury and purge?
If you remember.
I don't remember if that was substance of the off the record. I do know during the course of the meeting, she repeated that several times, trying to explain the difference between purge and perjury.
And off the record, the comments, any comments that were the comments that Ms. Hylton made regarding hypothetical instances where perjury could be occurring, did she clarify for Mr. Copeland in any way? Did she seek to clarify how she would be able to distinguish between perjury and something that wasn't perjury?
Objection, maybe.
Overruled.
The off the record conversation was very brief and very short. And there wasn't a whole lot of explanations because that had already taken place.
Do you remember anything that Mr. Copeland said in response to what Ms. Hylton said about being able to, if he got up on the stand and admitted something that she could prove he was lying about?
Yeah, is this you asking during the off the record conversation?
Yes.
Okay.
He said he wasn't going to do that.
And what is it that he said he wasn't going to do?
Get on the stand and lie for something he didn't do.
Do you have memory of him asking or saying something about not going to say that he killed Donovan Thomas?
He didn't use that word. He said he wasn't going to take credit or say he did something he didn't do. Yeah.
Do you recall that those words you just spoke were in response to a question about the murder of Donovan Thomas?
It wasn't a question specifically about Donovan Thomas. It was a question about him getting on the stand. It was a statement about him getting on the stand and taking credit for something he didn't do.
And broadly, do you recall Ms. Hylton making comments about Donovan Thomas that Mr. Copeland then made any comments about?
Other than if he got on the stand and took credit for something or said he did something that he didn't do and we knew he didn't do. That was the only statement she made, and that he said he wasn't going to get on the stand to do that.
Now, do you have any memory of Mr. Copeland, either on the record or off the record, saying anything about a gray infinity that the state, about having information about the infinity that the state doesn't know?
He never said anything about an infinity to me or Ms. Simone, Ms. Hylton.
Did you ever endeavor to find out what he may have told Ms. Bumpus privately? I don't want you to reveal if you heard it. I just want you to know if you ever endeavored to find out what he may have said to her privately.
No.
And
Go ahead.
Would it have stood out in your mind if Copeland had made any kind of inculpatory remarks about the murder of Donovan Thomas?
Almost definitely. If he had made a remark about the murder of Donovan Thomas, then we would initiate investigation. And I would assign one of those lieutenants to assist me with looking into that.
Do you have any memory of any exculpatory remarks Mr. Copeland made about any defendant currently on trial or not on trial regarding the Donovan Thomas murder?
No.
Your Honor, I'm
Go ahead.
ceding the floor.
That's
Okay.
fine.
All right. Does your memory of what took place during any portions of the conversation that were off the record, does your memory align with what you heard Ms. Bumpus testify about regarding off the record conversations?
The restroom break, just restroom break.
And what about the content of the off the record conversations? Does your memory align with what her memory is as she testified about?
Not for the majority of it, no.
Would you tell the court any discrepancies between what you recall and what you heard that she recalls?
The off the record, like I said before, basically Ms. Hylton having the conversation about Mr. Copeland getting on the stand and taking credit or claiming something that he didn't do and that we know he didn't do. That was in just the gist of the off the record. conversation before the judge came back in.
And what, if anything, did you hear Ms. Bumpus talk about that you have no memory of whatsoever, or that you can testify in your recollection did not happen?
The incident about the infinity, him claiming that I can claim all of this. The part about you coming back the second time, that's what stands out to me right now.
And was my absence from the interactions between Ms. Hylton and Mr. Scratch that. Your Honor, that's all the questions.
All right, thank you. Anybody from the defense side have questions for Investigator Long? Miss Love, do you need a cough drop? Because I actually have some if you need one. Okay.
This court.
Okay.
Investigator Long, good afternoon.
Good afternoon.
I want to talk to you specifically about the off the record portion of the meeting on June 10th, 2024, okay?
Okay.
All right, and if I have it mixed up, was off the record versus on the record, just correct me. I'm trying to understand myself, okay?
Yes, sir.
All right. First of all, the off the record portion of this ex parte meeting, you said that Ms. Weaver, the court reporter, did come in to the judge's chambers, the judge's back room and chambers during that discussion, correct?
Everybody was coming in initially.
Okay, and that was before what we're deeming the off the record conversation, correct? And Ms. Hylton specifically requested Ms. Weaver not to take those communications down, correct?
I wouldn't say she directed Ms. Weaver, but she did say she wanted to talk to Ms. Bumpus before we went back on the record.
She made the request, Ms.
Yes.
Hylton. Okay, and that was to remain off the record was requested by Ms. Hylton and Ms. Hylton alone.
Yes.
Can I get a little clarification there? So this is after the restroom break, right? Or whatever kind of break it was?
Yes, Judge.
Okay, and when Ms. Hylton said, I want to speak off the record to Ms. Bumpus for a minute, was Judge Glanville already in that room by then or not?
He had stepped in and then ended up stepping back out.
Okay, and so, all right,
Yeah.
thank you.
And you indicated that during this off the record portion, Ms. Hylton stated to Mr. Copeland that she would not pursue perjury charges unless it was a blatant lie. That was said during the off the record portion, correct?
No, that's not what I testified to.
Okay, when was that stated?
I don't ever recall her saying that she wouldn't seek charges unless it was a blatant lie.
Okay.
I think she was trying to explain the difference between the inconsistent statement and then a outright lie, if I can use that terminology.
Well, what did she say?
What do you mean what she said?
Well, you said that when I said she would not pursue perjury unless it was a blatant lie, you said that was not what she said. So what did she say regarding that?
And off the record?
Yes.
Yeah. Her statement or comment to Mr. Copeland was that if you did get on the stand and you took claim or took credit, just me paraphrasing, for something that you did, then knowing that you didn't, knowing we know you didn't do it, then she would see perjury charges for that.
Okay. And you indicated, my understanding of your testimony is you indicated that at some point, Ms. Hylton specifically referred to getting on the stand and claiming responsibility for the Donovan Thomas situation. Is that correct?
Yeah, if he took credit for something he didn't do, yes.
But specifically, it was stated the Donovan Thomas situation, correct?
Yes.
Okay, and that was out of Ms. Hylton's mouth.
Yes.
Okay, so Ms. Hylton specifically during the off the record portion referenced Mr. Copeland taking credit or taking responsibility for the killing of Donovan Thomas.
Yeah, it didn't come exactly like that, but yes, it just yes.
And Ms. Hylton specifically said that if Mr. Copeland did that, she would seek perjury charges against Mr. Copeland, correct?
If he got up and he took credit for something he knew and he didn't do, yes.
Well, you keep going back to you didn't do, but in the fact is in that off the record portion of the conversation, it wasn't just generally something we know you didn't do. She specifically said
it was both.
Killing. Okay, so it was specifically something we know you didn't do, and then she also said specifically for claim responsibility killing of Donovan Thomas. Okay, so to your recollection, if you recall, prior to Ms. Hylton, did Ms. Hylton just bring Donovan Thomas that case into the discussion, or did Mr. Copeland say something that Ms. Hylton was responding to when she warned him not to take credit for the Donovan Thomas killing?
Ask the question one more time.
What did Mr. Copeland say before then that prompted Ms. Hylton to start talking about Donovan Thomas's murder?
Mr. Copeland didn't say anything. I can only, I believe Ms. Hylton was attempting to just explain because he had received use immunity, not to go in and try to claim something that he didn't do because he received use immunity.
So your testimony is Mr. Copeland didn't bring up Donovan Thomas, but Ms. Hylton brought up Donovan Thomas murder.
Right.
Did Ms. Bumpus bring up the Donovan Thomas murder prior to that?
Not that I recall, no.
And how was it determined when Ms. Weaver was going to start making a record of this meeting again?
I don't know how it was determined.
Did someone call her in? Did someone ask her to start recording now or taking minutes now?
Yeah, I believe if you're asking what made her prompted to, yeah,
Yes.
we said, I don't recall if it was Ms. Hylton, but Ms. Hylton may have said we're finished talking, and we called everybody back in.
And instructed the meeting to go back on the record? Instructed that the meeting should go back
I
on
don't
the
know if we
record?
instructed, but we were clear to go back on the record.
I have no further questions. Thank you.
Thank you.
Anybody else?
How are you, sir?
How you doing, Mr. Steele?
I'm okay. How you doing?
I'm doing fine. Blessed and highly favored.
Can I answer you a couple of questions?
Yes.
What was your understanding, if you had one, of why you were having this ex parte meeting?
Objection, Rhodes.
Sustained.
At what point were you initially told that you're going to this ex parte meeting?
Objection, Rhodes.
I wonder which part he was there for. The beginning part, he said he came with Miss Hylton. I want to clarify.
Ask your question again.
At what point did you become aware that you're going to this ex parte meeting?
I'll allow that.
I believe that morning.
And when you say that morning, was it before the meeting began? Do you know when the meeting began?
It was before.
Okay.
It was before the meeting.
And who alerted you that?
Ms. Hylton, I believe. Yeah, because of course we had to escort him over to the judge chambers.
And did you escort, when you say them, who did you escort? Say it one more time.
Miss Hylton.
And was Adrian Love already there in the meeting, or did she come with you or go after you?
She was already there.
All right. Now, how often, besides this day, have you had these type of meetings with Judge Glanville?
With me, just this one.
How about with other people that you know about?
With Judge Glanville, no. Never happened with Judge Glanville.
Well, in this case.
Just this one.
Okay. All right. Thank you. Thank you, Your Honor.
You're welcome. Anybody else from the defense?
Oh, I have one other question.
Go ahead.
Did anybody tell you that that was not to be told to other people who are not invited to that meeting?
What's the relevance of that?
The state of Georgia, I objected to it, made a statement that I somehow knew about this beforehand, which is not true. So I want to ask if anybody directed anybody to tell somebody from the defense, not tell anybody from the defense.
I'll allow it.
Your Honor, I did not represent to the court.
That's fine. It's all right. I'm going to allow the question.
No. If I understand you correctly, they didn't want to tell me not to say anything.
One more time, you spoke very fast.
I'm sorry. Was your question, did anyone tell me not to say anything about this meeting?
Yeah.
No.
Did you tell anybody about the meeting? Did you personally tell anybody, me, any of the other defense lawyers, any of the people accused of this meeting?
No.
Thank you, Your Honor.
Mr. Matthews. While Mr. Matthews is making his way over, what is your recollection as to sort of when during the meeting, like within the first 10 minutes, within the last 10 minutes, right in the middle, if you recall that the bathroom break and then short off the record conversation occurred that you testified to?
This was near the end.
Near the end?
Near
Okay.
the end.
All right.
Good afternoon. How are you today?
Mr. Mathis, how you doing?
Doing well, thank you. Just a couple of questions. Did you have any recording devices in the meeting yourself?
No.
Did you make any written notes of any of the meeting yourself?
No.
Okay. And just for the record for today, you were actually in the courtroom during the time that Kayla Bumpus was testifying before this honorable court, correct?
That's correct.
Okay. Did you know this morning before court that you might be testifying about this matter today?
I did not know.
Okay.
I could ponder, but I did not know.
Okay. All right. That's all I have. Thank you.
All right. Anybody else? Any redirect?
When you spoke about the comment that Ms. Hylton made about claiming something that he didn't do, or the Donovan Thomas murder, did she qualify her comments in any way?
What do you mean by qualifying?
Did I hear, did she tack on anything about if she could or couldn't prove it? Or did she just say, if you do this, I will charge you with perjury?
She consistently, if she's mentioned charge, she would say that she would have to corroborate anything before we charge. But she did mention the fact of I can only speculate, I was use the word, the concern about him trying to take claim for something after receiving free use immunity.
And were those comments that she made that you're talking about also accompanied by any kind of explanation, like if I can prove it, or?
Yeah, because she mentioned the fact of if we knew, and we know you didn't do it. Yeah.
Thank you.
Mm-hmm.
Thank you.
Anything else from the defense? All right, is the transcript before the witness at this point? I don't know where it went to.
Yes, Your Honor.
Okay. Can you flip to page 41 and take a look at, well, the end of 40, starting at line 20, and then review that through the rest of line, or the rest of page 41? Let me know when you're done.
Okay. I'm done, Your Honor.
All right. Is it a fair characterization that during that portion of the meeting, Ms. Hylton, Ms. Bumpus, and Mr. Copeland are talking about what might or might not get him charged with perjury or false statements?
Yes.
And does Mr. Copeland raise the issue of murder and whether it has a statute of limitations?
Yes.
Okay. And does Ms. Hylton at some point after that talk about if she knows that he's lying about something and there's no other evidence, what that might or might not result in?
Yes.
All right. Do you recall whether the off the record post bathroom break conversation occurred before or after this on the record conversation?
Give me just a second. Let me look a little past just to make sure.
Sure.
It happened after.
Okay. If you take a look at the entire rest of the transcript, do you think you might be able to figure out about when that break and off the record conversation happened?
I will take a look.
And I mean, you may or may not be able to, but if you can, let me know. If you can't, let me know that as well.
Your Honor, I believe page 52.
Can you find out whether that's somebody who has a Rule 22? And if it is not, they cannot come back in with that phone. Thank you. Go ahead, I'm sorry.
No problem. Your Honor, I believe 52, around 13, 14,
Okay.
when we come back in. Let's see. Yeah, I think somewhere around in there.
Okay. And a break is actually indicated at lines 9 through 13 or so. Is that right? Okay.
Right.
And then at line 14, the court remarks, Mr. Clopin, have you had an opportunity to talk with Ms. Bumpus, your lawyer, and Ms. Hylton, the state's counsel? Have you got any other questions?
Yeah, because
So it's right before that the off the record
Yes.
conversation occurred? Okay, thank you. All right. Any other questions by any counsel? Defense counsel? All right. Anybody else? Silence equals none. Okay. Ms. Love, anything?
Yes, Your Honor, thank you. Chief, Deputy Chief Long, on page 40, lines 20 through 25, when the court refers to comments made to Mr. Copeland earlier by Ms. Love, did you ever hear those types of comments made by Ms. Hylton?
Yeah, Ms. Hylton. Yeah.
Was there any time you are aware of that Chief Deputy Love, myself, would have been in a position to make those comments to Mr. Copeland that morning?
No, not with Copeland in the room. You weren't around at all.
Okay. Thank you, Judge.
Okay. All right. Investigator, thank you. You may step down. Any other evidence, Ms. Love?
Not about, no, Your Honor, not at this time.
All right. Any rebuttal evidence from anybody on the defense side of the room? All right. Anything y'all want to suggest that this actually means?
So, Your Honor, there's a case that I believe that Mr. Steele has shared with you. I'm trying to get the site right now. Ford Motor Company versus Young, 322 Georgia Appeals, 348. And that case deals, that case, when we've been discussing this in the past, there's been suggestions that if there was judicial misconduct or what we believe is judicial misconduct from this side of the room, or if there was prosecutorial misconduct or what we perceive to be prosecutorial misconduct from this side of the room, that the remedy was with the bar. And that case, the Ford case, indicates to me that, Your Honor, in the trial court play an active role in fashioning remedies in the case of judicial misconduct and or prosecutorial misconduct.
I don't know about judicial misconduct. That's not what that case stands for.
Prosecutorial misconduct or lawyer misconduct, I should say.
Violations of the state bar rules.
Yes, and can I go get one thing for myself?
Sure.
So I filed a motion on Friday.
Yes, I worked diligently over the weekend on writing an order with regard to that motion. Haven't gotten to the Brady portion of it yet.
So, and I appreciate that, Your Honor. I appreciate the attention that you've given it. That motion in the beginning lays out things that I've observed that I've felt have been highly irregular about this case. The point of my inclusion of that in my motion was not to draw extra attention to it or for anyone to feel sorry for me or anything else, because it's really about my client, Mr. Stillwell. But the purpose of it was to try to inform the court, at least from my perspective, and I think the perspective of some of my colleagues, that things have been irregular in this case. And that there are real life consequences and consequences to the trial when we perceive what we believe is the lack of an impartial trial judge and also of prosecutorial misconduct. In this case, from my perspective, we've had with the ex parte communications in themselves, I don't believe that there was a valid reason to initiate the meetings. I believe that the state and members of the state's prosecution team in particular took something very small and jumped to unbelievable conclusions as a way to get their foot in the door of the judge's chambers to have a discussion. And there were at least 2 discussions that took place. I'm assuming that there was a third discussion, which may have strictly involved the grant of immunity.
All right, well, I think we cleared that up on Friday because we specifically asked, was there any hearing or any kind of ex parte, anything with regard to getting the order, or was it just the motion being filed? So, I mean, I don't have any reason to believe there's yet another one, but.
Right. And you know, there's a potential under the King case that one, if it was just for the purposes of granting immunity, may have been a proper ex parte, but these were not. The substance of these meetings exceeded what is appropriate. They violated Uniform Superior Court Rule 4.1, which says that judges shall neither initiate nor consider ex parte communications by interested parties or their attorneys concerning a pending or impending proceeding. Georgia Code of Judicial Conduct Rule 2.9 prohibits ex parte meetings except for a narrow exception: scheduling administrative purposes or emergencies that do not deal with substantive matters or issues on the merits. Provided that, so we don't believe that it falls under an exception to begin with, provided that the judge reasonably believes that no party will gain a procedural, substantive, or tactical advantage as a result of the ex parte communication. In my view, the transcript reveals open discussions about you're going to testify, you can say you don't recall. They're basically walking through the procedures for laying the foundation for prior inconsistent statements. To say that that doesn't put that meeting with just the judge and the witness who has been sworn in doesn't put the state at a tactical advantage over the defense who's excluded, I don't believe that to be the case. Secondly, even if it falls under the exception, the judge must make provision to promptly notify and give the parties the substance of the ex parte communication and an opportunity to respond. We were not promptly notified. We found out through, I keep saying, doggedness and happenstance. I believe that's what it was. We learned about it. And then when we asked for an opportunity to respond, we were promptly greeted with an invitation to go to the jail for 20 days. So that was violated. The Georgia Rule of Professional Responsibility Rule 4.2 regarding communications with a person represented by counsel. The state, it's the worst kept secret in this courtroom that John Melnick represents Kenneth Copeland. Worst kept secret. Everyone knew that. I knew that, and that's why I called Mr. Melnick.
Okay.
The state is somehow claiming that in this case where the world is watching, it's a huge case, that they did not know that Mr. Melnick was representing Kenneth Copeland, and they went behind Mr. Melnick's back and initiated conversations with Mr. Copeland. Let's be frank, all these gentlemen are facing RICO charges with overt acts going back to 2013. So this is not a case where Mr. Copeland could not possibly be prosecuted. He could easily be indicted. He could easily be indicted and put with the rest of the gentlemen who were severed off of this case and be in Rice Street right now. He was in legal jeopardy when the state was seeking to speak to him outside the presence of his attorney. From our perspective, that was a knowing violation of Georgia Rule of Professional Responsibility 4.2. Additionally, Your Honor, there's Bar Rule 3.3, candor towards the tribunal. Now, I can't flesh this out without Ms. Love taking the stand. I would love to ask her about it, but in the motion to grant Mr. Copeland immunity, in paragraph 12, I believe it is, they specifically stated that a member of the defense team had contact with Mr. Copeland, and that prompted him to begin to assert that he was going to exercise his Fifth Amendment right.
I would prefer that, since there continue to be allegations back and forth amongst the lawyers, that we specifically get what is actually stated in there instead of, and I know you're not trying to misrepresent anything, you're trying to give it your best recollection, but let's get the actual motion and read the actual words, okay? I've got it somewhere.
Okay, yeah, I've got it right here, Your Honor, from Ms. Persifield's email to us.
I've got it. If you've got it at hand, go ahead. But if you don't, I've got it now.
Okay. I'm trying to find out exactly, try to figure out where it was. Okay, paragraph 11.
Go ahead.
I'm sorry.
Paragraph 11.
Yes. And it says, Kenneth Copeland has been subpoenaed to testify in the above style case. Copeland is the next witness scheduled to testify in this case on June 7th, 2024, beginning at 9:00 a.m. On June 4th, 2024, and June 5th, 2024, investigators with the Office of the Fulton County District Attorney coordinated and arranged with Kenneth Copeland to provide Copeland transportation to court on Friday, June 7th, 2024. However, on Thursday, June 6, 2024, after an encounter with defense team members and members of the Fulton County District Attorney's Office, Copeland stated to an investigator and to an attorney with the Office of the Fulton County District Attorney that Copeland may attempt to plead the Fifth to avoid testifying against members of YSL. I can only speak for myself. I did not have any encounters with Mr. Copeland on June 6, 2024. I don't believe that any of my colleagues did. I don't believe any members of the defense team did. I don't believe that what's asserted in paragraph 11, to my knowledge, I don't believe it to be the truth. If it is not the truth, and again, I would love to inquire, but Ms. Love would be a witness at that point. Bar Rule 3.3, candor towards the tribunal, would also have been violated. The reason I focus on the violation of these rules is because of the Ford case and the proposition that we can do something about this besides run to the bar. And that makes sense because it's ultimately if, and I say it did happen, and I say the transcript establishes that it did happen, and you have the transcript, Your Honor. We have in the transcript the state and Judge Glanville both affirming each other that Mr. Copeland can essentially be incarcerated indefinitely until this trial is over, until the trial of the co-defendants is over. That, to me, is coercion. That's intimidation. We have other examples where Mr. Copeland is given what I would say incorrect legal advice about what his exposure is for these allegations and his potential criminal liability. That is coercion. That's trying to convince him to take the stand and plead so that the state can then impeach him with his prior inconsistent statements, presumably. Mr. Copeland, the act of him taking the stand as a result of those ex parte communications has prejudiced, has harmed all of these young men in court here today. So there has to be relief beyond bar issues for them. Your Honor, I'm not going to repeat everything in my motion. You have my motion. I know you've read my motion. But they have a right to a trial. They have due process rights. They have a right to a trial free of prosecutorial misconduct if that misconduct rises to the level of a due process violation. They have an absolute right to a fair trial and due process in front of a fair and impartial trial judge. They also have the right to be present at all critical stages of the proceedings, including, I'm saying, and I think it's fairly clear, that those ex parte communications talking about the witness under the Scudder case that I've provided to the court before, that was a critical stage and they were unlawfully excluded. And of course, there's no way we could have acquiesced because we knew nothing about it ourselves. So those are all violations that have harmed these individuals. There has to be a remedy. I believe that the facts are there for you to consider disqualification of district attorneys in this case. And I think Mr. Steele is going to argue that further. But also, I believe that the facts are there under the Wilson case, as well as the State v. Jackson, 306 Georgia 626, Anderson v. State 285 Georgia Appeals 166, and Wilson v. State 233, Georgia Appeals 327. Wilson v. State 233, Georgia Appeals 327.
All right, and those are the three cases that y'all gave me a
Correct.
couple of days
About
ago.
goading. And the reason I cite to those cases, because it's not often, well, it would be never probably, that a district attorney or prosecutor is going to say, yes, I did this intentionally, I did this to goad. These cases looked at the egregiousness of the violation, the experience of the prosecutors involved. Ms. Love is a chief deputy district attorney in the office, head of the unit
All right.
that deals.
Can I interrupt you for just a minute? So all of this is in your motion, and if and when we get to that point, that would be an appropriate argument, but let's
Okay, well,
pause it for now. I have it.
You asked where we are right now, and that's from my perspective, that's where we are right now.
All right. And I don't mean you can't argue anymore. I just mean
No, I understand.
the information about their qualifications is in your motion.
Yes, Your Honor.
All right.
Thank you.
Okay. And if Mr. Steele's going to argue as to something else, that's fine. But I had said a little while earlier that with regard to Ms. Love, your proffer about what Mr. Abbate might or might not have to say about Mr. Melnick's representation was not yet relevant. I think it is now relevant, and the proffer has not been accepted. So if you want to present evidence as to that, that would now be appropriate. And I don't mean this very instant, because I'm going to hear from Mr. Steele, but we now know that is an issue. So you can go ahead and get him lined up.
Thank you.
All right, go ahead, Mr. Steele.
Your Honor, I would just like the court to consider the case that was announced to this honorable court by Attorney Shard. I emailed it earlier today to your honorable court's co-worker and all the parties. It's Ford Motor Company versus Young, and it was 322 Georgia Appeal, 348. It's in Division 3. 745 Southeast 2D299 2013 case. And what our second highest court wrote was, and I've given a copy actually to this court. And
Oh, yeah, I got the copy. I appreciate it. Thank you.
it's on page 8 of 9 of the copy I've given. It's on the right-hand side, first full paragraph. And it specifically states that in the center, and we have previously held that trial courts may disqualify attorneys for violations of the disciplinary rules. We held that the trial court erred in ruling that because sanctions for violations of disciplinary rules appear to be the exclusive province of the Supreme Court of Georgia, not of the trial court, it lacked authority to determine whether plaintiff's counsel violated 4.2, Rule 4.2 of the Georgia Rules of Professional Conduct, and therefore should be disqualified. We noted that the determination of whether an attorney should be disqualified from representing a client in a judicial proceeding rests in the sound discretion of the trial judge. So I'd just like you to reconsider your order, not disqualifying Ms. Hylton and Ms. Love. And you've inherited a case that has a lot of history, and a lot of it bad. And I put into my motion, I can go over it with the court, and I also attached the YouTube links. It's on July 10th, 2024. I also filed in case the link goes away, I filed on a thumb drive to preserve it. So that's with the clerk's office, and a copy was sent to the prosecution as well. But it started before, but, an opening statement, I don't know if you
Yeah,
read it, so.
I read your motion and I looked at the portions that you were talking about.
Hurtful. It's hurtful. And then as of last week, a new court comes on. It's almost like, a breath of fresh air. It's all new. And again, I'm hit with emotion by Miss Love. That was the fourth time the same thing's argued, talking about a duty that is intentionally and knowingly not followed through by me, and I owe it to her. And I saw your email saying, whoever wrote that, you come into court. I understood it.
I don't think Ms. Love did herself any favors with that.
Well, the favors have to end. I'm not trying to, I've never done this before in my history of living in a courtroom, but it's just not appropriate that I can't accept a proffer from a lawyer. I've never said that before. I've never uttered any of those words. So I'll leave it with you. My point is, it doesn't end. There have been no sanctions. It's been ratified almost. And it's from everything. It's just, I put in paragraph 2, just choice examples from my memory, but it is constant. There are great people everywhere in the courts, and they shouldn't be treated like this. So I'm actually disqualified because it's just not, at some point, the message needs to be sent that this is not the state of Georgia and this is not our bar.
All right, thank you. As I understood the gravamen of your motion that you filed since I've been the presiding judge to disqualify Ms. Love and Ms. Hylton, it was because you needed them as a witness, and that was the basis of my ruling. And in Mr. Sharp's motion that is under consideration right now is a request, again, to disqualify them. And I know that I previously said, y'all, that's a matter for the bar. And when I was talking about that, I essentially meant the, and I don't want to call it bickering back and forth because I'm not sure it's been back and forth to any large extent, but that kind of thing, the whatever it is that had been talked about before, that's what I was talking about. I will tell you that this court takes Brady violations very seriously. And I mean, everybody ought to, prosecutors ought to. And I am considering that right now. So rest assured that I am aware and have been aware that I have the authority if I choose to remove them.
Thank you.
So, all right. Do y'all want to be heard from the state on this? Or do you want to go ahead and present some testimony to counter the Melnick, that you knowingly contacted Mr. Copeland, knowing he was represented by Mr. Melnick?
Absolutely, Your Honor.
All right.
What we did was ask that our witnesses be summoned, if you will.
Okay.
If the court would just give us.
Sure. Why don't we take a convenience break, and can you let a deputy know when you're ready with somebody, and we'll come back out.
Yes.
Thank you.
Thank you.
Appreciate it.
Well, let's go ahead and get this on the record. That's what we're going to do. Let's just go ahead and put it on the record. How you feel? How you feel? Yes, Lord. Yes, Lord. Let's put it on the record. We have said, and we certainly maintain, that somebody was going to have to slow down Speedy. That had to happen. You're going to have to slow down Speedy. And we have said over and over and over again, brothers and sisters, that if they can get her to slow down, and if she can get off of her conductorism, her have the trains run on time ism, her addiction to pseudo efficiency, if they can get Judge Speedy Whitaker to slow down and actually be respectful of the talented lawyers and their positions, motions, and experience within this trial, she may actually hear the validity and the depth of their argument, catch up to their argument, and realize I may need to shut this thing down. An appeals court is going to look back on this and say, why did you let it go this far? So then what are we doing here? Holla if you hear me. Brother Rhodes has laid it out to you days and days ago. You see what done happened here. The woman done moved so fast. There ain't nothing else really to do today. There wasn't nothing to do the other day because she done moved so fast till it's inevitable at some point, either send them back home or just let everybody talk a little bit longer. And effectively, what does that do? Slows it down. The only reason she's moving at the pace she's moving is what? Either somebody done pulled her coat, somebody up high done looked at this thing and said, girl, what you doing? Slow your butt down. Either that or what? It's just the fact of she ain't got nothing else on the agenda, so she might as well slow down. But if she slows down, what happens? Maybe you'll actually hear there are problems. What did she just acknowledge, brothers and sisters? She may remove the prosecution team. Well, wait a minute. We didn't already put that before you. I know, but let me find a way to save face and just kind of act like, yeah, but I was kind of hearing it that way, but I'm hearing this. No, you didn't hear it before. Because you're over your head, Speedy. But what else did Brother Rhodes tell you? There's going to come a time when that arrogance going to meet reality. There's going to come a time when Sister Whitaker going to look in the mirror and say, you know what? I don't think I don't need this in my life. I know I'm Diesel. I know I can get these trains run on time. I know I'm a good scheduler. I know I can, but I can't fix this mess. Ain't enough fixing. And you do know, brothers and sisters, if she brings an end to this prosecution team and Sister Fani's got to keep going with new cats, it gives Sister Whitaker a whole lot of extra time to catch up because she knows they got to catch up. So she can catch up and save face that way. She can also just say, you know what? I don't need this in my life. You want me to say it again? She can also get to a point where I don't need this in my life. I can also save face by letting the truth be told. This is a disaster. And there's no need to just go forward just to come right back. But they have to do it without prejudice. You understand? So she still has to find a way to get a chance to try the case again. It can't be a mistrial with prejudice. You understand? It can't be where you can't try him again. But she knows I can't do nothing with this. This is over her head. And she made the mistake of coming in here like a bull in a china shop, as they say, 150 miles an hour, doing surface level rulings when she had surface level knowledge. And we were saying from day one, where's the brilliance? She's got the go. She's got the so-called confidence, but where's the brilliance? She's got to come back home from break on time. But what good is coming back home from break on time if the motion I spent a week developing after over a year of watch junk, and you come in skateboarding through it, holla if you hear me, and we can't get a true reading. We can't get the true depth to get a true and fair ruling based on your reading, because you skimming, dipping and dodging. Don't need to see this. I don't need to watch that. I got it. I read it. I understand. We can move on. We don't need to talk about this. We don't need to talk about that. And lo and behold, well, let's back up. Well, maybe it is time for us to, let me let you know this court does take certain things seriously. Yeah. You in deep water, baby. That's what it is. That's what it is. And when you're in that type of water, how you gonna save face when you know I don't really need this in my life? I don't need, even if I could swim in this type of water, I don't really need. So how you gonna save face? You can't force the prosecution to be ready with stuff they're not ready for. You can't force the defense team to stop being as intelligent as they are and putting up as many roadblocks as they're going to. They have every right to object and fight for their client and slow things down when necessary, especially if you're not ruling in a way that's beneficial to their client. Then they need to recraft, redo, strategize, but they can't just let it be fail, deny. No, sir. No, ma'am. Do you hear me? So Love kind of felt like they was out of the hot water with this thing. Hylton is not even there right now. I'm telling you, brother Abbate is coming up. And he is smart, brothers and sisters. Brother Abbate's smart. So let's see what he has to say, because he may end up leading this case from here on. Dun, dun, dun. I'm going to tell you, there's a chance you're going to see Sister Fani herself. Dun, dun, dun. Coming to the so-called rescue. This is too high profile. There's too many eyes watching, and you know she loved the camera. But does she really want to come in and look silly? But see, she has a way now because everybody knows she picked it up. So she can laugh and joke with the judge. Well, you know, Your Honor, I'm just now catching up like you catching up. You know, she can kind of buy herself some time. You know, Sister Fani can put it a certain way, you know. Yes, ma'am, we're going to have that for you. Just give me a minute. You know, Your Honor, you know, I'm just now getting here just like you. You beat me here by 30 seconds. You know how she can do. But then she gets the camera on her. She gets to pull out. Lord have mercy. Lord have mercy. Lord have mercy. Well now. Let's just say the wardrobe can be on display to the world. Yeah. 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 I say the wardrobe, the no witches, well, maybe a few, but the wardrobe. Holla if you hear me. Maybe no witches, but maybe a few. But the wardrobe, huh? Where the line at, huh? A lot of lying going on. Are you hearing me, brothers and sisters? Yeah. So what am I saying to look out for? Sister Whitaker realizes she's in trouble. And that cocky go is being met with a brick wall called foolishness. And that mistrial is going to be looking sweeter by and by. Sweeter and sweeter by and by. The way, if you were barring some miracle for the state, if your brother Thug right now, you got to be feeling real good. Now, you might have to sit in jail for some time. You may have to sit there for a little while. But even if this goes to completion, and even if by some way you get found guilty of anything, you can already see where your appeal is looking pretty doggone good. You're in a heck of a spot right now if you're a Young Thug. Now, you may have to wait for it all to play out. I mean, she could just come and give granted right now, but it may take a little while if, right? If it go all, but you gotta feel pretty good, because if you was looking at decades in jail, and now you might be looking at, all I gotta do is just kind of wait for this. This is a procedural thing. There are too many gaps here. There are too many gaps. Put it to you straight. What's supposed to happen? Lil Woody's supposed to come on the stand and she gonna say what? Ladies and gentlemen, forget everything you were told after such and such a date. You didn't hear what you heard. So now in the appeal process, now come on, y'all. You know that's not possible that was able to happen like that. So we were done dirty, and then you were just told there's no proof, the empirical proof that they were able to do that. How in the world could this have happened? Their star witness gets a do-over, gets a chance to say it a different way, knowing what the questions are. Come on now. How do you get fairness from that? How you gonna get fairness? Yeah. So where we at right now, that Sister Love clearly heard. She clearly heard, and she's been hearing. Whitaker and I, we ain't cool right now in this courtroom. She been hearing that. I told you that first thing this morning when she didn't stand up on that objection. The tone in her voice, I pointed out to you first thing this morning. It's clear to Love she ain't got no friend up there in this courtroom. It's clear to her. And all that extra smiling and all of that, she realizing that ain't getting her where she need to get to. And now she hearing what she hearing. More confirmation, but not only confirmation, but the fact of, I am considering, and you might want to get you some more help. You might want to get you some more testimony, because there's a lot of love right now, brothers and sisters. There's a whole lot. But again, Brother Abbate, Adam, smart cat, he's going to come up, and if he says what she proffered, which is essentially what, I personally talked to Melnick, and Melnick told me he ain't want nothing to do with this. He ain't want nothing to do with no YSL. He wasn't representing the dude. He ain't want nothing to do with this. He's out. He ain't got nothing to do with this. If Adam testifies to that, then in good faith, right? Love can say, well, I'm going off of what I was told by a fellow member of the bar. And we all are sworn that, for candor, we all got to tell the truth. And this is what he said he was told. And I believed him. So how you going to be mad at me? Is that what's going to happen, brothers and sisters? But I think Adam has the ability to sound very competent as he's questioning, but how's he going to do on the stand? How's he going to do giving testimony? That's a different thing, right? I mean, we've been seeing that all day where attorneys are now on the stand, which is very, very ironic in this wonderful state of Georgia, because that's how we got to know who Adam was. Because when the other lawyers were questioning other lawyers in the Fani and Wade situation and all of that nonsense going on, it was brother Adam who was involved with that, with lawyer to lawyer and lawyer questioning lawyer. And now we're about to see it again in the same Fulton County. Lord have mercy. Lord have mercy. It's a bad look. Where the adults at? Where the adults at? I want to know. This the best we got? Is this the best? The American justice system. Is this? I just want to know if this is the best we got. Yeah. Yeah. Appreciate you being here. Appreciate you being here. Well, I'm putting stuff on your mind now again. Putting stuff on your mind now again. If you were Fani, what would you do? Look, man, look. The Trump thing didn't work out, right? Okay, so whatever you were trying to do with the Trump thing didn't work out. Now they say. We don't know, but they say. Okay, we'll jump on it. We'll see what's going on, brothers and sisters. But what would you do if you were Fani? A lot of bright lights.
All right.
You get a chance to get back in the camera, but love is under pressure. Baby.
I remember one
love
time when I was called as a witness in a case for some
Thank you for being here.
very ancillary matter. And
thank you for being here.
we're so used to being the ones examining. We're not used to being the witness. And the direct finish, and I got up to leave, just like all of the lay witnesses who have no clue. And then I felt like an idiot. But oh well, maybe Mr. Abbate won't do that. We'll see. You're coming up to the witness stand.
Like Mr. Melnick, I'm an officer of the court. He swear himself in, but whatever.
All right, let's.
It's like Mr. Melnick, I'm an officer of the court. He wasn't sworn in, but yes.
Thank you. Good afternoon, Chief Deputy Abbate.
I'm liking that start. I'm liking the start, brothers and sisters. I'm liking that. Are you digging it? Yes or no? He said like brother Melnick, I'm an officer of this court. He wasn't sworn in. You ain't got to come up here and swear me in. I'm an officer of the court, same way brother Melnick was when he came up here. Y'all didn't swear him in, so you ain't got to swear me in. Now, the deep part of that, brothers and sisters, is if he's going to be leading this investigation, or excuse me, leading the case that from here, if they do get removed or what have you, right? Talking about Love and Hylton, right? If that does happen to happen, Adam's already letting it. He didn't come in with all that smiley. I mean, unless he gonna change something right now, but he didn't come in the way they came in. He came in with the funk. He came in with the you ain't got to like me. Hylton and Love, they went to smiling. They went from Granville. They went from brother Glanville with the tension. They went to trying to, buddy up with Speedy Whitaker. Adam came in with the what? Nah, you ain't got to be my friend. I don't care if you like me or not. Which is very interesting if he ends up being the one. He already might be the one who's going to question Lil Woody. I'm giving you a heads up, brothers and sisters. If this makes it to that point, he may, okay, we're looking for possibly Fani, okay, but Fani might send him first, right? Holla if you hear me. And if he brings Lil Woody that kind of funk right there, right? That's a whole different day of testimony, brothers and sisters, or days. Come on now, let's see what happens. I'm just letting you know that you got to catch these things. No brother still didn't do it. Nobody did what he just did on his first moment with this judge in this case. Everybody was deferential. Everybody was trying to be, cool, set the tone. He came in with look, let's see. Thank you for being here.
How are you?
Fine, thanks.
Just for the record, would you state where you work and what your position is?
DA's office in Fulton County. I'm the chief deputy of the Major Crimes Division.
All right. And February the...
It's Abbate, and I said chief deputy of the Major Crimes Division.
February of 2023, where were you working within the DA's office, if anywhere?
Same position.
All right. During that time, do you recall having a conversation with an attorney by the name of John Melnick regarding a person by the name of Kenneth Copeland?
Yeah, it was a conversation on the Zoom call where Judge Whitaker was on the call and heard all the contents of what I'm about to testify to. Yes.
All right.
Well, I'm singing Mary, oh Mary, don't you weep, tell mother not to moan. What just happened there on the Zoom? Actually, Judge Whitaker was, yeah. Thanks for being here.
And would you tell the court what the purpose of that Zoom call and that conversation with Mr. Melnick was?
It was related to a bond order or bond conditions for a bond order for his, I think it's 22 SC 182, I think maybe 134. It was his possession of a firearm by a convicted felon and reckless driving, I think is what it was.
Okay. And did you have occasion to look at the bond order and see its contents, or the proposed bond order? Had the state proposed a bond order?
Yes.
Right. And did the state's proposed bond order have any reference to or any conditions that are related to Mr. Copeland's witness, position as a witness, in this case, 22 SC 183-572?
No, not to my recollection specifically, no.
Did the bond order or the proposed bond order reference co-defendants? Let me ask this. Are you familiar with the co-defendants on, or the defendants on indictment 22 SC 183-572?
Some of them, yes. I've tried. I think Khalif Adams was somebody who I was the prosecutor who, when he was convicted of murder.
And the bond order, did it reference some of the defendants on this case?
I think it referenced all of the defendants on the case involving Jeffrey Williams.
All right. Did the bond order, well, Your Honor, I'd ask the court to take judicial notice of the bond order, which is in this case.
I'll take
already
judicial
filed.
notice of it, but I'm also just going to print it out right now and make it a part of this record, so it'll just be easier.
And I did misspeak and say, in this case, it is actually in Mr. Copeland's 22 SC case.
Yeah, 22 SC 182-134.
Thank you. Would you please tell the court,
Brothers and sisters, just as a note, Whitaker knows her name was invoked. She does care about her career. So that little flippant, I'm just going to print it out right now so we can all have it. Okay? Just to let you know the difference. When other stuff was coming up, oh, I got it. Oh, don't worry about it. Even when she rushed Kayla and didn't even wait for somebody to bring up the transcript, right? Just, but right now, her career and her name was invoked. Oh, no. We're going to print this out right now. And everybody going to have the actual copy. I want y'all, brothers and sisters, to just put a pin in that, okay? These lives have been on the line. And she been quick to just be like, move on. Okay. Is there anything else? But her name has been invoked. Oh, no. I'm going to print that out right now. I want you to just see the difference. Thank you for being here.
The content of the conversation and communication you had with Mr. Melnick regarding Mr. Copeland on that day.
Yes, it was. So it was me, myself, Abigail Potter, who at the time was the trial division lawyer assigned to Judge Whitaker's courtroom. Judge Whitaker and Mr. Melnick, and I believe Ms. Rosser, the case manager who set up the Zoom link, was on the Zoom, and it was just a discussion as it related to the bond conditions for his possession of a firearm by a convicted felon case that was before Judge Whitaker, and the conditions that would be included in it.
Was there any part of that conversation that referenced?
We ain't never seen this, brothers and sisters. We ain't never seen this. Shout out to Ms. Ma with the Speedy to the printer. We ain't never seen this, but it's just the truth, man. Look, I'm calling it fair. All right, I call it fair. Now you ain't never seen her rushing to the printer. All the stuff that's done come up, all the stuff she wasn't even around for, right? That we know she didn't know. But because her name is in it, now look at her. Come on, y'all. Just be fair. Just look, be fair. That's all I'm saying. Be fair. Again, what if Young Thug was your son? How would you feel about you sitting there? Because they tell me that Young Thug's family comes to the courtroom every day. We've heard that they are in that courtroom. They're representatives of Jeffrey Williams' family. And well, of course, that they from the, this fam, right? This is your city, right? But there's people from his family, immediate family in that courtroom every day. That's what we've heard. Which makes sense though, right? But okay, but every day. So you watching, all of a sudden you seeing her, you seeing Speedy getting documentation, and she gonna get this right. She gonna get this right. Whoa. Where was that before? When other stuff was coming to you that you didn't know about, that you could have, you know what I'm saying? All right. Okay.
Mr. Melnick representing Mr. Copeland as a witness in this case.
Yes, specifically. And the reference is that Mr. Melnick was all hot about the fact that I was on the call representing, as a representative, pretty much you as a member of the team for this case, because he specifically said on more than one occasion that I'm not here about that case. I don't represent him on that case. The only case that I have before this judge that I represent Mr. Copeland on is the 22 SC case. He said it over and over again, and he kept making snide remarks as it related to you and the district attorney's office, and eventually me, to which I said, I finally interrupted him. I said, we're done with your used car salesman, stuff. And that's when the judge was kind enough to intervene and say, all right, whatever, we're here just for the.
Stop it. Shout out to Sister Love. She calls him Brother Adam, and Adam not only puts his bar and his credibility on the stand, but he actually shifted it all back to Whitaker. Because now she can be called as a witness the same way Glanville could have been called. Do you realize what just happened? Shout out to Sister Love. Sister Love went from, oh yeah, you do need to call somebody. Whitaker finally slows down. Brothers, are you hearing me? Sisters, are you hearing me? Speedy finally slows down and allows an argument to be developed because she sees she can get a real smackdown on Love, and it actually turns into a moment that may all the way come back on her within minutes. Within minutes, this thing just completely turned potentially to whereas Whitaker could be questioned. Love is not even the focus no more. Adam already validated. Love is clear on that one piece right there. She's in good faith. If Adam told her this story, and Adam has given you no reason to believe, that ain't the story. He's got the whole credibility issue now shifted to Whitaker. Whitaker now has to say, I was on that call and that's not what happened. Those words were never said. Whitaker didn't remember. Why do you think she printed it out? She didn't remember. Otherwise, when Melnick has come and gone, remember what Melnick was gone real quick before Steele brought him back. Steele went and got him. Melnick was out. She was moving on. She would already even said it don't even matter. This is done deal. Whoop, 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 whoop. She's pushing this. Whitaker pushed this up again by trying to hammer Love. And it brought it all back. It brought it all back. Melnick been gone. Man. Shout out to Love. Thank you for being here.
22 SC case, we understand you don't represent him in the YSL case because there's nothing to represent him on, was the gist in my recollection.
And when you're talking about the 22 SC case, are you solely meaning the one Mr. Copeland faced charges on, criminal charges on?
Yes, the one that was before Judge Whitaker that we were there for to, I guess, negotiate and agree upon bond conditions for. That I think it's 22 SC 182, I think it's 134, and the charges were possession of a firearm by a convicted felon, and I think reckless driving. I think this all happened February 24th of 2023.
Do you know whether that Zoom call was transcribed or whether or not there was a court reporter on that Zoom call?
I'm not sure, but I don't remember seeing, I think it was Miss Evelyn, sorry, who was the court reporter back then. I don't recall.
Do you recall how many times Mr. Melnick stated with any degree of emphasis that he did not and was not representing Mr. Copeland in his capacity as a witness in 22 SC 183572?
2 or 3 times, and it was all in relation to the state's request that he be fitted with an ankle monitor. And that was particularly angersome, I guess is the correct word, as it relates to Mr. Melnick's reaction, because that's when he kept saying, this case has nothing to do with that case. I have nothing to do with that case. I don't see why he has to have an ankle monitor.
Are you familiar with what it is that the state was trying to secure with the ankle monitor?
His location at all times, I suppose.
And are you familiar with
Okay, just a strategy point, ladies and gentlemen, brothers and sisters. Love should stop, in my opinion, right now. She's already hit the home run. Whitaker now needs a way out, okay? And you know, if Love continues to meander, it gives the potential for Whitaker to jump in with some nonsense and try to turn this all this way and that way. So it's clear to all the attorneys in the room that at this point, Love has validated herself in good faith that she was told this from Adam. Okay, so you're gonna have to get her on something different, which they got other stuff, right? Just the fact that the ex parte still happened, okay, and the fact that they weren't told, and the potential Brady issue of what Lil Woody said, or whatever the case, right? But as far as whether or not she was wrong to even talk to the boy without Melnick being present, she now has a good faith reason why she didn't believe, she nor Hylton believe he had representation at the time, because of what Adam told them that Melnick made clear to them. Okay, so just, you see her now trying to fish and find, well, what else? Nope. Respect what you just did. Okay, respect the funk you just laid down, and respect the fact that there's a whole lot of intelligent people in the room, and they all heard it. And they all know Adam. And they know Adam is not caring. Look at Adam's body language, brothers and sisters. Look at Adam's body language. Adam is not caring. Adam is giving you the straight funk. I don't care what you think. Look at Adam. Ain't nobody got up there leaning to the side like that unless it was Lil Woody. Adam's not caring. So he's like, look, this is the funk. Take it or leave it. I'm out. And everybody in the room, they feel that from Adam. They know when Adam is being like that. They know what that means. Adam's not backing off his point. So just let it be. Whitaker's got to deal with it. Then let her deal with it. Sister Love's got to realize that even if the defense gets up and cross-examines Adam from here, then she gets a chance to come back. So she still will have a chance to come back if they come with something. So sit down. Let them figure it out. Let them figure it out. You can counterpunch from here. You know Adam ain't going to change his story. So what else is there? Rhodes. Thank you for being here.
Did you speak with Mr. Melnick at any other time regarding his representation of Mr. Copeland as a witness in this case?
No, I try to avoid him as much as possible.
Has he ever?
See, we don't need this. And you see that Whitaker is off in space. She is focused. She is reading. She's trying to develop her argument. You see what's happening. Whitaker ain't looking around no more, is she? She ain't wandering. She ain't. No, she's completely zoned in. You see her. All you see right now is hair. She is focused, studying. Don't give her this time. Love is actually giving her time to develop her argument. Don't do it. Sit your butt down. And you're giving a chance for Adam to say something that maybe he shouldn't say because Adam is being Adam, right? So, hey, you don't need Adam to just be, just saying some other stuff because you see Adam don't care. So then, hey, then don't let Adam say the wrong thing. Shut it down. So y'all got to learn these things. You got to learn these things. But I guess she's been feeling she's been getting beat up so much that now that she's, got a little gas going, you can't let that emotion. So what? And it's about winning. This ain't about feeling good for a minute and I'm riding high. So let me go ahead and okay. Whitaker got her head down for a reason. You keep playing with her if you want to. I ain't never said Whitaker was dumb. She got to where she got to somehow. You don't be just giving her a chance now to figure it out. We said everybody in the room is smart. That's why we were looking for brilliance to handle this room, to handle the situation. But ain't nobody said she was dumb. You keep messing with her, she'll figure out a way out of this thing. Rhodes.
In life represented to you that he represents Kenneth Copeland as a witness in this case?
No, it was the exact opposite in front of the exact same judge that we're sitting before today.
And showing what our marker states is that I don't know if the court had already.
Here you go. Here's the bond order.
Showing you State's Exhibit 2, which I'll mark, which is a copy of the filed bond order. Is that the bond order that you spoke with Mr. Melnick about on the date that you're speaking about now? Or is there?
So this would be the bond order that came from the conversation we had in February 20, February 24th of 2023. This is stamped for March 3rd. So there would have, the whole reason for the Zoom was to negotiate and come to some sort of agreed upon set of bond conditions as it related to Mr. Copeland and being released on bond for the 22 SC 182134. That was right.
So that was not the right bond order, brothers and sisters. He's saying, you know, you're giving me a bond order, which I guess is what Whitaker printed out. So she don't even got the right thing, right? They were discussing, right? They were discussing on the Zoom the possibility of it. So that means it's before it actually was printed, before it was actually agreed to. Therefore, you print out something that was agreed to, right? But the Zoom call that he's talking about was a discussion about it, is our understanding right now. So he's like, yo, this ain't the right, this don't match up. This happened at later. So if what he's saying is right, and if we're understanding what he's saying right, then Whitaker don't even know where she's at right now. She doesn't even know where this is. That's bad.
So this would have been the product of that conversation.
Okay, thank you.
Yes, he just said it. This is the product of the conversation, which means what Whitaker printed out was not what was before them during the conversation. They didn't have that document.
All right, that's all I have for this witness, Your Honor, for right now.
All right.
Shout out to Sister Love. All right. Okay. All right. Now, good. Now, she went longer than she should have, and she gave a lot of extra time that she shouldn't have given, but at least she had the sense to stop right there. So, all right, Love, you know, you could have done better. You could have stopped it sooner, but all right.
Any questions by any of the defense attorneys for this witness? Nope. Ms. Weinstein, Mr. Matthews.
No, Your Honor.
Mr. Harvey, who I can't really see over there in the corner. Is he even there? Is Mr. Harvey over?
Ain't really trying to mess with Adam right now. That's respect. Shout out to the room. You know, shout out to the room. That could just make things a whole lot worse than up there just trying to tangle with Adam right now. If you're going to tangle with Adam, do it about something that you need to do it about, that you know you got him on. But right now, he's way ahead. He's got the juice. Whitaker's in trouble. So, you know, I mean, why tangle with Adam about something that you don't even know about, that you wasn't there? He was there. Whitaker's the voice. Whitaker's the one now. So ain't no need to tangle with Adam like that. Now you can get up there and try to say something that to like be agreement. You could be like agreeing with him, change your argument, but why would you do that? Right? I mean, because maybe you just want to push the focus more so on Whitaker, like just, okay, well then I guess Love did know. So now tell us why Whitaker didn't say. Why do you think Whitaker, you know, but that's just silly, right? So there's nothing to say then. There's nothing to say.
There. Anybody for Mr. Harvey's client? Any questions? Okay, great. Thank you for your time. You may step down. All right, call your next witness.
State calls Attorney Peter Herzog.
Okay. It doesn't matter to me. I mean, do you want him sworn or do you want him to testify in his place?
I have him sworn.
All right, yes, please swear him.
swear affirm testimony you give, you tell the truth, the whole truth, nothing but the truth.
I do.
Have a seat.
Thank
State your first and last name for the court.
Peter, Peter, Herzog, Hertzog. TZOG.
Good afternoon, Mr. Herzog.
Good afternoon.
Would you please, just for the record, state for the court, where it is that you work and what position you hold there?
So I'm a senior assistant district attorney in the anti-corruption unit of the Fulton County District Attorney's Office.
How long have you worked in the anti-corruption unit?
Since I started in the office, about a year. I think I started March of 2023.
Did you say March? And I just need to speak up a little bit louder. March 2023?
Yeah, I think it was March. I've been here about a year and a half.
Okay. Have you ever worked in any unit besides the anti-corruption unit?
I did a short stint where I screened cases and then I cover a court part for a complex, but I've always remained in anti-corruption.
As an attorney with the anti-corruption unit, have you ever had an occasion to speak with Mr. John Melnick about a person by the name of Kenneth Cole?
Yes, I believe so.
At any time during those conversations, did you ever, in any way, seek any information regarding Mr. Melnick's representation of Kenneth Copeland as a witness in the case 22 SC 183572?
No.
Did you ever, in any of those conversations, have any occasion to talk with Mr. Melnick about his representation of Kenneth Copeland as a witness in any YSL related case?
No.
Did you ever, during your conversations with Mr. Melnick, reference either myself or Deputy District Attorney Simone Hylton?
No, not to my recollection. No.
Have you ever been asked by either of us or anyone prosecuting the YSL case to reach out to Mr. Melnick?
No, absolutely not.
Is this the longest you and I have ever even talked?
I believe so. I think I ran into you once in the hallway and said hello. Other than that, I don't think we've had much contact.
Did the matter that you spoke with Mr. Melnick about have anything to do, in any tangential, direct, indirect, any way, have anything to do with 22 SC 183572 or the criminal indictment that preceded it?
Absolutely not. No.
Was the case that you spoke with Mr. Melnick about a case that was in your unit?
Yes, ma'am.
Were you ever asked by anybody within the DA's office to have any communication with Mr. Melnick regarding his representation of Kenneth Copeland as a witness in this case?
No, ma'am.
Did Mr. Melnick ever just tell you, hey, I'm representing Kenneth Copeland as a witness in the YSL case?
No, not to my recollection.
Do you recall sending Mr. Melnick an email back in March of 2023?
March of 2023. I don't recall.
Your Honor, I'm not certain exactly where the evidence.
I'm sure it's somewhere with the court reporter.
I'm going to show you what has already been admitted as defendant Williams number 4, Your Honor. And I'm going to show you ask you to take a look at the bottom portion of defendant Williams number 4. And ask you if you recognize or if you recognize that time frame as a time frame that you reached out to Mr. Melnick.
The time, yeah, I did reach out to Mr. Melnick. It could have potentially been around that time frame. If you'd like, I can go into more detail.
Yes, please.
So we were as part of anti-corruption, we were investigating.
Without getting into the details of any anti-corruption case
Okay.
at all.
There was an allegation made that involved Mr. Copeland. At the time, I was relatively new to the office. I'm not from here, I'm from New York. I spent years practicing up there. So I know nothing about what's going on down here in relation to this case. I reached out to Mr. Melnick to see, as per our usual in our unit, to speak with every witness. And I believe I asked him if Mr. Copeland wanted to talk about that specific matter. And I don't believe we ever followed up on it.
Was Mr. Copeland in jail at the time that you reached out to Mr. Melnick?
I believe so.
So was Mr. When you reached out to Mr. Melnick, where and why did you seek to go through Mr. Melnick to get to Mr. Copeland?
Because if I remember correctly, he represented Mr. Copeland in that other matter.
To your knowledge, had that other matter been resolved?
At the time, I'm not sure if it was resolved at that time, but I don't believe so. I think that's why I went through Mr. Melnick, I believe.
Outside of the anti-corruption matter, did you speak with Mr. Melnick regarding anything else related to Mr. Copeland?
No, ma'am.
That's all I have.
All right. Any defense examination of this witness?
You know, I did a thing, I wrote a check mark, and I'm gonna have to get that out before.
Okay, probably have some white on it. That would work. Is that okay with everybody if on states 4, Ms. Love White felt the check mark she inadvertently wrote on state 4, which is why I don't like to ever handle the evidence, because I'm constantly taking notes and then I end up writing on the evidence.
And Mr. Phillips, Williams exhibit.
Is that okay? All right. Thank you.
With the court's permission, I'll do that after Mr. Sharp has had an opportunity.
Go ahead, Mr. Sharp.
Good afternoon.
Good afternoon.
So from what I understand, March 2023, you are working for the DA's office in the anti-corruption.
Correct.
Okay, and you are building up a case?
Yes. I'm investigating a case. I'm not building up a case. I'm investigating a case.
And is Mr. Copeland the target of this case?
No.
Okay, so he is a witness.
Yes, he would have been a witness.
He's a fact witness, I assume?
Objection, Your Honor, to the relevance of what type of witness.
Sustained.
What kind of case is this?
Objection as to.
Well, can we just leave that it's an anti-corruption type case?
I ask, was Mr. Copeland the alleged victim?
No.
So he's a witness.
Well, it's.
Your Honor.
Yes. Do we need a bench conference? Okay. earphones work right now. So what I'm wondering is if y'all would be comfortable with Mr. Sharp relaying the substance of the bench conference, or if each of you wants to try to come up and gather around, or.
And Your Honor, since we cannot have, since we don't have the ability to let it be heard, I'd ask that the court ask whether each defendant waives their presence at the bench conference.
So do the attorneys want to come up, or? Okay, so I know the defendants normally are able to hear what's going on. I'm sorry we're having technical difficulties. Apparently you need to put these things on their charger pretty frequently in order for them to work. So I'll know that for the next time. But one of your attorneys is going to come up and listen to what the substance of the bench conference is, and then I am directing them to return to the tables and let you all know what we talked about. I want to find out whether that's okay with each of you defendants. And also, I am happy if you're not satisfied with what the attorney has told you about it, to then you can let me know and I can say, well, here's my take on what happened. Okay. So, Mr. Kendrick, are you okay with Mr. Weinstein just coming up and then telling you what we talked about? All right. How about you, Mr. Huey? All right. Thank you. Mr. Williams. Okay. Who else do we have? Mr. Stillwell, are you okay with that? All right. And then Mr. Ryan, you okay with that? All right. Thank you. Appreciate it. So y'all can't even get it.
Yes, Your Honor.
And do any of the defendants have any questions about it that they want to ask me? Okay. And did you talk to your client about it?
I will.
Do you? Okay. All right, go ahead.
Attorney Herzog,
Spin your mic towards you.
the anti-corruption case that you were working on in 2023, is that still an active investigation?
No, it is not an active investigation. It was and the investigation was wholly unrelated to YSL.
Okay, and is there a pending case involving that investigation that resulted from that investigation?
A pending criminal case?
Yes.
No.
Now, at the time you sent this email, you wanted to speak with Mr. Copeland, correct? About the matters you were working on?
Yes.
Okay. And you have the ability as a district attorney, you said that your understanding is he was in jail, correct?
I believe so.
Okay, and you have the ability to go to the jail at 901 Rice Street, correct?
Yes, I have the ability to go to the jail.
Okay, and as a district attorney, you have the ability to bring an investigator with you and interview a witness there, correct?
I wouldn't represent someone I wouldn't speak with someone that was represented by counsel.
Okay.
On any case or was recently represented by counsel.
Okay, so the reason that you called Mr. Melnick is because you would not speak ethically. Your code of ethics, you would not want to speak to someone who's represented, correct?
It's all of our code of ethics.
Correct. And you also would not want to speak to someone who was represented recently. Is that what you said?
I would reach out to the defense attorney prior to that, yes.
And that's what you did in this case. You reached out to Mr. Melnick, correct?
Regarding our investigation, in the
I
limited
understand.
scope to our investigation.
Yeah, I understand. You were not involved in the YSL investigation, correct?
Correct.
Okay. But as part of your investigation, you reached out to Mr. Melnick in an effort to speak to his client, Mr. Copeland, correct?
Yes, I believe so.
I have no further questions. Thank you.
Does anybody else have questions for Mr. Herzog? All right. No?
Inquiry for the court.
Sure.
I don't understand enough about it, and I understand that the ruling is maybe I shouldn't know about it. With the court, Mr. Williams has no objection. And if you do, please correct me. Would the court be able to find out whether this has any Brady implications from Mr. Copeland, either under Giglio getting a deal or he did not get prosecuted because he was involved, but he was being used as a witness, and I don't have that information.
Sure, I don't either, but yeah, that's valid. Let's find that out. So you can ask that question. You don't have any objection to that question, do you, from the state? Okay.
Hello.
Mr. Still.
How are you?
Good, how are you?
I'll let you know. Brady evidence, you feel comfortable talking about Brady evidence, what is required by Brady and its progeny?
Is the question whether I feel comfortable?
Yeah. Do you understand Brady and its progeny, what it includes?
Yes.
Okay. And I didn't mean that to be insulting at all. Just, some people have different definitions of something. Dealing with Mr. Copeland, only Mr. Copeland. Was there any type, no matter how non-promising, was there any type of agreement, promise, benefit to him, whether that's reduced charges, no charges, he's cooperating, he's a CI or whatever you want to call it, anything to do with that?
Absolutely not. I have no information regarding the YSL case or any investigation of the YSL case. I reached out solely related to a wholly unrelated matter.
Okay. And I'm broadening it besides what you call the YSL case. I'm saying, was Mr. Copeland given any benefit? Forget about this indictment before the Honorable Judge Whitaker. Was he given any benefit on any matter, including the matter you were investigating?
Not to my knowledge, no.
Okay, all right, thank you, Your Honor.
Okay. All right, anybody else? Mr. Williams? Okay, anybody? All right. Any redirect by the state?
No, Your Honor.
All right, thank you. You may step down.
Thank you, Your Honor.
And did you have one other witness?
Yes.
Are they ready?
I couldn't put allow Mr. Atkins to go outside and check.
Sure.
Sure, getting a pretty
While we're waiting on
Different tone
finding that out,
the judge here.
were, well, I guess it was Mr. Atkins that was going to do it, so never mind. I'll wait on that one, trying to see what else we can get done while we're waiting. Nothing. Huh?
There was one matter, I guess, as it relates to Mr. Copeland, that I would ask that the court take additional notice of, since we're all on here.
What's that?
The date that his criminal matter that we were just introducing testimony about was resolved. There should be within the 22 SC 134, I believe, case in Odyssey, a disposition for those criminal charges. I would ask them just to take judicial notice of that date.
All right, so it appears that the plea was entered on June 28th, 2023, and the disposition was filed on June 29th, 2023, and I'll take judicial notice of that. All right, what do we know, Mr. Atkins?
So Ms. Potter is 30 minutes away. I'm not going to ask the court to wait on.
Okay,
I'm
okay,
sorry, he said 40 minutes, he corrected.
okay.
And so, rather than have the court wait on that,
We're gonna do that tomorrow?
I can, yes, I can do that.
All right.
And Your Honor, the other, thing that I was looking at was I'm obtaining a certificate of service for Mr. Copeland that I believe was filed. I think he was served most recently in May of 2024. And if the court would indulge me one moment, I was just trying to determine who it was that served him. Since the subject is state's actions regarding a witness, Mr. Copeland. And I would also argue to the court that there is not standing to complain of the interactions between state prosecutors and their witnesses in this case. And there's not standing to complain of what happened as it relates to Kenneth Copeland in the in-chambers hearing. But to the, on June 10th, in terms of King and its progeny, and what the transcript reflects and the court has heard testimony reflecting.
All right. Well, their claim is a right to be present, and they have standing to make that claim. Whether I make a determination that they did have a right to be present or didn't is yet to be determined, but they can certainly make the claim. Was there, with regard to them, are there not being standing to complain about whether the state communicated with Mr. Copeland when, according to the defense, the state knew him to be represented. I understand the assertion in that regard to be that the prosecution has violated a bar rule and that they've also violated other bar rules over the course of this case, and that I should take that into consideration in determining whether and what remedy to fashion. Do I have that about right? I'm getting nodding yeses. Okay. So yeah, they can assert that to the court.
Okay. And Your Honor, as I obtained for the court that those final two pieces of information.
Okay.
I'd ask for the court's brief indulgence while I get the certificate of service and the date that he was served.
Okay. I'm not even sure which one you're talking about, but sure, if it's relevant, I will unseal it. Can you let me know which one it is?
It was a certificate of service and it was filed on, okay, that's what we're getting today.
Okay. It's, and that's in which case? This
22.
YSL case?
Yes.
Okay. So I actually, once you let me know what it is, I actually, because I'm the court and I can, kept a copy of what is in each of the sealed filings once I reviewed it, so that in case we needed to see something again, I didn't have to do another order unsealing and resealing. So those are in an envelope in my litigation manager's office. And when you let me know what it is I'm looking for, I'll just pull it out of there.
There is a certificate of service for Kenneth Copeland that should have been reflective of a subpoena that was served on him, I think in May of 2024.
Okay. Without
The exact date, I don't want to, I think maybe May 31st.
Okay.
That sounds about right. May
All right.
31st of 2024.
Sure. And maybe Ms. Persfield, you already are anticipating my need and sending an email to Ms. Rosser to see if she can pull that. Thank you. All right. And then with regard to Ms. Potter, is she gonna be available in the morning, or does she want to Zoom? I don't care if we take her testimony by Zoom if nobody else does.
Okay.
I don't even know if she's available, but that's an option as well.
Thank you, Judge. That would actually work. I'm gonna.
All right. Would that be okay if, I don't know if everybody's familiar with Ms. Potter, but I don't know if is she still with the DA's office?
She is. She's
Okay.
outside.
She's a prosecutor with the DA's office who used to be in my courtroom and who was the prosecutor for the case that Mr. Melnick handled on the other side of. Would everybody be okay on the defense side with us taking her testimony by Zoom here in court? If anybody has an objection, please voice it orally now. Okay. All right, so that'll work. If you can line her up for that, and I think you already have the Zoom link, we can do that.
Thank you.
All right. And as Ms. Love's doing that, Mr. Atkins and whomever from this side of the courtroom was going to work on the maybe one or two issues with Mr. Copeland's jail calls over the weekend. Did y'all get an opportunity to do that and reach any kind of resolution?
Your Honor, I have not spoken to the defense counsel in relation to those jail calls.
Okay. Wasn't that your task?
Your Honor, I will speak with Mr. Shard.
Okay. I can't remember who said they were going to do that, but I don't know. Y'all had told me at the end of Friday, before we had all of our more explosive
motions put before the court that on the jail calls that might or might not come in with Mr. Copeland's testimony, y'all had maybe 2 items that you thought you could work out everything, and there were 2 items that were still kind of in dispute?
That may have been Ms. Hylton.
It might have been, I don't know.
Just to get him.
I was out a little bit on Friday, but did Mr. Steele not deal with the jail calls at the end of the day on Friday?
I mean, so what we ended up doing was saying, oh, we may be able to just come to agreement on everything. So give us a little minute over the weekend and we'll get back to you. Anyway, apparently nobody did it, but y'all do that
Yes, Your Honor.
tonight, if possible.
Yes, Your Honor.
Your Honor, may I be allowed to step outside the courtroom for a brief 5 or 7 minutes?
To line up Ms. Potter?
To line up Ms. Potter, and to speak with another member of our office.
Okay, so we will take another break and be back.
Is it fine?
Whenever you let a deputy know that you're ready, okay? Which hopefully won't be more than 10 minutes. All right.
Thank you, Judge. The state is asking if the court will allow us an opportunity to respond to the Ford Motor Company case that we provided today, and in making our final argument. And to allow us, if we decide the need to call 88 Potter, the main thing that I wanted to get out was regarding when Mr. Copeland pled, and I haven't had an opportunity to talk to her about that. I think she was the one that represented the state in that plea.
Yeah, she was, but I mean, I told you that he pled on June 28th of 2023.
Right. When I first started looking at Abigail Potter and had the three names.
Oh, okay. So you may not need her after all, then that's fine. Yeah, if that's all you needed her for, it's in the court record.
Okay.
And I have taken judicial notice of it. And then a response to the Ford case, I mean, with regard to whether that's the law or not, or whether that's an appropriate
I have not
sanction. Yeah, yeah, sure. You haven't had a chance to take a look at it. Sure. Is that what you're saying?
Yes.
Yes, that's fine. You can make whatever response, if any, you want to in the morning.
And thank you. So that's it.
Okay.
Outside of Ms. Potter, I don't think that we would have any other persons to present, but if we did, we would have them here and ready to go first thing. I just wanted to review all of our notes and make certain that every issue that was raised here today is addressed properly.
That's fine.
Thank you.
And Ms. Rosser's looking for that certificate of service of the subpoena. And
I know that we keep copies, so I can get one of those too.
I think that I've got the certificate of service of a subpoena that you are referencing, because it has that on May 31st, Investigator Long actually served Mr. Copeland, and I'll let you look at it. It looks like it actually is also attached as a and I don't know if it was or not, but it at least references that the order that Judge Glanville enters on the 7th that is pursuant to 24.5.507 that gives him immunity maybe attaches that subpoena, but I don't know. Anyway, if you want to come take a look and see whether that's what you mean. And if so, we can make a copy of it and you can do whatever you want with it from there.
Okay.
Is that it?
It is. It is. It's attached to the, as the court said, it's attached to the motion to, well, the order granting the state's motion to compel.
All right. And so it's already, I would think, then in the record.
Yes. Yes.
All right. And so what's their argument you wanted to make about that? Or just
that, and I can reserve the rest of it for tomorrow, but just that he was served, Mr. Copeland was served on May 31st, and I think that's well a week before he was ever called to testify or anyone was informed that he would be the next person up. And we did not, I'll make argument at the appropriate time.
all right. Okay, so tomorrow, in addition to wrapping up whatever final evidence and argument there might be as to either of those issues, what I would like, I think y'all now have, if not every bit of Mr. Copeland's prior testimony, almost every bit of it. And Ms. Weaver's been pretty fast at turning it around. And at this point, it may be best to redo the entirety of Mr. Copeland's testimony, including bringing him back in and asking him whether he wants to testify. And I'll hear from everybody on what we might need to advise him of, if anything he's been, or re-advise him of, or correctly advise him of, and then just maybe start from scratch with him. If there are things that everybody can agree, I just don't know whether we know what he's going to do or how he's going to testify. So I don't know if it's productive to continue to look and see whether there are things y'all can agree on. But if there are things that everybody can agree on and we can just say, okay, you know, these 5 things take as, you know, something he said and the rest of it redo, or whether we just want to start 100% from scratch. As I understand it, nobody had played the June 10th, 2015 interview from him yet anyway, right?
That's correct.
Okay, and that's the only one where he inculpates any of these defendants, right?
No.
No, that's not right. That
Just stop. Stop. Brothers and sisters, let me just run it at you real smoothly. Okay. So the issue was everything from when Weinstein had put forward the recusal motion after the ex parte, the first one that we knew about. The contention is everything from the ex parte, should we do it over again? But the stuff that came in before then, leave in. That was the basic understanding. So, brothers and sisters, what she's saying right now, start all over, everything. Okay. Now catch this, brothers and sisters. Let's say these past few days when I've been saying as a defense attorney, yeah, we object to that. Yes, let that in. Yes, we object to that. Yes, let that in. Okay. Let's just say. But in my mind, I'm building something based on things he said, based on things that were said before. We're going to delete and start over. Right? Before. So there's certain things, I'm building something here, right? So there's certain things he may have said on the first couple of days. You dig where I'm coming from? I want that. So then when you ask me if I will allow this and that and the other to come in from a future recording, I'm judging that. See, I'm more complex than this Speedy crap. You dig what I'm saying? So I know he said something, let's say on day 2, and I like the way he said it. So I will object to something that's happening in this other recording, or I'll let in something in the other recording that I wouldn't have let in because of how it fits in the puzzle based on the testimony that will get accepted. So basically there's a long conversation, right? And if I knew you were going to accept the first couple of days of the conversation, I'm building an argument based on the whole totality of it all. Things I object to, things I want in, right? But now you tell me that you may want to just start from scratch. Well, that's disrespecting my genius that I was letting things in or not letting things in based on the totality of an argument, the totality of the testimony. So now after we've done all of that, minus a couple little tidying up things tomorrow, after we've done all that, you now tell me, well, we're going to start all over. Well, then my argument may be, well, then I need all these other things to come in that I objected to. I now need them because I have no idea. Like you just said, we have no idea what he's going to say when he gets on the stand, but at least I know what he said here, here, and here, but you're taking that away now. If we have to start all over, then I don't know what I'm building on. Holla if you hear me. So you just flippantly just say, oh, well, maybe we just start, I don't know, maybe we just start all over. But we've been making rulings as if there were certain things that were already going to be there. I'm not a fan of Speedy Whitaker. I'm not a fan of Speedy Whitaker. Holla if you hear me. Thank you for being here.
In the Donovan Thomas murder is what I mean.
Oh. That's the first one, yeah.
Okay. All right.
It's directly in the way that he did on.
Okay. Okay. All right. But we need to make some progress into the, I mean, I am still considering and working through Mr. Shard's motion, and then we'll get to Mr. Weinstein's motion for mistrial. Both of them are motions for mistrial. But assuming for the purposes of getting things done, those are not ultimately granted, then we need to pick back up with this trial. Obviously, if they're granted, then that's a whole other ballgame. But I want us to make progress in the meantime. So tomorrow, I would like for our focus to be on how to handle Mr. Copeland and his testimony or potential testimony once we have the jury back, whether there's any agreement as to anything, proposed jury instruction as to if we're disregarding any or all of it, what that should say, whether we need to take notes, all of that kind of like the details we actually need to think through. I want y'all working on that tonight so that we can make progress with that tomorrow. And, you know, there are a lot of things up in the air in this case. And I am going to once again say to everybody that there's a lot of risk for everybody. There's a lot on the line for everybody, both sides of this case. And I know not everybody has necessarily the most fruitful relationship with each other across the aisle right now. But I know, Mr. Steele, you said that you do still have a good relationship with the district attorney herself, who certainly authorized to talk about each and every case because they're all her cases ultimately. But, you know, y'all need to be thinking about all of the potential ways to handle and move forward in this case. And I encourage y'all to be doing that because who knows what it's going to be otherwise, okay?
And we did get last night, speaking of things that we can deal with.
Yeah.
We got last night from Mr. Sharp, and he can correct me if I'm.
So ultimately, it's Fani's case. Glad we have that on the record. That's clear. Okay, so now our understanding is what we thought. Sister Fani can do what she needs to do, how she needs to do, when she needs to do. So, okay. I really could care less about what Speedy just threw out there, though. It really doesn't matter to me. like she's coming to some realization, so she's going to make everybody else know that there's actually a lot on the line. No. You have it wrong, Speedy. The issue is you haven't been showing us that you realize. So now that you're now realizing, it's not time for you to put us on notice that there's a lot on the line. But welcome to the party. Thank you for being here.
I believe about 76 proposed redactions from the proffer of one of our witnesses that we discussed on Friday, Mr. Zachary.
Okay.
At some point, I know that the court is going to have us address those. So, and I believe that Mr. Sharp, he can again correct me if I'm wrong, said that he could go through that was for I believe the August 2017 interview, a proffer from Mr. Zachary. And there's an earlier one that I think he said he's going to go through and okay. He said he's gonna go through another one.
Okay.
And so if he sends us those, that's another thing that we need to work out.
Perfect. And so y'all go ahead and tackle the first 76, see if there are things that you can agree on so that we can have an efficient day like we did on Friday, where we sort out so that everybody knows here's what can and cannot come in potentially with regard to this witness. And he's coming up pretty soon. And if Mr. Copeland makes a decision different than his last decision, we may be getting to Mr. Zachary sooner than we think.
And if that is the case, then the state would have a motion for the court, similar to the one prior, with respect to Mr. Copeland.
You're gonna have to give me a hint as to what you mean by that.
So, Your Honor, just now, Your Honor, reference if Mr. Copeland.
She means throw his butt in jail. But here's the deal. If they throw him in jail, right? But he may take that. Do you understand what just happened, brothers and sisters? Let me go back. Let me go back, because I see I need to say this. Brothers and sisters, this stuff is outrageous. This could be huge. I mean, big. Do you understand what's happening, brothers and sisters? Lil Woody, if she starts from the question of, do you want to, right? And he pleads the fifth, and then she slaps his butt in jail. He may take that. As much as he don't like to be in jail, but listen to what's happening here. He may take it. So you're going to tell the jury to dismiss everything he said, forget about everything that he said, right? Just erase all Lil Woody, right? Okay. But I already know this case ain't going to take 10 years now. See, Lil Woody he can look at it now and he can see. See, before when he was back there with Glanville and they doing the thing and, he may be in here for 1,000,000 years and I can't be in here for no 1,000,000 years. And y'all telling me it could be to this and to that and to this and to that. But see, now he know there may be a mistrial coming up in a couple of days. So shoot, I ain't even got, I can do a couple of days. Holla if you hear me. What is that? You see the difference? How you gonna scare me into testifying this time when I can see this train is broke down? It could fall apart at any moment and I'm out. Case is done. I'm out. You throwing me in jail for contempt, but I'm out of here. There's no more case. Wow. Whitaker's just throwing stuff out there and the ramifications are big.
And different than what he chose to do last time. To testify. I'm assuming the court means plead the fifth again. I don't know.
Well, I mean, I'm not undoing the immunity order. The immunity order stands. Unless y'all got some,
That's what I understand.
Okay. All right. Well, I mean, I guess we can, I don't at this point see a need to undo and potentially redo an immunity order. I know that there is the argument about how paragraph 11 might contain a misrepresentation as to whether there was an encounter. I mean, the way I read it and what it says is there was an encounter with
representatives of the DA's office and people from the defense team. After that, Mr. Copeland told somebody he might plead the fifth. Now, I don't know whether from that it means Mr. Copeland was even a part of that encounter, or if that's just given me some kind of a timeline about one thing happened and then another thing happened. But the import of that to the predecessor judge and to any judge considering does immunity need to be granted and is immunity in the public interest here is not what triggered it. It's this witness who the state thought was going to be testifying voluntarily under subpoena or not, now intends to take the fifth. The only way we can get their testimony, which we believe we need, is to compel it. Will you compel their testimony? That's the import of it to me, not what led up to it, because there's no allegation of coercion or dirty dealing or anything like that, if it even means that Mr. Copeland was involved in any of that. So I don't believe that the immunity order needs to be redone. If somebody else thinks differently, y'all let me know that right now. Silence. Mr. Steele.
I don't believe anything before Mr. Weinstein filed the first motion to recuse. I'm not challenging anything before that.
Okay.
But I do want to hold, there was a lot of exculpatory information before the recusal motion was filed, so I don't want to wipe out Mr. Copeland's testimony.
Shout out to Rhodes and shout out to Brother Steele. Now we stopped and gave it to you right when it happened. It's just ridiculous what Whitaker is doing. There are huge implications. Shout out to Brother Steele. Shout out to Brother Steele. Like, yo, wait a minute. There's stuff. We're not that simple. We're not that simple. We're building this thing block by block. Block by block. This is Rome, baby. Rome. Are you hearing me? Well, we'll just start from over there, or just start from over there. Just start from over there. What? You're not hearing the depth of what's happening. So shout out to Brother Steele for saying, yo, wait a minute. Before Weinstein's motion, there was stuff said. We want that stuff. That's been a part of the building that we're erecting right now. Thank you for being here.
Okay.
On the 10th,
All right.
11th, or part of the
All right, which is why I need y'all to get together on it and let's tackle that tomorrow. The nitty gritty of it. Okay. All right. So that means y'all have to do that.
No, it's not okay. Now that you just want to make your kumbaya statement again of this is why y'all need to get together. No, how about when we first came up with this to you, you should have slowed your butt down and we would have dealt with it right here in court. But now we all need to get together so we can get down to the nitty gritty. No, you should have never jumped off the nitty and the gritty when you first heard about it. So it's not, oh, this proves the point that we need to get together. No, it proves the point that when you had it in front of you, you need to slow your butt down. And that's why we at Rose Dogs and Conversation said what? Yeah, Glanville got his issues. Yeah, he definitely has some things that, need to be upgraded. But shucks, at least he was dealing with what was in front of him. At least he was dealing with what's in front of him. He wasn't rushing to the other 50 things. He was dealing with what's in front of him. And everybody had their say, good or bad, and they moved on. And yes, it took an exorbitant amount of time, but at least you were building, you knew you were able to build your thing, not just make a bunch of rash decisions that then go back and she can just take the legs from out from under you way back when. Even what she's talking about right now. Well, if I grant the mistrial, but just so we can be productive, y'all need to get together and do these things tonight so that tomorrow we can, so we can still be productive. But I still may just, rule. And Yeah, okay. 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 Maybe I should just work through lunch again. Thank you for being here.
Do that tonight if you haven't already done it. All right. Anything else before we break for the evening? One more thing. All right, so it's my understanding that other than the transcript of June 12th, everybody should at this point have all of the testimony of Mr. Copeland, and the transcript from the 12th should be forthcoming within hours. And, you know, Miss Weaver was working at like midnight last night. So as soon as she gets it, she'll either forward it to Ms. Percival, who forward it to you, or she'll forward it directly. So y'all should have that very shortly. All right, anything else before I bid y'all adieu for the day?
May I inquire if it's appropriate? Is the court's plan to bring the jurors back in on Wednesday? Is that still the plan?
I don't know, because we got things done today, but we didn't get any evidentiary, make any evidentiary progress today. So I don't know. It's less likely now than it was on Friday. And I'll just let y'all know right now that I have an appointment that was set up well before I had any involvement in this case for Friday morning. So I am not available this Friday morning, regardless, this coming Friday morning. And I'm not gonna, I don't know. Let's just see how tomorrow goes. I think we'll have a much better idea tomorrow, whether it's Wednesday for 2 days.
All right, brothers and sisters, let me just say we're breaking down. We're breaking down, baby. We're breaking down. The strong suit of Sister Whitaker is her scheduling, is her ability to keep the trains running on time, right? That is her specialty. So to hear her right now at a loss about the schedule, about the jury coming in, and her thing is scheduling, that's her thing. Yeah, brother. Wheels falling off. Wheels falling off. If she can't dig into her strong suit and still have confidence, it's what we've been telling you. Mistrial's looking sweeter and sweeter by and by. Do I really need this in my life? These folks don't have their stuff together. I'm not going to be able to just come in here and do what I thought that I could do. I'm now questioning myself. I'm now questioning this case. I'm now questioning whether the appeals court's going to overrule this anyway, if it gets there. Why am I doing this to my life? This will age me. This will not turn out well. What am I doing here? It's worse than I thought. I don't control what I thought I could control. This is bad. Foolishness. Rhodes was right. Foolishness. So yes, I'm saying with the cameras rolling, I'm saying, yeah, I don't know if the jury, it's not as likely as it was. I don't know. I don't. This is Whitaker talking, y'all. This is the scheduling queen of Fulton County talking. There's just a lot of stuff. Yeah. Rhodes. We've been telling you. Drowning out there. Cameras rolling. Drowning. It's too much. And what did she say? We didn't even get to the evidentiary things. We didn't even get to. Yeah. Didn't even get to, right? That means progress is not really progress, right? You're not even getting to what you wanted to do today. And you're that far behind. And you're not even getting to what you wanted to get to try to make up some ground. You're not even getting to the get to so that you can get to the get to. Yeah. I understand. Sister Whitaker, take a look in the mirror. Say, wait a minute, there's an extra wrinkle. That wasn't there last week. Do I really need this in my life? Thank you for being here.
Which I don't love, or whether it's just next Monday and let's actually make lots and lots of progress in the next few days and then buckle down with a trial on Monday if it turns out being that. But I'll, remind me tomorrow to think about that again. All right. We're adjourned for the day.
Okay, brothers and sisters, we appreciate you being here. Don't have much else to say. No, I just said it, and I'll stand by it. Thank you for being here. Shout out to Miss Mod. Shout out to Miss Mod. Shout out to Miss Mod.